Give me coffee in the morning, gotta have the coffee. Wake me up, shake me up, dip me like a lassie. One sip, two sips, and I'm feeling so alive. Coffee in the morning, it's the best way to survive. Woke up in the morning, sleepy eyes yawning. Jumped out of bed, started the day, opened the curtains. Felt the cool breeze, the sun shining on my face. But something was missing, I needed my job to chase. Give me coffee in the morning, give me coffee in the morning, gotta have the coffee. Wake me up, shake me up, dip me like a lassie. One sip, two sips, and I'm feeling so.
Good morning. Good morning. Welcome in, Dolphin. Good morning. How are you?
Oh, good morning. I'm actually nice and awake for a change. How are
Right?
you doing?
I'm doing good. Got my coffee. I'm ready to go, I think. I'm ready to get this show on the road. This case may wrap up by midweek at the latest. So,
No?
yeah.
Mm.
Well, Karen had said after court the other day that they were looking to wrap up her case by Tuesday, the 10th. So,
Mm-hmm.
we'll see
Oh,
how that
okay.
We'll see how it plays out. So, yeah, I got my morning coffee and I'm in here. Um, Hopefully they'll get a full day in today, but no kind of messery. It's too early for me to start cussing. YouTube don't like that. Save that for later in the show. It's so crazy, this Karen Reed case and that Lori case yesterday. Oh my gosh.
Oh, yeah, what happened with her?
Not a whole lot. They just kind of, when they finally got going and got her better and she felt like standing there and could actually talk, um, she didn't have much of a case. I think the first 2 to 3 witnesses, she didn't even have any questions for us. She's just like, no questions, nothing she can ask them. And the first witness was her victim. So
Mm.
she claimed she was unprepared to cross-examine Brandon Boudreaux because her investigators hadn't given her all of the information and documents that she needed. And we're like, but he's the main witness. You knew you were going to cross-examine him all this
Yeah.
time. What the hell you doing, lady? But yeah. So I guess they've agreed to let him come back on today, I guess, for her cross. It's just a shit show over there with Lori. It really is. Good morning, Spinster. Welcome in. Welcome in, guys. You guys, I appreciate you all coming in here with us this morning. Hit the like button on your way in the door. We're going to get Karen Reed underway. And then at lunchtime, we've got to review some stuff out of Idaho and Pennsylvania for the Brian Koberger case. A little bit of movement and activity going on over there. Some new witnesses possibly being brought in to testify in court. We don't know yet if they're testifying for defense or for prosecution, but we'll take a look at the documents and the players and a couple of articles and see what we can figure out from that. I don't think anything new was dropped into his Idaho docket.
There was one thing yesterday. It was an
Oh, that's
order.
right. I did see that thing yesterday, or last night I was reading that, but I didn't check this morning.
Mm-hmm.
I haven't even checked Stearns this morning.
Nothing this morning.
Nothing. Let me check while we're waiting. I'll check. There was something dropped in the Stearns docket, but you couldn't view it yet.
Oh,
Um, yeah, let me see what that was really quick. If they got that up on the docket yet. Still waiting on those damn rulings to come down on that case. On that evidence. Let's see. Okay, it's loaded now. Let me make this larger so I can see good. Okay.
I should have made myself some tea while I was just sitting around.
It's a notice of appearance was filed 6/2/25, and it just says requested on the image viewer.
Mm-hmm.
That usually takes a day or two to go through into the docket. So whatever that was, it is a notice of appearance requested, but that's all that we can see. And still the judge has not made any rulings on about the motions to suppress the Google search, cell phone seizure, and the unlawful search of the cell phone. We're still waiting on that stuff.
He's taking his time on the cell phone.
Yeah, he is taking his time. It makes me a little nervous.
Hmm.
Why? Why did I know he requested all the body cam video and the interviews the judge did, to try to get a better grasp on what really happened there and how it all went down. But it sure is taking a minute, and it's giving me a little pause. It's like, is there really something there legally? I don't know. It does make you wonder,
I
though.
hope not.
Oh, I know. Me too. Me too. Oh, JCN, welcome in. Good to see you. It's been a minute since we've seen you around. How are you? Hope you're doing good. Okay, let me pull up the feed on the side so we can make sure we are ready to go when they're ready to go. Um, a document came down also in the case of Mickey Steins and the Kentucky sheriff who shot the judge.
Oh.
Yeah, his attorneys are asking for the case to be dismissed. It's hard as heck to get documents out of that state.
Hmm.
I know who's got them, but I do. They have been releasing more and more of that body cam footage over the past month, from when the judge shot the sheriff, and I've got the whole video now from when he walks into the office from the very beginning and clears everybody.
You mean the reverse?
Yeah, he clears everybody out of the office. I've got the whole video. Fox has been dropping it, more and more of it, over the past month, and I've just been saving it and collecting it. Karen Reed streaming all day every day is just about to kill me with other content. Like, I don't even. I've got other stuff saved we want to get to that I want to cover. So it's just finding the energy. I'm so exhausted at the end of the day. I can't even. Okay, let me pull this up before I sidetrack myself here. Okay, we have the OnlyFans spinning in the room. I'll go ahead and bring
Great.
the screen. I know it makes me damn well dizzy. I can't look at it. It's like riding in the car, but you're not trying to get car sick at the same time. Because if I stare at that fan, it will certainly make me dizzy. Just ignore it. Yes, good morning, everyone. Happy Friday. It is Friday, isn't it? Butterfly says. It is Friday. Y'all be happy. Yes, thank you for joining us, and please hit a like and share. We do appreciate it. Guys, I don't know. I may come, I don't know. It's hard to say. Depending on what happens, because when Nick Balance testifies in Lori's case, I'm so going to be listening to that. I may not get to listen to it while it's happening if I'm streaming Karen, but I know they're calling Nick Balance back.
Hey, thank you so much for watching the Karen Reed trial with us, but I wanted to tell you guys about.
I'm a little obsessed right now with Nick Balance, if y'all can't tell. I just need to know more. I watched all of his testimony in Chad Daybell's trial, and I was extremely impressed. If it's going to be a battle of the experts, so far I'm leaning with Nick over Cy. Just saying. Oh, we probably have another interview with that guy coming out. That Garrett Discovery guy.
Yeah. Mm-hmm.
Did you see that?
I was informed of it. Where is it?
It's not out yet. I think. Did I put a link in
Is it
Discord?
on Twitter or something?
It was on
No, she
Twitter.
told me about it.
Yeah, it was on Twitter.
Oh.
There's always a lot on Twitter, but yeah, I think that's where I saw it.
No, I don't hardly check Twitter for anything
I'm just on there. If I
except for direct
scroll,
messages. That's it.
yeah, if it scrolls on my feed, I see it. Even if I don't follow people, their shit still shows up. I don't know. There's only a few people I care to communicate with on the Twitter much, but I scroll through for shits and giggles if I'm bored. But a lot of funny things go down on the Twitter, a lot of crazy things. People say, they'll say some weird things sometimes, won't they? You're like, what in the world?
Oh.
Oh?
Mm.
Oh?
Yeah, no, I when you said, Twitter, I was like, yeah, I don't do anything to, except check messages. So I went to Twitter and checked messages, and yeah, I was
Got a
just
message?
reminded about the rumor, and I'm like, I wonder, is there something behind it? I'll tell you
Okay, I was about to
later.
say, which rumor? You know there's 150. Now I'm gonna be wondering which damn rumor.
Mm-mm.
There's so
Yeah, I forgot
many.
about that one.
Uh-oh. Hmm. Yeah, let me know. Um,
Hmm.
there is some more deep diving coming soon on this case. There's some documents that, I mean, there was so much packed into some of those documents that were boom, boom, boom coming out, and we were just reading through them, and there was just a lot of information in there. And I've been sitting down trying to go back through some of those and organize my thoughts with those and get it down on paper a little bit better. So we can talk about some of the things, setting up pretrial for that. For that, and a lot of people are now coming into that case that haven't been around the case, and that's fine. There's no problem with that, but they don't know about a lot of the back stuff, and then they don't know what's actually real and what isn't. You know what I mean? And there, I see a lot of that coming back up to the surface now. I don't know if they're tuning into older stuff and they're, or if it's just being regurgitated. I'm not sure what the heck's going on with all that. But people are always going to have their alternate thoughts and theories, and that's okay.
Mm-hmm.
Yeah, we're gonna have ours, and they're gonna be different from other people's at times. That's okay.
Yeah.
Um, let's see. Oh, oh my gosh, people getting all creepy with their AI stuff.
Yeah, the AI is out of hand.
It is out of hand, and it's fucking creepy.
Mm-hmm.
I will not. I refuse. I absolutely. I'm gonna put it in writing right here today. I refuse to do a thumbnail using AI. Call me old fashioned, behind in the times. I don't care. It's creepy. I have the actual pictures of the actual people.
Oh yeah.
I don't need to make a fake Brian Koberger. It's so obvious they're fake. I don't understand the reasoning behind it. Are y'all now mainstream media too? Clicky clicky, look at me
Yeah.
sensationalizing the case,
The
right?
shower selfies that have been animated are just like
So
beyond.
ridiculous.
Yeah.
It's very ridiculous. I don't care how I personally feel about the case. That shit's ridiculous. It's like are we in elementary school art class and we're all trying to one up each other? I guess if people are into that though, then that's what's getting them in there. That if the only thing getting you into my show is the thumbnail, maybe I am doing it wrong. I don't know. I just can't feel that creepiness. I'm not totally ready to accept that AI can just take over the world, and I'm going to say it's okay. I don't need AI to freaking think for me. It's kind of annoying that people let AI think for them. And let's go ask Grok. Who the hell is that? A machine? Hmm. I've got we got to have a show and talk about some things. I'll get totally sidetracked on this other subject and I'll forget all about Karen Reed today.
Mm-hmm.
Oh, God, girl. Welcome in, Vixie. Thank you for coming in. Yes. Look, they're spending all the money they can on this trial, round two, but they can't. Somebody posted a thing on Twitter, somebody locally who lives there. And they're like, the millions they're spending on this trial, and our courtroom is using dollar store curtains and a broke ass AC that can't cool the courtroom. And I'm like, man, that is pretty pathetic. Maybe they should allocate some money to bring their courtroom into the times, right? Bring it on in.
Yeah, you would think.
Yeah, it's like these courtrooms needing massive amounts of technological advances. They all need the monitors and they need their little tiny desk people. Shit, Hitler's already ordered the ones over in Idaho. Y'all better get your tech people together. Get in here, test out what we got going on. Don't get in here and act all stupid. Don't lose the pointer.
Yeah.
And don't everybody trail up here on the sidebar. Sit your ass down. I love that about him, though. Bev's messy courtroom antics are just a little much for my. They don't compute with my brain. I like order in the court. There's too much disorder going on in this courtroom constantly. Butterfly, I see your comment. Are you having issues with the comments popping up? But then again, when I'm on Restream, they come in slower than usual than they do on the YouTube. Let me pull this up. Okay. Yes, ma'am, we see your comments, so we're good to go. So, guys, it looks like they have subpoenaed about one, two, three, four, about at least 5, maybe 6 people out of Pennsylvania to testify in the upcoming Brian Koberger trial.
Oh boy, we're getting closer and closer to this thing. Hopefully, it's still on
Yeah.
track.
Now, you see the judge did post a hearing notice for the 18th, and we'll cover that. Now, part of that's going to be closed, it appears, and they will be discussing that alternate perp stuff,
Mm-hmm.
as well as other stuff so part of that portion, I think, will be closed, a portion open to the public.
Yeah, the continuance is open and the alternate perpetrators is closed. We
Right.
have 2 months, 5 days, 11 hours, and 7 minutes until that trial.
Okay, so I get like a 2-month vacation. The days I won't count because I got to wrap up Karen Reed. So that gives me a little bit of time.
Yeah, Karen Reed went, what, 30 something days the last time?
I'm not really sure. I think it went a minute.
Yeah, I've got where is it? Let me look in Discord.
Coburgers is scheduled to go a lot longer than that, but we do have a lot more victims to move through. And
Oh, I'm going to be all in for Koberger.
yeah, I will too. I will be streaming it from the minute it starts till it
Mhm.
ends.
Pins and needles.
I just got to figure out the best way I want to do it. I don't really like the idea of coming in late to it.
Mhm.
The only benefit you have to that is you can fast forward through the BS. You can stop and rewind if you want, things like that. But I just don't know if I want to be that far behind.
Mhm.
I don't know. I'm still thinking about it. Because there's going to be times we're going to be like, what? Did we just hear that right?
Yeah, but then with the time zone difference too, since
Exactly.
they're behind us,
Yep.
and everything, if you do start it later, then you're going to be running really late,
Exactly. And I don't want
later
that
in the
either.
evening. So,
Yeah.
yeah.
I don't want that either because it interferes with what I have going on in the evenings around here. We'll work it out. And I'll probably just stream it from the minute it starts because they are on a different time. All these trials are on different damn time zones and it's crazy.
Mhm.
But yeah, with Karen starting early and it wraps up earlier in the afternoon, then I get Lori starts later in the day, wraps. Shit, we didn't even get finished with that. It was 7 p.m. Central, I think, or damn well close to it before they wrapped up yesterday.
Oh, really?
Yeah.
Mm.
Normally her cases would run till at least 6 p.m. my time.
Mhm. Well, she's only like 1
Justice
hour
of the
behind
Superior
you.
Court,
Yeah.
holding in Dedham within
2
and for
hours.
the County of Norfolk. Draw near,
I think
give
Idaho
your
is too.
attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
All right, guys, let's rock and roll.
All right. Good morning, Council. Good morning, Ms. Reed. And good morning, jurors. So happy Friday. I do have to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left yesterday? Day before. Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into the case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left the other day? No? Everyone said no issue. Okay, I understand we have a witness this morning?
We do, Your Honor.
Okay.
Permission?
Yes.
We would ask to join us Dr. Dan Wolf.
Okay. But we'll see how. Thank you, Tony.
You solemnly swear the evidence given before the jury in the case matter will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Good morning.
Good morning.
So, sir, we're going to try and keep the keep the air conditioning on this morning. So I'm going to ask you to speak really loudly into that microphone, and Mr. Jackson, you do so as well, please. Okay.
Of course, Your Honor. Dr. Wolf, could you please state your entire name and spell your last name for the jurors, please?
Daniel Michael Wolf, last name spelled W-O-L-F-E.
May I inquire, Your Honor?
Yes.
Dr. Wolf, what do you do for a living, sir?
I am the director of accident reconstruction at a company known as ARCA, A-R-C-C-A.
And I'm going to start right off the bat, getting really comfortable with that microphone. It's adjustable. Pull it right close to the area of your chin. It's really loud in here.
Okay.
Dr. Wolf, you said you work for ARCA, A-R-C-C-A. What is ARCA?
ARCA is a forensic engineering consulting firm. We have a variety of disciplines: accident reconstruction, which is the group I'm a part of, biomechanics, failure analysis, and crashworthiness.
And you said that your title again, one more time?
The director of the accident reconstruction team.
And what sort of contracts does ARCA normally engage in routinely?
So in addition to our forensic consulting work, we have, going back in time, we've dealt with doing contracts with the Department of Defense, where we designed energy-absorbing seats for MRAP vehicles, mine-resistant armored protective vehicles, where these vehicles were going over explosive devices, and the energy from those explosions was going through the vehicle into the occupant. So ARCA designed energy-absorbing seats to help mitigate the injuries in that type of in those types of incidents. We also do work for the National Hockey League. I myself am part of that work. It has to do with scanning and analyzing player pads, but we certainly do impact testing and help set guidelines for player safety.
With regard to those MRAP vehicles, was that contract for the Department of Defense for the United States government?
Yes, sir.
For the military?
Correct.
Is ARCA both nationally and internationally recognized as a leader in accident reconstruction?
Sustained.
Does ARCA have a reputation, or let me ask it this way, does ARCA entertain or engage both domestic and international contracts and clientele?
Yes.
As the director of accident reconstruction, do you specialize in anything other than just accident reconstruction, anything having to do with human factors?
Yes, so my other specialties in addition to accident reconstruction are lighting and human factors.
What is, give us a 25-word overview of human factors. What is that?
So to give you a good example of that is, and again, this is a case that I commonly see, but let's say you're driving down the road at night. It's an unlit roadway. You're relying on your vehicle headlights to see the roadway ahead, right? And you've got a pedestrian that is entering the roadway. And you want to have an understanding based upon the lighting conditions, how much sky illumination there is, their clothing, right? When would a driver recognize that individual on the roadway? So that's where it starts from the vision aspect of human factors. Then we get into driver response, right? So the driver is presented with a hazard. So how do drivers typically respond to that? What are their actions, and how long does that take to avoid and initiate a reaction?
That's human factors. Can you do the same thing and give us an explanation for accident reconstruction just in the broadest sense? What is that discipline?
I think a very simple definition of accident reconstruction is the application of physics and engineering science to collision events.
What role do you take as the director of accident reconstruction for ARCA as contracts come in or engagements come in?
Well, my scope in cases can vary greatly. As I just mentioned, I could have a case where I'm assessing the conspicuity of a pedestrian and a driver's response time. It could be a 50-car pileup on a highway, and I'm trying to figure out a sequence of events. It could be a rear-end collision where a seat back has failed in the vehicle and the occupant has sustained injuries. and we want to have an understanding of the crush, the damage, the forces. So again, it can vary case to case.
Do you engage in reconstruction or attempt to engage in reconstruction of all sorts of passenger vehicles and commercial vehicles?
Yes.
What about motorcycles?
Yes.
Bicycles?
Yes.
Involving pedestrians and sometimes involving no pedestrians?
Yes, I see all types of collisions.
How many cases, if you have a number in mind, have you been a part of in terms of engaging in accident reconstruction broadly?
That's something that I don't track, but I've been with the company now for over 8 years. So at this point, if I had to estimate, it's well over 1,000 at this point.
What education, training, and background do you have that allows you to perform the duties that you've described for these jurors in terms of accident reconstruction and human factors analyses? In
terms of, are you looking at additional training?
No, let's start with your education. I want education, training, and background, but we can do them in order.
Okay, yeah, so we'll go back to 2012. I received a Bachelor of Science in Engineering from James Madison University, along with a minor in mathematics. Some of my courses included physics, statics, dynamics, thermodynamics, fluid mechanics, your engineering sciences. Subsequent to that, I then went on to pursue my PhD in electrical and computer engineering, with a concentration in electromagnetics and photonics. So my coursework while doing my PhD included optoelectronics, semiconductor physics, basically how to guide light on semiconductor devices.
Did you write a dissertation to get your PhD?
Yes.
What was the subject matter broadly of the dissertation that you drafted?
So my dissertation focused on a technology called smart glass. So you may have seen this technology where if you've seen a pane of glass that is transparent, somebody flips a switch and it goes opaque. That's a type of smart glass technology. So my PhD involved developing a new type of novel, what we coined optofluidic smart glass. So we are using geometric structures that we've optically designed to create a very reflective surface or medium, if you will. And then through the introduction of various fluids, we can then modulate the amount of visible light and electromagnetic energy that is passing through or being reflected. So not just visible light, but also energy that you can't see. As part of that process, I ended up prototyping these structures with a 3D printer that was capable of printing 3D printable polymers. And as we kind of got towards the end of my work, we looked at how we could scale this up on a larger scale. And we ultimately ended up researching and doing tests with a material known as polymethyl methacrylate, which is PMMA or acrylic.
What relevance does PMMA play in terms of this case?
So with respect to this case, the outer lens and the clear plastic diffusers of the taillights on the Lexus are comprised entirely of polymethyl methacrylate, or that PMMA material. The
same material that was the subject of your dissertation?
Correct.
What additional training and experience do you have as it relates to accident reconstruction beyond your BS and your PhD?
So certainly the 8 years of work that I've had at ARCA has certainly trained and taught me a lot over the last 8 years. Like I said, I've seen hundreds of collisions, all different types of accidents. But in addition to that, I've continued to take courses through Northwestern University in crash reconstruction, human factors in lighting, heavy vehicle forensics, heavy vehicle EDR downloads, Bosch data retrieval and black box downloads, photogrammetry, so a number of continuing education.
Are you accredited as a traffic accident reconstructionist?
Yes.
By whom?
An organization known as ACTAR.
Is that a nationally recognized organization?
Yes, sir.
What does that stand for, ACTAR?
The Accreditation Commission for Traffic Accident Reconstructionists.
Are you trained in photogrammetry?
Yes.
What is photogrammetry generally?
So photogrammetry is the science of extracting and measuring information in a photograph. So you don't actually have to physically inspect something to be able to get information about its measurements or where things are spatially. You can do that from a photograph alone.
Is that an accepted methodology in the field of accident reconstruction to use photographs and or videos without actually having been at the scene during the course of the crash?
Absolutely. It's very common.
You mentioned Bosch. What is the Bosch crash data retrieval analysis? What is that generally?
So generally, most modern vehicles on the roadway now have what's called an airbag control module, or more commonly known as a black box, which can contain crash-specific data in a collision.
Are you a member of any professional societies?
Yes.
Can you describe those for us, please?
So I'm a member of the Society of Automotive Engineers, the National Association for Professional Accident Reconstruction Specialists, the Illuminating Engineering Society, and the Optical Society of America.
Is it fair to say that you've authored a number of peer-reviewed papers in the field of physics and/or accident reconstruction?
Yes.
Can you describe that for us?
So my most recent publication in the field of accident reconstruction deals with vehicle control history records. Publications prior to that were focused primarily on my dissertation PhD work.
I think you testified that you have dealt with probably over 1,000 different types of cases. Are you able to estimate, of those 1,000 different types of cases dealing with accident reconstruction, how many of those, or what percentage of those, have involved pedestrians?
I don't know if I can give a percentage. I would certainly say it's the majority of my casework. As I mentioned earlier, given one of my specialties being in human factors and lighting, there's a direct correlation between time of day and pedestrian collisions. We certainly see a rise as sky illumination drops and the illumination levels go down. We're having to rely on artificial light sources. So given that occurrence happens in nighttime hours and low illumination, like I said, I certainly see many pedestrian accidents.
What types of pedestrian impacts have you been involved with in terms of your analysis or evaluations?
All different types, everything from pedestrians being run over, running into the side of vehicles, being hit by the front of a vehicle backing up in a parking lot into a pedestrian. So I've seen it from all sides of a vehicle.
What is kinematics? Can you describe that or explain that phrase or term?
I think a simple definition would just be the motion of an object or a body.
Have you done any testing as it relates to kinematics and the interaction between pedestrians and motor vehicles?
Yes.
How many times have you engaged in such an analysis?
Numerous times. We frequently and routinely do testing at ARCA.
You mentioned ARCA has several different disciplines within it. What are some of those different disciplines in addition to accident reconstruction?
So, as I mentioned, we have biomechanics and crashworthiness, and there's a few others. And I will note that it's very common in our casework that we will work together as a team. So to give you an example of that, I mentioned earlier about, that rear end collision, right? So let's just say we have a rear end crash and there's crush and there's damage to the rear of the vehicle and the seat back failed, which caused the driver to ramp up in the seat and ultimately hit their head on something and sustain an injury. So I myself, as a reconstructionist, will analyze the forces, the speeds, and the severity of the crash. The biomechanist will evaluate the mechanism for the injury based upon those crash forces. And the crashworthiness expert may analyze, okay, is there a better or stronger seat that may have held up in this crash?
Is it normal for you, as the director of accident reconstruction at ARCA, to work with others in the other disciplines that are housed under the umbrella of ARCA?
Absolutely, yes.
Is that a normal process for you?
Very common, yes.
As a matter of fact, it probably would be uncommon if you didn't do that, correct?
Depending on the kind of case, but yeah, certainly wouldn't be uncommon.
Tell me about the testing that you've undertaken to determine forces that are at play in a given accident or an impact.
Okay. So to give you maybe a simple example of it is, let's just say we have a sideswipe type collision where two vehicles sideswipe each other and a front bumper gets torn off or deflected, essentially, and there's some deformation to it. Right? We can do testing at ARCA to determine how much force does it take to bend that material so that we get the deformation that we have. That would be a good example.
Is there a specific type of testing, or is there varied types of testing that you've done and undertaken to determine the forces that would be, for instance, in your example, in that the forces at play in that sideswipe collision?
Yeah, absolutely. It would have been, again, as part of the test, we would be measuring the forces, we'd be measuring the displacement, we'd be able to calculate acceleration and things of that nature from that test data.
The tests that you undertake, are they generally accepted methodologies in the field of accident reconstruction?
Yes.
What are quasi-static tests?
So a quasi-static test would be like the example I just gave you, where we have basically the bumper would be stationary, right? And now we're pulling on it to determine how much force it takes to bend it. So that'd be an example of a quasi-static test.
So that test specifically is determining or attempting to determine the amount of force necessary to deform a bumper, for instance, in the way that it's seen after an impact.
Yes.
Or any other body panel, correct?
Correct.
And on the human side, also there are forces at play, I'm assuming, in terms of injuries that are sustained by pedestrians in the accident reconstructions that you've done involving pedestrians.
Yes.
Do you have experience in evaluating whether damage to a vehicle is consistent with a proposed scenario or set of facts?
Yes.
Describe those circumstances for us. What are the circumstances in which you're trying to determine whether or not the damage fits a proposed scenario?
So a case that commonly comes across my desk is we have two very different versions of how an accident unfolded according to Party A and Party B, right? And we have a set of evidence in terms of the damage to the vehicles, maybe some roadway evidence, right? So we can look at that objective evidence, utilize physics, maybe some calculations, determine whose version is most consistent based upon the damage and the roadway evidence.
Is that an accepted methodology in the field of accident reconstruction?
Yes.
In other cases in which you've undertaken such an engagement to determine whether or not the physics or the physical evidence matches a particular scenario or is inconsistent with that scenario, have you been able to ultimately reach conclusions and opinions to a reasonable degree of scientific certainty in those cases?
Yes.
Is that normally what you're seeking, to ultimately come to an opinion or a conclusion about those scenarios or circumstances?
Yes.
Are your opinions and conclusions based on your education, your training, the background and experience that you've explained to the jurors?
Yes.
Is it also in furtherance of the scientific methodologies that you employ in order to come to those opinions and conclusions?
Yes.
And are those generally accepted in the scientific and accident reconstruction community as a proper methodology to come to opinions and conclusions of that nature?
Yes, sir.
Have you been qualified in other courts to testify in the area of accident reconstruction?
Yes.
Let's talk about how you began your work in this particular case. When you were initially retained in connection with this case, were you hired by the defense?
No.
Did you know who we were?
Sustained.
Your Honor, may we approach?
Yeah, you can ask it differently.
Oh, we
Sure.
knew that was coming.
Were you hired by anybody affiliated with the defense?
No.
At that time, did you know any of the names of the defense?
No.
At the time that you were hired to or engaged in this case, did you even know the name Karen Reed?
Sustained.
Did you know any of the names or of any of the parties?
Sustained. I'll see it.
Sure.
Y'all know it was the feds. Bev, you know it was the feds. Can't we say the other agency? You didn't know any of us, and another agency hired you, sir. What you scared of, Mr. Prosecutor? This guy's about to blow handy dandy paint guy out of the water. There's a couple of new faces I haven't seen before. They're over there trying to figure out how to explain it to the jury without spilling the beans. I think y'all should have talked about that before the trial. I think Bev needs a lesson in courtroom decorum. I don't think she'll be writing any papers on how to give advice to other judges on how to run courtrooms. She needs to be reading those. Running a courtroom in modern day times, it's not what it used to be. Picture our forefathers sitting in this room just screaming at each other. Yeah, it might have been a good idea, but old Bev, she just doesn't care about ideas. She was one of those people that just rolls with life. Whatever comes up today comes up. We'll just meet it as it happens. Spencer, my dad, would be sitting right there beside me. Amen to him. That's what a family's supposed to do from both sides, right? It's be there to support. It says a lot about both sides, actually.
When you were initially hired to look at the facts and circumstances of this case, did you do so independently? In other words, were you given a series of facts and a series of data and asked, just look at these facts and look at these data and make a few determinations about accident reconstruction in this case?
Yes.
What were you asked to do specifically?
It was to look at that evidence that we were provided and determine whether or not the damage to the vehicle was consistent with the injuries to Mr. John O'Keefe.
At the time that you were asked to engage in this independent analysis, were you provided information or data?
Yes.
Who at ARCA was assigned to the team that would ultimately engage in this particular analysis?
It was myself, Dr. Andrew Rentschler, and Scott Klein.
Describe what the materials were that you were provided in your initial assessment of this case.
Could I refer to my report?
With the court's permission.
Would you like me to just go in order from the materials reviewed?
That would be fine.
The Norfolk SPDU homicide death report, the Commonwealth of Massachusetts Department of State Police crime scene report, OCME dispatch removal report, photographs of the incident location, videos of the incident location, photographs of the 2021 Lexus LX 570, photographs of recovered evidence, crash data retrieval report from the 2021 Lexus LX 570, report of autopsy photographs, and there was a few other items there, but those were generated internally.
There were about 14 things that were listed in terms of categories of information that you were provided, or ARCA was provided, is that right?
A little less than that, because some of those, like I said, were internally generated, but yes.
Why were you provided that data? What's the reason why it's important for you to get certain data as you begin your analysis?
Well, we wanted to have an understanding of, or ultimately the entity that retained us wanted to have an understanding of what, I guess, the evidence that we would need to reconstruct this.
Did you get enough information to engage in a fulsome analysis, an accident reconstruction, in terms of the initial request by the entity that hired you?
Yes. In terms of our scope, yes, we had sufficient information.
Were you able to review photographs of not only the Lexus involved, but John O'Keefe's body?
Yes.
Did you use those photographs in furtherance of your analysis?
Yes.
Did you use the reports detailing scenarios or possible scenarios in furtherance of your analysis?
From what I recall, I don't believe any of the reports indicated any type of theory or understanding of how the accident occurred.
Were you asked to determine whether or not certain scenarios could be possible?
I don't recall them giving us any scenarios to evaluate. They essentially left it in our hands. Here's the evidence. What do you think happened?
That was an open question, correct?
Correct.
All right. Did you engage in an analysis that basically allowed you to think of any scenario?
I think that's fair, yes.
In your initial analysis, did you note damage to the vehicle?
Yes.
Describe the damage. Let's start with the vehicle. Describe the damage that you noted in furtherance of your analysis.
The primary damage was to the right rear taillight on the quarter panel section. The majority of the outer red lens was broken and shattered, as well as some of the underlying components and diffusers that are underneath that outer layer, as well as some damage to the back portion of the taillight.
Can I stop you right there? Describe when you say the outer lens material and some interior material as well was damaged. Describe that in detail for us.
So the outer lens is red, and it's about 5 millimeters in thickness, and it basically encompasses the majority of that quarter panel taillight. And then there's a small segment that is clear, that is for the turn signal indicator, which is yellow. Underneath that 5 millimeter thick red lens, there are additional diffusers that run along the bottom. There's two rows of those, I believe, and then they also go up vertically on the side, and those are clear. And I think the thicknesses of those are about 3 millimeters.
Is 5 millimeters of PMMC, have I got that right? PMMA?
You'd call it acrylic. That's the more common name.
Easier for me. Is 5 millimeters of that acrylic, that outer lens material, is that considered thick or thin in terms of just sort of what we'd see on a taillight?
I would describe that as a pretty thick piece of plastic. It's certainly by no means. You can't, if you had a segment of it and you try to bend it, it's not going to bend.
Okay. In addition to that outer taillight material, that acrylic, in terms of the information that you received, did the interior acrylic also have damage to it?
Yes, those clear diffusers that, again, there's 2 rows of those, and they also went up vertically. Those were shattered and broken as well.
Was that important to you in your ultimate analysis?
Yes.
Did you note any superficial scratches or dents anywhere on the tailgate area or the liftgate area?
Yes, there was a dent and some paint chips, if you will, above the liftgate taillight assembly. So again, that next to that quarter panel taillight, there's another assembly that is on the liftgate, and there was a small dent and some paint chips at that area. There was also on the wraparound section of the bumper cover, as it's going from the rear to the right side, there were some superficial scrapes in that area.
Did you note any other damage or deformation to the Lexus? Deformation in the the liftgate, the bumper, anything like that?
No.
Is it common in a vehicle-pedestrian collision that there is some sort of bumper deformation that's associated with a vehicle-pedestrian incident?
That can certainly occur if a pedestrian is in an normal upright position. You can certainly get displacement of the bumper.
Did you see any displacement or panel deformation on the Lexus?
No.
Is it more common that there's panel displacement or deformation if the collision is above, say, 10 or 15 miles an hour?
Yes.
During your review of all the investigative materials, did you note any items of evidence that were recovered or claimed to have been recovered on the bumper itself?
I recall there were 2 or 3 apparent glass fragments.
What's the significance of that? Let me ask it differently. Is there any glass in the taillight assembly? May I ask that again?
Yes.
Is there any glass in the taillight assembly?
No.
Was there any shattered glass anywhere on the Lexus? Meaning panes of glass, the back window, quarter panel windows, anything like that?
No.
Did you have any understanding at that time of what the Commonwealth's theory of the case was when you began your initial analysis?
Sustained.
Did you have any indication of what the Massachusetts State Police theory of the case was based on the investigative reports that you had received?
Sustained.
Did you perform an accident reconstruction analysis to determine whether or not the damage to the Lexus, that taillight housing material, was consistent with an interaction with a pedestrian?
Yes.
Specifically, did you perform an accident reconstruction to determine whether the damage to the Lexus was consistent with an interaction with John O'Keefe based on the injuries that you were aware of?
Yes.
Did you evaluate whether the investigative theories regarding, let me ask it a different way. Did you consider the possibility of Mr. O'Keefe's head striking the taillight?
Yes.
Did you consider the possibility of Mr. O'Keefe's arm striking the taillight?
Yes.
Did you entertain the possibility that Mr. O'Keefe's center of mass, his body, struck the taillight?
Yes.
Before we get into the initial testing, were you able to come to opinions and conclusions concerning those things that I've just mentioned?
Yes.
Did you also entertain the possibility that a drinking glass could have damaged the taillight?
Yes.
Were these some of the things that you were sort of, it was left open to you to decide yourself?
Yes.
Did you later provide all of those opinions and conclusions in a report to the entity that hired you?
Yes.
Is your understanding that those reports were then later supplied to both sides here in this case?
That was my understanding, yes.
Did you testify about those initial testing opinions and conclusions at a proceeding last year?
Yes.
Let's talk for a second about that initial testing that you conducted in connection with this case. When approximately did you begin your testing? And I'm going to phrase it as your initial testing, the testing that you testified to about last year. When did you start that initial testing?
From what I recall, it would have been late 2023 into early 2024.
I want to talk about the drinking glass first. Did you become aware that there was a drinking glass that was found at the scene?
Yes.
And what was the testing that you sought to determine as it relates to the drinking glass and the taillight?
So looking at the evidence, as I mentioned earlier, when we're looking at that quarter panel taillight, we have an isolated region of damage. And looking at the additional evidence in terms of a broken drinking glass at the scene, we wanted to do testing to determine if a small object or projectile such as the drinking glass could induce damage that was consistent with that we saw on the subject Lexus.
Were you able to reach an opinion and or conclusion as it relates to whether or not there is a possibility that the drinking glass or a drinking glass could cause the type of damage that you saw on the Lexus?
Yes.
Given everything else in your investigation, are you concluding that the glass was responsible for the taillight damage?
No.
However, you did seek to determine whether it was possible, correct?
Sustained.
I'll ask it a different way, Your Honor. What testing did you do, did you undertake in furtherance of that specific, answering that specific question? Could the glass damage the taillight?
Right. So we designed a pressurized cannon that was capable of firing the drinking glass into the taillight at various speeds. We aimed for speeds of 30 and 40 miles an hour. Our achieved speeds were at 31 and 37 miles per hour. And we found that in the 37 mile an hour impact, and again, this is to emulate or simulate an individual throwing a drinking glass. The purpose of the cannon, if you will, was to be able to hone in on a speed precisely and obviously aim for that target. So it would just serve as a means of getting that projectile to the taillight in a means that we could measure it. And what we observed in the 37 mile an hour test is that we got damage that was generally consistent with that of the subject taillight, and that there was a large portion of the outer lens that was shattered and fractured, as well as the underlying clear plastic diffusers and chrome piece.
Tell me a little bit about the methodology that you undertook, the scientific methodology in building that pneumatic cannon and aiming that glass directly at the taillight.
Absolutely. So, as I mentioned, it was a customized cannon, if you will. It had a barrel that was capable of fitting a rocks or an old-fashioned drinking glass in it, and that's a glass that has a thinner sidewall, if you will. I think the glass was about 3 inches in height or so, maybe 3.5 inches, with the bottom portion being solid glass or just a thick piece of glass. So we were able to design a kind of a holder for it, if you will. Almost, you could really think of it as stuffing an actual cannon with a cannonball. So we literally would put the drinking glass in the cannon. There was a pressurized vessel behind that we would open up a valve rapidly, and when it was set to a certain pressure, that would determine the exit velocity that it would leave the barrel at. And we were able to aim that device into the taillight at those specified speeds to be able to determine what would the damage pattern be when we fired that glass.
Were you able, in this scientific experiment, to control for aim and trajectory?
Yes.
Were you able to control for velocity or exit speed of the glass?
Yes.
Were you able to control for damage patterns as it pertained to both the glass as well as the taillight at which it was aimed?
I don't know that we had control over that. Ultimately, physics takes over after that interaction occurs. I can't influence how that material is going to perform or how the glass will break, per se.
It's a poor question on my part. Were you able to, or did you undertake to memorialize the damage pattern that you saw on the taillight and the glass as the glass was projected into the taillight?
Yes.
All right. Did you do that through photographs?
Yes.
High-speed video?
Yes.
And all of that was memorialized in your report?
Correct.
Your Honor, may I approach?
Yes.
I'm handing you 2 photographs, or 2 8.5 by 11 documents that contain 2 photographs each. Can you take a look at those 2 documents and tell me if you recognize those?
Yes.
Does one represent, you mentioned that one of the tests that you performed was at 37 miles an hour, correct?
Correct.
Did you mention the speed at which, or the velocity at which the other test was done?
If I didn't, it was 31 miles per hour.
All right, so 31 and 37. Do you see those 2 documents in front of you?
Yes.
Does one of them represent the 31 mile an hour test and the photographs associated with that?
And an extracted frame from the high speed, yes.
Okay, and does the other one represent the other test, the 37 mile an hour test?
Yes.
If we could take those one at a time. May I approach one more time? If I could ask that these be marked as next in order, one at a time, 31 mile an hour test, and hand it to the corner with the court's permission.
So there's no objection?
None, thank you.
Okay.
I'm sorry.
213?
And the second document represents the 37 mile an hour test.
214.
She had to find that comfy spot, Dolphin. Make sure it was really her bed. You just slid a fake in there on her.
Exhibit 213. I'm sorry, present Exhibit 213.
She had to nest.
Is this the photograph that was just marked as Exhibit 213 that's in front of you?
Yes.
Can you explain to the jurors what they're looking at?
So on the left part, you are looking at a frame from the high-speed video just after the contact with the taillight. On the right, you're looking at the post-damage to the taillight after the glass had been fired into it.
And if we could look at the next exhibit with the court's permission.
Okay.
And what are we looking at here?
Same thing on the left. Again, this is the 37-mile-an-hour test. The glass striking just in the area where the bottom of the turn signal indicator is, so right where it meets the red portion of the lens and the clear portion of the lens. That's about where the impact point was. You could see that a large portion of the outer red assembly, lens cover is missing and fractured. The clear portion of the part of the outer lens to the turn signal indicator is also fractured, as well as the underlying clear diffusers in that assembly.
Would your testing in both of these scenarios, the 31-mile-an-hour test and the 37-mile-an-hour test, represent an accepted methodology for controlling for aim, velocity, impact site, and those issues, if you will, as it relates to testing of this sort?
Yes, we were able to control those variables.
And is that an accepted methodology in the area or the field of accident reconstruction?
Absolutely, yes.
When you finished your testing, were you able to make a determination as to whether or not either one of these velocities, the 31-mile-an-hour velocity or the 37-mile-an-hour velocity, were consistent with the damage that you saw on the subject Lexus, which is the 2021 Lexus belonging to Ms. Reed?
Yes, from the 37-mile-per-hour test, we are getting damage that's generally consistent, and that I mentioned we have portions of the outer lens missing, the underlying diffuser. There was also some fracturing on the backside of the assembly. So again, we observed damage that was generally consistent with that of the subject taillight.
And that was the 31 or the 37?
The 37.
The 37. What about the 31?
Didn't have enough energy to create that damage.
So were you able to conclude, in your opinion, whether or not the velocity of that glass hitting the taillight would have to be somewhere in the vicinity of 37 miles an hour, well above 30 miles an hour?
Well above, and it certainly could have been above 40 miles per hour per se. I mean, we may have actually blown out more of the outer lens had the speed increased.
Did you have any information in the data or documents that you reviewed associated with this case, for instance, that John O'Keefe had a pneumatic cannon with him out there?
No.
Okay. So obviously, well, let me ask a different way. Based on this series of tests, were you concluding that the damage on the taillight conclusively was the product of a glass being hurled into the taillight?
Objection. Sustained.
Were you concluding, or did you opine, that the damage to the taillight came from a drinking glass?
No, I gave an opinion that the damage was generally consistent with that in the test, compared to the subject taillight.
But only in the circumstance where the glass is being hurled at 37 miles an hour, correct?
Sustained. Can I ask it differently?
Under what circumstance did you determine that it was consistent with a drinking glass?
If that drinking glass, again, the purpose of the test was to do a test to evaluate or simulating somebody throwing a drinking glass at the taillight. So that's what that test was to demonstrate.
Understood. Let's turn to another test that you undertook regarding the head injuries that you became aware of. Did you become aware of, in the data that you received, that Mr. O'Keefe had suffered head injuries to the back of his skull?
Yes.
What sort of testing did you do to determine whether or not and under what circumstances that head injury may be connected or associated with the damage to the taillight?
We performed a drop test with a hybrid 3, so that's an instrumented anthropomorphic test device to be able to measure the accelerations on a head form and observe the damage to an impact to the taillight.
What is an ATD, anthropomorphic test device?
So it's a device that's commonly used in our field, and it's certainly approved by the federal government to evaluate crash forces and occupant kinematics, or I should say occupant crash forces. So it's a device that reconstructionists and biomechanists typically use or commonly use to be able to evaluate, like I said, whether it's forces in a motor vehicle, or let's say you have something being dropped on somebody's head or an impact to somebody's body part, right? We can use that instrumented dummy to evaluate and measure the acceleration in the forces.
Another word or another phrase often used in association with ATD devices are crash test dummies, correct?
Correct, yes.
Why was it important to do a drop test?
So we wanted to have an understanding based upon the fact that Mr. John O'Keefe had a skull fracture to the back of his head, whether or not an impact, a direct impact between the taillight and the back of his head could have caused that skull fracture.
What did your testing indicate?
When we did the test, the impact to the taillight was at 15 miles per hour, and we observed that the damage to that taillight was significantly more than the subject taillight at the 15-mile-an-hour speed. Furthermore, it did not generate, according to my colleague, Dr. Rentschler, enough forces to cause a skull fracture.
So ultimately, what was your conclusion related to the taillight potentially striking John O'Keefe in the head at above 15 miles an hour?
From a damage perspective, it was inconsistent.
Inconsistent.
Correct, inconsistent.
Did you consider temperature and control for temperature in any of your testing?
Yes.
Why is that important?
Well, that will affect how that, we've talked a lot about that acrylic material of the lens. That will certainly affect how it fractures, so we absolutely controlled the temperature during these tests.
How did you control for temperature?
So we had them sit overnight in chest freezers to get them to the desired temperature, which for our original set of testing was at 28 degrees Fahrenheit. We then rapidly moved them to our test fixture, and then they were fired almost immediately after that.
And when you're talking about them, you're talking about exemplar taillights.
Correct, yes.
Are those exact replica taillights that you would find on the 2021 Lexus SUV?
Yes.
After your testimony in the first proceeding last year in the spring of 2024, were you ultimately contacted by the defense in this case?
Yes.
When were you contacted by the defense?
I know that I had reached out to you, I believe it was in February of this year, because I think I saw some things in the media and was just wondering what was going on.
Sustained. Just when? Just a date, Dr. Wu?
He shouldn't have said
I don't
that.
know if I could give a specific date. If I had to estimate, sometime in February or March, probably.
Thank you.
Were you still under contract with the other entity that hired you?
Sustained.
At some point, you and I spoke, correct?
Correct.
And that was, you believe it was February of 2025?
Yes.
Had we spoken at all between the end of your testimony at the proceeding last year and February of 2025?
No, that was the first time.
Did I ask you anything about retaining you?
Not at that time, no.
At some point, subsequent to that initial discussion in February of 2025, did we have another discussion about the potential of retaining you?
Yes.
Tell me about that. When was that?
From what I recall, it was sometime in March, and we were trying to figure out.
Sustained. Next question, please.
Did I ask you if you were available to be retained by the defense?
Sustained.
May we approach?
Okay.
Yeah, how y'all want him to handle that question? We don't want to give Hank stuff to have a field day with in a few minutes or attempt to make himself look crazy. Yeah, approach. I would be so angry at that defense.
She has such an attitude.
She
Jesus.
does.
Next question, please. Oh my God.
This defense team, though, is really keeping it together with her. I would have gotten so frustrated with her by now. I'd have been like, you hag, I mean, very, very bad words. Probably what came out of my mouth.
Yeah. I was just sitting here. I had moved it to my second monitor, so I was watching it and watching chat, and I was like, "Ooh, I haven't reconciled my Quicken in 4 months." Right? I was like, I need to do that. So I'm over here cha-ching, cha-ching, because it makes a noise every time you match something. And then she was, she said all that, and I was like, ugh,
Yeah.
this woman.
Yeah. I mean, So when the feds hired ARCA and he did his testing and he gave them his conclusions, then later he's still not talked to the defense because they don't even know about him. And he's
Mm-hmm.
watching stuff on the news and then he reaches out to the defense. That's how they became connected. Now, did you pay him or did you not? Well, aren't they all paid? I don't care about that part. Like, I don't care. What matters is his testing and the results that he found, right? So far, he's believable. His methods of getting the testing done are far better than paint guys' stuff. It makes you wonder, all these insurance companies out there, if you ever get in a car wreck and they want to not pay you because the guys like, what's his name, were over there reconstructing your accidents saying, nah, she's crazy. It was really, her
Mm-hmm.
fault. Yeah, that's the kind of guy who's out there deciding your case, not this ARCA guy, that other guy. It's
Why don't they want them to know what agency originally hired them?
because this jury isn't allowed to know about the federal investigation.
Oh.
They know about the first trial.
Mm-hmm.
They do know we've had one, so that's why they keep referring to the other agency, and they're not allowed to say the feds
Mm-hmm.
or
And the
whatever.
federal investigation came into being because of so-called police corruption or whatever.
Yeah, the feds began to investigate, what
Mm-hmm.
was going on over there, and they're the ones that dug up all the stuff on Proctor, the text messages, and which ended up in resulting in him getting fired. But
Oh,
they,
nice.
yeah, and then the feds also hired the ARCA team to come in and give their findings. So if ARCA gave the feds findings that said we don't believe a car hit this man, what are they doing with that information, and what will be the outcome of that?
Mm, yeah.
That's what I'm waiting to see.
May I inquire?
Yes.
Thank you. Okay, Dr. Wolf. So ultimately, in March of 2025, were you hired by the defense?
Yes.
Okay. Were you asked to do anything or to review anything from the Commonwealth and any of their experts in relation to testing that was undertaken by them regarding the Lexus and Mr. O'Keefe?
Yes.
What were you asked to do?
My understanding is that we were asked to review and evaluate the report and analysis conducted by Dr. Welcher.
Did you receive Dr. Welcher's reports?
Yes.
Did you receive his raw data?
Yes.
Did you receive his 140-plus page PowerPoint?
Yes.
And did you undertake a review of that, all of that data, in order to evaluate that data?
Yes.
What methodology did you undertake at that juncture before you began any testing? Just your review process. What methodology did you undertake in terms of your review of his evaluations and his opinions and conclusions?
Well, I think when reviewing his report and his analysis, I look to his opinions, and then I look to what's the basis and the foundation to those opinions, right? How did he ultimately arrive at those final conclusions? So I'm looking for the methodologies that he followed, what testing did he do, what type of experiments, what type of data analysis, ultimately to provide that opinion.
Ultimately, did you prepare a PowerPoint presentation in furtherance of memorializing your review and opinions and conclusions of his evaluation and testing?
Yes.
Did you bring that with you today?
Yes.
Do you have that with you on your computer, or are we going to run the PowerPoint?
It's on this computer up here with me.
With the court's permission, could Dr. Wolf present his PowerPoint presentation?
Okay.
Your Honor, I have a thumb drive that I believe represents the PowerPoint. Do we have this marked?
Yes, is this coming into evidence?
I'm agreeing it's minus the name, not evidence.
All right, so we'll mark it for identification.
We can mark it for identification for the time being and discuss it later. Thank you, Your Honor.
Should it BBB for identification?
May I proceed, Your Honor?
Yes.
Dr. Wolf, do you see what's displayed or presented up on the TV screen?
Yes.
All right. Do you have with you, by the way, just a matter of housekeeping, something called a spotlight?
Yes.
Something that can do whatever spotlight that.
Yep.
Okay.
Yes.
I may ask you to employ
Get
that,
your
or I may
pointer.
take it from you at some point as we're discussing this. Do you recognize what's on the screen?
Yes.
What is this?
This is my PowerPoint with just the first page, the title.
If we can move to the next slide, please. Describe what we're looking at in this slide.
This is from Dr. Welcher's PowerPoint presentation, slide 121, in which he's indicating that there are lacerations on John O'Keefe's right arm and forearm, and he's indicating in this slide that the location and orientation of the lacerations on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right rear taillight of the Reed 2021 Lexus LX 570.
In coming to your opinions and conclusions, and I know this is a mouthful, did you consider the opinions and conclusions of Dr. Welcher in conducting your analysis and your ultimate testing?
Yes.
Did you rely on Dr. Welcher's report and his PowerPoint in reaching your conclusions and opinions ultimately in this case?
I don't know that I relied on it. Certainly, I utilized them to have an understanding of what his basis was for his opinion and what his opinion was. Ultimately, at ARCA, we did our own independent testing to evaluate that.
So just to be clear, I'm not asking Dr. Wolf if you agreed with his opinions and conclusions. I'm simply asking, did you rely on those in order to come to your opinions and conclusions? Did you incorporate them?
Sustained is to the
Did you agree ultimately with Dr. Welcher's opinions and conclusions?
sustained.
You certainly were aware of what his opinions and conclusions were, correct?
The form, Mr. Jackson, on that one.
Were you aware of Dr. Welcher's opinions and conclusions?
Yes.
Are some of those opinions and conclusions represented in your PowerPoint?
Yes.
Are some of them represented on this slide in your PowerPoint?
Yes.
You indicated that this slide indicates that the location and orientation of the lacerations on John O'Keefe's right forearm and arms are consistent with the geometry and orientation of the right rear taillight, correct?
Correct.
Are the injuries to John O'Keefe's arm lacerations?
That would be an opinion for my colleague, Dr. Rentra.
Have you ever heard the phrase abrasion?
Yes.
In your opinion, are the injuries to John O'Keefe's right arm better described as lacerations or abrasions?
I don't have an opinion on that.
Okay. Slide number 2, please. Based on your review of Dr. Welcher's reports and his data, what testing did Dr. Welcher undertake or conduct?
So he did, initially it appeared that he did a static test, if you will, just demonstrating holding his right arm out adjacent to the rear taillights on the right side of an exemplar Lexus to demonstrate his theory of how the arm contacted the taillight.
What is a static test?
So I'm sustaining that. Ask it differently, Mr. Jackson. And I'm going to strike that.
Lady,
What testing did you note that Dr. Welcher did with regard to this particular photograph? What is a static test?
Well, in a static test, that neither the arm or the vehicle is moving. It's just he's aligning his right arm adjacent to show how his arm aligns to the geometry and the dimensions of the Lexus.
Did Dr. Welcher appear to be wearing similar clothing as John O'Keefe was wearing on January 29, 2022?
Yes.
Was there any significance or purpose for that, in your opinion?
In this test, no.
Did you identify any limitations with regard to this sort of testing undertaken by Dr. Welcher?
Well, it's very basic in that the only thing that this demonstrates is that you can get your right arm to align with the taillight. Beyond that, it doesn't tell you anything with respect to what happens to the arm when it makes contact with the taillight, right? What's the motion of the arm? What's the damage to the taillight? What's the acceleration of the arm? What's the forces of the arm? So it doesn't answer any of those other questions. The only question it answers is, does the arm align with the taillight?
You're aware that John O'Keefe was 6'1", correct?
Correct.
Is the only person, let me ask it a different way. Can only a 6'1" person align their arm with the taillight?
No, the arm is adjustable, so certainly people of different heights could also meet that alignment as well.
Just by pivoting your arm a little bit, right?
Sustain.
How would you describe the ability of somebody 5'7" or 6'3" being able to align their arm with the taillight?
Just changing the orientation and the posture of your arm.
Was there any scientific significance, in your opinion, of this particular test?
Again, other than just demonstrating that it aligns with it, no, nothing beyond that.
Next slide, please. What are we looking at here?
So this is an extracted frame from one of his dynamic tests in which the vehicle is moving at about 2 miles per hour into his arm, making contact with his hand, his forearm, and his elbow.
What is a dynamic test as it relates to a static test?
So that's when something's in motion, and in this instance, it's the Lexus moving at about 2 miles per hour into his arm.
Did Dr. Welcher explain what the purpose of this test was?
From what I recall, I think it was to demonstrate that when his arm makes contact with the taillight, he observed paint transfer in the general location that there were the abrasions or the lacerations on his arm.
Did he appear to paint the taillight?
He did, yes.
Do you see that Dr. Welcher appears to be wearing an orange T-shirt?
Yeah.
Sustain.
What is he wearing?
Appears to be an orange T-shirt.
Is that similar to what was described as John O'Keefe having worn that night on January 29th, 2022?
Yes.
Is there any significance to wearing that T-shirt?
Not that I can think of, no.
Did you note any or identify any shortcomings with this particular test?
Well, much like the static test, again, it leaves the door open to all those questions, right, about, again, doing this at 2 miles an hour doesn't tell you anything about, well, what happens at 10? What happens at 15? What happens at 20? Right? In terms of what are the collision forces? What's the damage? How does the arm move? What would the expected injuries be? Right? This dynamic test, as well as the static test, doesn't answer any of those questions for us.
Is this test from Dr. Welcher considered a force calculation?
I'm not aware of him making any type of force calculations or measuring accelerations or anything of that nature, no.
Did Dr. Welcher conduct any testing to determine whether the damage to Ms. Reed's Lexus was consistent with the striking of an arm of a pedestrian?
I'm not aware of any impact testing that he did, no.
Did Dr. Welcher conduct any testing to determine the forces necessary to cause the damage to the taillight of Ms. Reed's vehicle?
Not that I'm aware of, no.
Did Dr. Welcher conduct any testing to determine the forces necessary to cause the injuries to John O'Keefe's arm?
No, not that I'm aware of.
Did Dr. Welcher provide any opinions as it relates to the speed of the subject Lexus at the time of the alleged incident?
No, from reviewing his report and his PowerPoint and analysis, I could not find anywhere in it a specified speed or even a range of speeds.
Did Dr. Welcher provide any opinion as it relates to the forces experienced by the taillight in such an impact?
Not that I'm aware of, no.
Did Dr. Welcher provide any opinion at all as it relates to the post-impact trajectory or movement, if you will, of John O'Keefe's mass or his body subsequent to the alleged conduct?
No, not that I'm aware of.
Next slide, please. Do you recognize this photograph?
Yes.
What is this?
So this is something that you probably have heard and certainly I've discussed already, but this is looking at the right rear corner of the subject Lexus, specifically in the area of the damaged right taillight.
Did you consider this photograph in coming to your opinions and conclusions?
Yes.
What, if anything, of significance did you note about this taillight, other than the fact that it's damaged?
Well, I'm going to jump to the next slide, if you will. So this is now the taillight obviously has been removed from the vehicle. So obviously what's important here is looking at what is the damage that we have to this taillight. What components were damaged in this alleged interaction. So we're looking at the clear diffuser at the bottom is fractured and missing. Same with the ones on the vertical side. The majority of the outer red lens is also missing and fractured. And then on the back side, we also have some damage in terms of some fracturing to that black plastic, and there's also a chunk of plastic missing on the top portion of the taillight as well.
I want to ask you a couple of questions about that diffuser. If you could focus your attention on this area. Describe for the jurors what they're looking at in terms of the diffuser. What is the diffuser?
Right, let me see if this. So the diffusers, right where my mouse is, there's a clear diffuser that runs along the bottom, and then there's another diffuser that runs along here, and then it also goes up vertically. Same here on the bottom one, that also goes up vertically. So this piece was missing and fractured on the bottom, along with the vertical portion. The chrome piece here you can see is also fractured and damaged, and then the kind of the second tier, if you will, that clear diffuser was also fractured and broken on the upper section as well.
Was that of significance to you in your review of the damage to the taillight?
Yes.
Why?
Well, because that tells me that we have to have enough force and energy to break, we talked about earlier that 5mm thick red outer lens. We have to have enough force to be able to get beyond that to now start penetrating into the interior components of the taillight to get to, again, those clear diffusers and certainly cause damage to get induced out the back end of the taillight as well.
May I have just a moment?
Yes.
Dr. Wolf, did you bring with you an undamaged taillight exemplar?
Yes. It's up here with me.
It's up there. Oh, I was just looking for it.
Yep.
Thanks for nothing. Describe what it is that you brought with you.
So I brought a two-part assembly. So what I did is I 3D printed a bracket so that I could mount the lift gate taillight assembly as well as the quarter panel taillight assembly.
And these are undamaged in sort of manufacturing specs, correct?
Correct, yes.
May I have just a moment, Your Honor?
Okay.
You have it with you up there at the witness stand?
Yes.
Could you retrieve that with the court's permission?
Okay.
If you could remain standing for just a quick second. Do you recognize what that is?
Yes.
Is that what you just described?
Correct, yes.
Describe it one more time for the court and the jury. What is it that we're looking at right here?
So this is an exemplar set of taillights from a 2021 Lexus LX570. On my left side here, this is the lift gate taillight assembly, and it's attached to the quarter panel taillight assembly. And I will note it's not normally like that. Obviously, you can't have a connector, else you wouldn't be able to open the lift gate. But I've printed a bracket back here so that these can remain as one unit.
Your Honor, with the court's permission, I'd like to have that marked as next in order.
Is that coming into evidence?
Yes, if possible.
Is that okay?
Okay.
Okay. So how?
May I approach?
Yes.
This might be clunky. Thank you. If we just have the tag perhaps put it somewhere on the maybe the lift gate side.
And is Dr. Wolf going to use it for his testimony now?
He is.
Okay,
Very
so
briefly.
give it back over there, please, Chrissy. Just give it to him when you're done. Thank you.
Is it 250?
Thank you. If I may, Doctor.
Yes.
May I?
Okay.
Thank you. Dr. Wolf, you indicated that there was a 5 mm area of acrylic covering the diffusers, correct?
Correct.
What I'm knocking on, is that the 5 mm acrylic?
Yes, both on the quarter panel part that you just pointed to, as well as the liftgate part.
Mr.
Those are-
Jackson, why don't we give that back to the witness and let him do it instead of you?
Sure. Is there, can you see through that loose material into the diffuser that you've just been describing?
Yes, so as I mentioned earlier, in this area here, there's a diffuser that's running along the bottom.
So, Dr. Wolf, I'm going to ask you to not have that so close to
Oh,
court reporters.
my apologies.
Use the other side. of
Don't
the
smack her in the
Yes, Your
head.
Honor. So
gonna roll
along
her
the
eyes.
bottom is the clear diffuser that runs along and then goes up vertically. And then on the second tier, there's also a clear diffuser that runs along here and then goes up vertically. And you might be able to see it through, it kind of looks like there's little dots on it. So that's what I'm referring to in terms of the diffuser that's underneath. And that, again, so you have that outer material that's 5 mm roughly in thickness. And then those diffusers are about 3 mm in thickness underneath this.
Could you make a determination, and you can go ahead and have a seat. Well, actually, you may not want to. Could you make a determination of the space, the gap between the outer plasticine area, the outer acrylic area, and the internal diffusers? If you could just estimate that gap.
If I had to estimate, I'd probably estimate around an inch, maybe inch and a half.
Okay. You indicated that something was of significance to you in this photograph about the diffusers on the subject taillight, correct?
Correct.
Describe, now that you're holding that, what was it that was of note to you, Dr. Wolf?
So as I mentioned, we have damage not only to this outer thick portion, but it was enough force and energy to then penetrate deep enough to fracture the underlying diffusers that sit below this outer surface, and certainly enough force then to work its way back through inducement into the backside, and ultimately there was a top portion of the taillight that was also fractured up here.
Was all that significant to you in your review of the subject taillight material?
Yes.
Okay, you can go ahead and put that away.
All right, so that can't go back there because it's in evidence. So why don't you take it and... Mr.
I was
McDermott.
just going to store it there until he's finished with his testimony, and then we can give it to the clerk magistrate.
Okay.
However you want to do it, Your Honor.
All right.
I have
Do
no
you wanna take
preference.
it? Is he using it still for his testimony?
Not right now.
All right, so, thanks, Jim.
You make a big deal out of bullshit, Bev.
Thank you, Your Honor.
Yeah,
Okay.
she's something, all right.
It's fucking psycho.
May I continue?
Yes.
Can we go to the next slide? What are we looking at here?
This is a collection of photographs that depict various fragments from the right rear tail lamp assembly of the Lexus. And I will note that, and I'll try to spotlight it, there are a few fragments in this photograph that are glass fragments, which, as I discussed earlier, there's no glass in the taillight, so these did not originate from the assembly. But altogether, from what I recall, there's about 50 fragments, I believe, that were counted or so, maybe a little less than that from the right taillight.
If we could go to the next slide, please. What are we looking at here?
So these are photographs depicting the sweatshirt or hoodie that Mr. John O'Keefe was wearing on the night of the alleged incident.
And what was the role that this played in your analysis, ultimately?
Well, so one of the things that I noted, and I can go to the next slide, is there were a series of small punctures or holes in the sleeve, on the right sleeve of the sweatshirt in varying sizes. I think some as small as just a few millimeters. Again, I think there was maybe 10 or 12, I think I recall, on the right sleeve of that sweatshirt.
If we could go back to the larger photo, the previous slide. Do you see the right sleeve denoted on the photograph to the right?
Yes.
Your review of these photographs, what was the significance of the triangular sort of arrows or markers?
I believe those were to annotate or draw attention to those holes.
Okay, the defects in the right sleeve?
Correct.
Can you count those for us, please?
On the photograph on the right, I believe I see a total of 9.
And what about the photograph on the left, just the right sleeve area?
9 as well.
If we can go to the next slide. What are the arrows pointing to in these photographs?
So this is basically the previous shot, but what appears to be close-ups of some of those evidence markers.
You indicated some of the sizes. What were some of the smaller sizes of those defects or holes?
From what I recall, like I said, I think it was around 3 to 5 millimeters, maybe some of the smaller ones.
How big is 3 millimeters in inches?
It'd be probably around like an 1/8 of an inch or so.
Can we go to the next slide, please? What are you describing when you say the word fundamental, or do you write the word fundamentals?
So I want to discuss some very basic concepts that I hope will kind of resonate as we go through the PowerPoint so that you have an understanding of the underlying physics and what I'm talking about.
Can you go ahead and describe the role of an accident reconstructionist and the fundamentals that an accident reconstructionist undertakes when performing the kind of testing that you performed? So,
as I mentioned earlier, when I was describing what a simple definition of accident reconstruction is, it's the application of physics and engineering to collision events. So I want to go through some very basic elements of that so that you have an understanding of the physics.
Can we go to the next slide, please? What are we looking at here?
So this might be something you all remember back from high school physics, but even though it's been around since the late 1600s, we still use these laws today. So what we're looking at here is what I've done is just describe Newton's laws very simply. So, and again, you might be familiar with these. So, for instance, if we're talking about Newton's first law, an object at rest tends to stay at rest and at a constant speed unless it's acted on by an outside force, right? So if my arm is just here, right, it's just going to stay there until I give it a push or a pull, right? When I do that, that's going to induce an acceleration, right? So that's when we get into Newton's law, where if I apply a force to a mass, I'm going to cause it to change its speed. It's going to accelerate. And then Newton's third law, basically the law of reaction, indicates that when I push on my arm, there's also an equal and opposite force going back to my hand that I'm pushing with.
What role did these three very fundamental laws of physics play in your reconstruction or your ultimate opinions and conclusions following your accident reconstruction in this case?
So when we're talking about the concept of acceleration, what you will see in the dynamic test that we did and conducted, we measured the acceleration of an arm when it's impacted by a taillight. If we know the mass of the arm and we've measured the acceleration, we can use Newton's second law, which is force is equal to mass times the acceleration, to calculate what that force is applied on the arm, which ultimately you will hear from my colleague, Dr. Rentschler, to talk about that.
Is that broadly considered a force analysis?
Yes.
What role did force analysis, your force analysis, play in the accident reconstruction that you did or you undertook in this case?
Well, there's certainly going to be a correlation between the impact speed and the damage that we see. The higher the impact speed, the greater the force. So from my perspective, I was interested in the speed and the force to look at what's the observed damage to the test taillights that we did.
Do you think that's fundamental to an accident reconstruction?
Yes.
Did Dr. Welcher engage in any force analysis with regard to John O'Keefe's arm and the taillight?
Not that I'm aware of, no.
Let's move to the next slide, please. What are we looking at here?
So don't be too afraid. This is some really simple equations that I want to show you. So that first one, delta V. So what do I mean by that? That simply just means you can think of delta, change in. So change in velocity. So if you look at that equation, the change in velocity, really simple. If I've got an object that's, let's say it's initially, for what V naught is, initially at 0 miles per hour, I hit it, and it's now moving 10 miles per hour. That means it underwent a change in speed of 10 miles an hour and is moving at that velocity. Acceleration is essentially how quickly did that velocity change occur, right? Did it go from 10 miles an hour in a split second, or did it go to 10 miles an hour over a few seconds? So depending on the timing of that, how quickly that change in velocity occurred will determine what the acceleration is. And as I've already mentioned on the previous slide with Newton's second law, we can then take that information about acceleration and apply it to, if we have a known mass, to calculate what the force on that object is.
How did these math equations, delta V, acceleration, force, how did these play into, what role did they play in terms of the accident reconstruction here, in this case?
Well, they're extremely fundamental. And I think as we go through the PowerPoint, you will have an appreciation and understanding of what these concepts are. You'll see that I have plotted graphs with acceleration that shows the rate in that change in speed over time. You will see graphs of delta V, so the change in speed of the arm as it's being impacted by the taillight. And then ultimately we can calculate the force of that impact to be able to assess whether or not there's a mechanism for the injuries. And as I mentioned, that'll be my colleague, Dr. Rentschler, that will discuss that.
Can I ask you about delta V specifically? I'd like to focus on that for a second. Is that okay?
Yes.
When you say that that equation suggests or dictates that an object that is struck by another object with mass moves up to the same speed of the object that struck it, describe that in a little bit more detail in colloquial terms, if you will. 6th grade terms.
I'm sorry, can you rephrase the question?
Probably not, because I don't understand it as well as you. If an object, does delta V describe the circumstance in which you have an object that may be at rest and it's struck by another object moving? Is that calculating the speed at which the object that has struck moves to the same speed as the object that struck it?
So that's sustained. Just ask him a simple question, let him answer.
Easier said than done. Sure. Can you describe in more conversational terms what delta V is describing in terms of mathematics?
Right. So let's just give an example specific to this case. If the majority of the arm is struck by a 6,000-pound vehicle moving, let's say, at 20 miles an hour, that arm will experience a change in speed. It'll go from 0 up to about 20 miles per hour due to that impact. So that would be the change in speed. If my arm is at rest, stationary, is impacted by a 6,000-pound vehicle, it's going to change its speed up to roughly what that impact speed is.
And what about acceleration? What are you describing, or what is math or physics describing in that equation in terms of the time it takes for that arm to now move from 0 to 20?
Right, so that's how quickly that change in speed is occurring. So to give you maybe an example you're more familiar with, let's say you're driving down the road, you come up, you see a red light at the intersection, right? You're going to get on the brakes lightly, and your vehicle is going to change in speed, right? It's going to slowly decelerate. Let's say you're driving and a deer jumps out in front of you, you got to slam on the brakes, right? You're going to change your speed much quicker. So that's an example of two different rates of acceleration. One where you're mildly braking, right? You're going to coast down slowly, versus a sudden, emergency in front of you like a deer. You're going to slam on the brakes, and your speed change is going to be it's going to happen much quicker with that acceleration rate.
Are there circumstances in which the acceleration can be from 0 to, say, 20 miles an hour in milliseconds?
Yes, when we're talking about impact durations, especially of this nature, yes, they're not going to be, we're not talking about the impact occurring over a second, 2 seconds. That's extremely long. Even a duration of a couple hundred milliseconds in the context of this is considered long.
And then, of course, the force calculation is associated with the delta V and the acceleration calculations. Is that right?
Correct, yes.
In what way? What are we looking at in terms of that a little bit more complex calculation?
Absolutely. So if you look at the bottom equation there where I have force is equal to mass, and then that top component is the change in speed, right? That delta V, V1 minus V naught, divided by the change in time, T1 minus T naught. So if you substitute in that equation, right, that's delta V over delta T, which is acceleration. So there's a relationship between all of these equations.
And do all of these equations, or did all of these equations assist you in coming to determinations and opinions and conclusions concerning this case?
Yes.
Are these normally accepted methodologies in determining delta V, acceleration, force, all the force dynamics or impact dynamics in an accident reconstruction?
Absolutely. They are the core of physics.
Can we go to the next slide, please? What are we looking at here? Scientific method. What does that mean?
So the scientific method is a process that scientists typically use to be able to reach conclusions. And so you can think about it in this case, we make an observation, right? We have injuries to the arm. We've got a damaged taillight. So let's try to do some research to figure out, okay, has anyone done testing with that, right? Has anyone hit an arm with the taillight, see what happens, see what the forces are, right? And then we start to make a hypothesis, right? So what happens, it's kind of an if-then statement. If the arm contacts the taillight, does the taillight break? Does it not break, right? What's the hypothesis there? And at least my understanding of reviewing Dr. Welcher's work, it appeared to be that his hypothesis...
Sustained. Next question.
Sure. Did you review, well, let me ask a different question. Going back to the calculations previously, the delta V, the acceleration, the force calculations that you described to the jury, did you see anywhere in any of Dr. Welcher's reports or his data that he undertook those core calculations?
No.
With regard to the scientific method, did you see whether or not Dr. Welcher followed this scientific method as you're explaining it to the jury?
Sustained.
What did you note, or what opinions or conclusions did you come to about the scientific method, if any, that Dr. Welcher did or did not undertake?
Sustained.
Did you review Dr. Welcher's entire database? In other words, all the reports, all the raw data, and his PowerPoint?
Yes.
Did he undertake the scientific method as you know it?
Right, so that's sustained.
Continue to describe the scientific method as you know it and you employ it.
Certainly. So, again, from reviewing Dr. Welcher's report, he indicated...
It's sustained. I'm going to see you at sidebar.
I had to go to the restroom, if I can get my word out. Are they at a sidebar?
Yeah.
Okay, that's what I thought. Goodness gracious. It took a minute to get to the next sidebar, though, guys. We might be on a roll here.
I don't know. She's putting in as much work as the prosecution on,
Yeah,
these objections and whatnot.
it's insane. I don't even know what to think about this woman. She's worried about frivolous things. No one's gonna run off with the taillight lady. It's fine. Y'all, are Elon and Trump fighting with each other?
Yes, they are.
Apparently they are. It's like we knew it was a matter of time.
I just found that out last night. I saw a timeline of the spat on
Yeah,
CNN.
I saw it last night too. I was like, what?
Because I haven't been checking in.
Yeah, me neither. I don't even, them fools. Oh my God.
Hmm.
Right. And then I saw that. I was like, man, it's all over with now, but the crying folks.
Oh, did this download everything? Oh, yeah. Mm.
Dr. Wolf, may I inquire, Your Honor?
Yes.
Dr. Wolf, where are we on the chart? I've lost my place.
I think hypothesis.
Okay. Let's describe, if you would, please, what role hypothesis plays in the general scientific method.
So generally, it's like I said, it's an if-then statement. So if you make a statement, if the arm contacts the taillight, then the taillight will shatter, right? So you want to do tests and experimentation and analyze that data to see whether you can accept or reject that hypothesis.
And what's the next stage?
So as I mentioned, after hypothesis, it's once you've determined that, what your hypothesis is, you want to test with experimentation, analyze that data, and that certainly may be an iterative process that you do multiple times to then be able to draw a conclusion from that analysis and testing.
What's the next stage?
To basically report those conclusions and findings.
Why is it important to report those conclusions and findings?
Well, I think so that you can, whether you can accept or reject the hypothesis that was put forward earlier.
Do you have to analyze the data following the testing that you undertake?
Yes, like I mentioned, I think it's an iterative process, because certainly you could do one test and it may not be clear what the answer is at that point, so you may have to do additional tests to basically parametrically evaluate your hypothesis.
Did you see this well, let me ask you first, did you undertake this scientific method with regard to your reconstruction or your testing in this case?
Yes.
Did you observe this same scenario in Dr. Welch's report?
Sustained as to that point, Mr. Jackson.
Did you see this undertaken anywhere else?
Sustained there.
Did you look for testing in Dr. Welcher's evaluation, all of his data?
Yes.
Did you find any,
No.
other than the static blue paint test?
That was the only test, correct.
Did you see any force dynamics testing?
That's leading, so you can
Sure.
get to it without that.
What about any other testing? Anything else that we've talked about? Do you see anything else done in Dr. Welcher's
As it
report?
pertains to an analysis to the taillight and the damage and the forces, no.
Let's move on to the next slide. Did you actually undertake testing in furtherance of the scientific method?
Yes.
Let's move on to the next slide and you can describe what we're talking about. What are we looking at here?
So you're looking at a test matrix of the various tests that we conducted at ARCA. I could go through them one by one if you want.
Let me ask you foundationally, was your testing directed toward determining whether or not the scenario proposed in Dr. Welcher's report was consistent or inconsistent with what you would find, ultimately?
The objection sustained.
Was your testing specifically designed to determine whether the damage to Miss Reed's vehicle, her Lexus, was consistent with the scenario that was proposed by Dr. Welcher?
Yes.
That's sustained too. Ask it differently, Mr. Jackson.
What was your testing? What were you engaged in terms of your testing? What were you trying to find out?
Well, I think it was to, again, we talked about earlier about that hypothesis, right? My understanding, Dr. Welcher indicated that the arm contacted the taillight, but there was no analysis or testing to determine what's the expected outcome of that. What's the damage to the taillight?
So you answered the first question. I'm striking that second part. Ask another question.
Was there anything else?
I think simply put, it's to find out what happens when you impact an arm with a Lexus taillight at various speeds. What happens?
What was your understanding of Dr. Welcher's hypothesis?
That's sustained.
Did you have an understanding of Dr. Welcher's hypothesis?
That's sustained too.
Ultimately, what were you trying to find out through your testing?
As I mentioned, I think it was to determine when you impact a taillight at 10 miles an hour, 15 miles an hour, 25 miles an hour, what happens to the taillight? What's the expected damage? What happens to a sweatshirt when it makes contact with that? What happens to the fragments? How does the arm move? What's the acceleration of the arm? What's the change in speed of the arm? And certainly, as I mentioned, my colleague Dr. Rentschler will discuss what are the expected injuries in that type of impact.
Did you see any of those questions answered in Dr. Welcher's report?
Yes.
Ask it differently.
What did you see in terms of Dr. Welcher's report as it relates to those types of questions?
That's sustained.
Ultimately, did you undertake a methodology to perform the testing to answer the questions that you just explained needed to be answered for this jury?
Yes.
Describe that, please.
So we started out, we kind of worked at this incrementally, right? We didn't start right off the bat with utilizing an exemplar Lexus going right into an ATD or a test dummy, right? We wanted to start in the laboratory to have an understanding what happens at a range of speeds, in this instance, in our first two tests, between 10 and 17 miles per hour, right? What happens, what kind of damage do we observe, right? At 10 miles an hour, do we even break the light? At 17, what kind of damage do we get? What kind of accelerations do we get? And then we moved up to full-scale vehicle impact testing.
Is that methodology that you just described generally accepted in the field of accident reconstruction, in the broader field of engineering?
Absolutely. Everything from utilizing an instrumented test dummy to using an exemplar vehicle to all the data acquisition systems that we had in the laboratory as well as the vehicle. All of that is generally accepted techniques in the field of accident reconstruction to evaluate what we did in this case.
And are those techniques also supported by peer-reviewed articles in scientific literature related to accident reconstruction?
Yes.
Did you rely on this methodology that you just described to render opinions and conclusions as it relates to this case?
Yes.
Have you relied on that same methodology in rendering opinions and conclusions in other courts?
Yes.
Let's go to the next slide, please. What are we looking at here?
So we've gone over this before, but this is looking at the exemplar vehicle that we utilize for the latter part of our testing. You're looking at again, just annotating where the liftgate taillight is as well as the quarter panel taillight.
When you say exemplar vehicle, what is this SUV that we're looking at?
So it's the same year, make, and model of the subject vehicle. So it's a 2021 Lexus LX 570. So it's the same weight, same geometry, same as the subject vehicle.
Is this a picture off the internet, or do you actually have access to this truck?
We have access to that vehicle, yes.
And ultimately, what testing did you undertake specifically as it relates to this particular vehicle?
We did full-scale vehicle testing with the vehicle driving into an ATD arm as well as an ATD arm attached to a dummy and then a full-on impact to a test dummy.
Did you assess the damage to the right tail light after these various tests?
Yes, after all of the tests.
Did you assess the acceleration and quantify the forces that were involved?
Yes.
Did you assess the material and textile damage to the clothed ATD?
Yes.
Ultimately, did you conduct lab tests in an effort to answer some of these questions as well?
Yes.
And you've already mentioned this, but you utilized in your testing the exemplar vehicle to the fullest extent that you felt necessary?
Absolutely,
Were
yes.
you hampered or hindered in any way in terms of damaging the vehicle or utilizing the vehicle in any way that you wished?
No.
Let's go to the next slide, please. What are tests A and B? What are those laboratory tests?
So these were the initial two tests that we did to get an idea of starting to test this hypothesis. As I mentioned, we weren't sure at 10 miles an hour what would happen to the taillight. We wanted to see what would happen at 17 miles an hour with the arm. So again, it was to evaluate from a starting point what happens in this interaction based upon how Dr. Welcher had his arm oriented in his PowerPoint and analysis.
Next slide, please. What is this?
So you're looking at a photograph of our lab setup. You can see on the left side of that is our Hybrid 3 anthropomorphic test device. To the right is a linear impactor, and this is something we already have in-house that we built years ago for our testing that we do for the National Hockey League when we're looking at, what's the accelerations on an impact to a goalie wearing a helmet, right? We use this same device for that type of testing to measure head acceleration. So we applied this same linear impactor to be able to project, if you will, or accelerate the tail light at a known speed into the ATD arm.
What are some of the instrumentation that you use in addition to the mechanical impactor? What's some of the instrumentation you use to track the data?
Certainly. So you could see, I'll get my, see where I'm here. So at the top here, there's a blue camera here. There's another blue camera here. So these are our high-speed cameras. And you'll see there's a bunch of lights around those high speeds. That's just because the frame rate's so high. And again, it's only sampling a very, very short amount of time. So you have to have a lot of light when you do these high-speed tests. So we have the high-speed cameras running. We have an accelerometer mounted to the ATD arm here on the other side. So that's some of the instrumentation. There's also a couple other cameras that we're documenting this overall.
Can we move to the next slide, please? What are we looking at in these photographs? So this is looking at, and not to be confused, this wasn't the arm position when the impact occurred. This is just showing you the setup. So on the left is just kind of an overall shot, and then on the right is, right here, is a uniaxial accelerometer. So that's going to measure, we talked about that term earlier, right, the acceleration. So that's going to measure how quickly is this arm changing its speed, right? What's the acceleration of the arm as it's impacted? Does that accelerometer put into motion some of the mathematical formulations that you talked about earlier? Yes. Let's move to the next slide, please. Tell me about these photographs. So the importance of this is, more specifically looking at the right photograph here, might be a little bit hard to see, but we wanted to get the same exact sweatshirt or hoodie for the testing to evaluate if the taillight breaks, is there a mechanism for the fragments to penetrate and cause holes in the sweatshirt as were observed in Mr. John O'Keefe's sweatshirt? Next slide. Were you successful in finding the exact replica sweatshirt? Yes, and I will note, as I mentioned, I know it probably is hard to see, but the material blend on the sleeves are the exact same. They are 60% cotton and 40% polyester. Was it important in your mind to maintain consistency with the data that you had received concerning John O'Keefe's clothing? Certainly. I think we wanted to try to control as many variables as we could. Let's move to the next slide, please. Test A. Describe Test A for us, please. So you're going to see a series of photographs and then videos
But test A was mounting a preconditioned taillight on that linear impactor to accelerate it into the hybrid 3 arm to, again, evaluate the damage to the taillight and the acceleration to the arm.
Let's move to the next slide, please. What are we looking at in these photographs?
So you're looking on the left, a photograph just before the impact test was conducted. On the right, you're looking at a thermal image that is depicting the temperature profile of the taillight.
Describe that thermal image.
Certainly. Your Honor, may I refer to my notes?
Yes.
So what I did is I analyzed the profile of the temperature down in this area. And when we look at that segment, that lower portion here, where contact was made, the average temperature in that area was about 34 degrees with a minimum of about 33 degrees.
How did you get that exemplar taillight down to around freezing?
So all of the taillights that we tested were preconditioned overnight in a freezer.
Why was that important?
Well, it's my understanding that at the time that this allegedly occurred, the ambient temperature was 31 degrees Fahrenheit. So, as I mentioned earlier, certainly there's a correlation between how plastics perform in cold weather. So we wanted to take that variable into account in our testing to precondition them down to temperatures that were consistent with at the time of the alleged incident.
Next slide, please. What are we looking at in this slide, on this photograph?
So this is a video. Do you want me to go ahead and play the video?
Tell us what we're about to see, and then I'll ask the court's permission.
So you were looking at a camera that is mounted above the entire setup. If you look at the top portion of this video, you will see the tail light. Part of it's covered by the high-speed camera. But what will happen is the linear impactor will fire, and the tail light will be accelerated up to 10 miles per hour, striking the clothed ATD arm.
With the court's permission,
Okay.
let's go ahead and play the video. Next slide, please. What is this?
So this is also a video, but with the high-speed camera. So it's the high-speed camera that's looking top down at the arm. So you will see when the video plays, you will see the tail light enter from the left and contact the arm. And I will note that this is essentially slow mode, so it's not happening in real time. So you'll see the tail light slowly moving, but it's actually in reality moving at 10 miles per hour.
Understood. Go ahead and play that. Can I ask a question now that that's played? How did you mount the taillight to the accelerator, that linear accelerator?
Right. So we had to get a little bit creative there because you may have observed this when we had the physical assembly out earlier. The back of that, it's not some nice clean surface that we can just bolt on. So what we had to do is 3D print a bracket that we could bolt onto the linear impactor, and we used a polyurethane expanding foam to be able to marry those two together so that we could then bolt it onto the linear impactor to use it for this test.
Did you see any debris from that foam mounting mechanism?
Yes, there's a few flakes you can see of that polyurethane foam off the backside kind of going into being dispersed there.
Okay. With regard to this particular 10-mile-an-hour test, what did you note in terms of the damage to the taillight?
It was very minimal.
And what did you note in terms of any damage at all to the hoodie?
There was none.
We go to the next slide, please. What are we looking at in this slide?
So this is looking at a side view. So same test, just looking at it from the side. And similarly, you'll see the tail light come from the left and impact the arm.
If we could play this, please. What did you note in terms of deflection of the arm, the test arm?
Well, the arm essentially, and we'll see this in the data later, it reaches a common velocity with the tail light based upon portion of the arm that was contacted, again, consistent with how Dr. Welcher has it oriented, it will become accelerated up to 10 miles an hour roughly.
Over approximately what period of time is that arm accelerated up to 10 miles an hour along with the taillight?
We'll see it on the data plots. I think it's about 10 milliseconds or so.
How long, do you know how long an eye blink on average takes?
Off the top of my head, no, I don't. Probably pretty quick.
Somewhere around 250 milliseconds? Does that sound right?
Sustained.
Let's move to the next slide, please. What are we looking at in this series of photographs?
So these are extracted frames from the high-speed video that we just saw on the previous slide, basically showing just at contact, just after contact, and then post-contact, so you can see the kinematics of the arm and how the arm is moving.
Okay. Let's move to the next slide, please. What is this photograph?
So this is photographs taken of the taillight after the 10-mile-an-hour test. I will note that there was a couple small fragments of the clear portion of the assembly, the outer lens that was missing from that turn signal area towards the left here. There was a couple fragments missing, and then there was some small fracturing here in that area.
How would you describe the damage to the taillight at the 10-mile-an-hour test?
If I may go to the next slide, I think it might.
Sure.
So this was the totality of that damage at 10 miles per hour. So I would describe it as minimal and superficial.
Okay. Next slide, please. What is this?
So this is the photograph that I just shown you compared to that of the subject taillight, so that you can have a side-by-side comparison of the test taillight compared to that of the subject.
Were you able to reach any opinions and conclusions about whether the damage to the subject taillight is consistent with striking an arm at 10 miles an hour?
It's inconsistent, in my opinion.
Next slide, please. This is still test A, is that correct?
Correct.
Were you able to reach any opinions or conclusions as to whether or not the damage to Mr. O'Keefe's clothing is consistent with being struck by the taillight at 10 miles per hour?
What I observed from the test is that there was no mechanism to create any of the holes that we observed on the subject sweatshirt.
Do you hold that opinion to a reasonable degree of scientific certainty?
Yes.
As well as the former opinion that you just gave us?
Yes.
Next slide, please. What are we looking at in this graph?
So this is a graph that shows the roughly, on the next graph you're going to see a 24 millisecond window. So what I want to show you on this graph is what does that look like over a full second, so you can have an appreciation of just how quickly this is occurring. As you mentioned earlier, I think your comment about a blink of an eye, this is even shorter than that. We're looking at, as you'll see on the next graph, again, it spans over just a few milliseconds. So that yellow tick that you see in the middle there, what I've done is I've plotted that over a full second. So 1 second is equal to 1,000 milliseconds. So if we go 500 milliseconds to the right, 500 milliseconds to the left, this whole graph represents 1 second in time. This impact duration is occurring very quickly.
1 second, is that reflected from the beginning of the graph to the end of the graph? That's representative of 1 second, is that right?
Correct. So starting at this y-axis all the way to here is 1 second in time, with our impact duration happening over just a few milliseconds.
And this was at 10 miles an hour?
Yes.
Next slide, please. What are we looking at in this graph?
So we're looking at the acceleration or the change in speed over time, that parameter that we discussed earlier. So what you can see is that as the arm is impacted, we had the accelerometer mounted on the inside portion of the forearm, if you will. You see that it starts to accelerate, right? Because it's changing its speed, and then it starts to level off after the impact has subsided, basically, and it's reached a common velocity.
What do we see in terms of the G-forces that the arm is subject to?
So the peak is occurring right around here at about, looks like just over 6 milliseconds. And the peak acceleration is just over 130 Gs.
And what does that mean? What is a G?
So a G is acceleration due to gravity. So if we're being held down by 1 G, so you could think of it as basically a multiplication factor, that it's 131 times the acceleration due to gravity.
And the next slide, please. What are we looking at in this slide?
So this is, again, that concept that we talked about earlier, delta V. This is the change in speed. So if we do some math to the previous data that we collected, it's a technique called integration, but we can actually add up all of that acceleration to determine what speed did the arm get up to. And when we do that calculation to this data, what we see is that initially at the impact, right, the arm's at rest, right, Newton's law, first law. And then we impart a force on it in terms of the tail light impacting it. It's going to cause the arm to accelerate and change its speed. So as I noted earlier, it's essentially going to reach a common velocity with the impact force based upon how Dr. Welcher has the arm oriented. And we can see that it's a tick over 10 miles per hour at just over 10 milliseconds. So that means that the arm in a 10 millisecond period is going from 0 up to about 10 miles per hour, which was the speed of the impact.
And 131 times the force of gravity is exerted on the arm at the same time?
Sustained is to that point.
Where does gravity play into this? What is the 131 Gs? Where's that force exerted?
So that is the acceleration that the arm experienced as a result of that impact. So that's how quickly it was changing in speed.
Understood. Let's go to the next slide.
So is this a good place to take the morning recess? All right, folks, we'll take a recess. Dr. Wolf, you can file our jurors. I'm going to see counsel regarding just scheduling, please.
All rise for the court, please.
We knew it was time for that morning break. Y'all get over there and get your scheduling conducted. It's refreshing to finally see some actual work in this case that makes sense. He is far more impressive than Dr. Welcher, right? I mean, far more impressive. And you can put their two tests side by side and see the vast difference in that. Oh my goodness. Oh, Jesse. I got him on silenced already. I had one-upped him. It's not getting me today, sir. Okay. There we go. Let me pull this up. Let's see. I don't think I have to ask, but do you guys feel more inclined to believe the ARCA guy over Welcher? Dr. Wolf or Welcher? My money's on Wolf right now. Okay, let's see. Rachel just said the credibility here isn't even comparable, right? Yeah, you can see why. Exactly. Hank didn't want him, and now you can see why. But he's going to try to make a big deal over Dr. Wolf seeing things on the news and contacting the defense. So what? You're just mad because they didn't agree with your Dr. Welcher. That's the only problem there. You didn't agree with Welcher, so we can't use him. Joe reported like 5 minutes ago that I think they're going to start early today in Lori Vallow over there at 9:30 versus their usual 10:30. It's only 8 a.m. over there right now, so it's still going to be a little while before any action over there in Lori's case. The amount of testing and all the controlled environment and the setting that they were, even down to freezing and bringing the taillight lens into the temperature at the time of the accident. All of these things that you should absolutely do in testing, Welcher didn't. They just got some blue paint out and went out there and recreated what the state told them happened. Oh, let's go recreate that real quick. And there was no actual testing done, right? And it just didn't make any sense to a lot of us. Yeah, Wolf. He makes a lot more sense explaining his everything, from the way they did their controlled testing, the variables, all the things they took into account, all of the reports, all of it is so much better. And the fact that the feds have hired them, and I also like the fact that they've done testing for the hockey league, velocity and impact testing. That's a lot, you know. They're far more experienced than a couple of guys at the insurance office who recreate accidents on the daily to help out insurance companies, right? Can't forget that part. I won't anyway. Yeah, Rachel, they brought all that out in testimony this morning about how they were working for the other agency, and then how Dr. Wolf saw things on the news, and then he reached out to the defense to talk about his findings. The defense had no idea that he had done any testing at all at that point for the feds, right? That's what they were saying in court this morning. I'm sure Hank will have different things to say about that, but your word against mine. I have a little humidity today here, and I just got a cold. Can y'all believe that? I'm monitoring the feed on the side still. They're going to be gone for they usually take about a 15-minute break or so in the mornings. So I'm thinking they're going to call the other because there were two of the reconstruction guys that worked this case. Or what's his name? Retchler? Is that how they say his name? So he'll come in and talk about other aspects. I think they both testified first trial. No, I don't have a cold, hun. I got cold sitting here. I had the window open a little bit, and I just like, what happened? I like looked to see if it got all cloudy all of a sudden because I started feeling cold. I think my thyroid medicines need to be adjusted. That's usually the culprit. I shouldn't be cold right now. It's warm in Florida. It's usually my first indication something's amiss. So that if you guys were watching Lori's trial, she yesterday before they started the trial, she did file a 10-1 motion again trying to get the judge removed from the case, and it went back before the judge who decided the other day not to recuse him. And she said there's nothing there, that Lori is not entitled to have Boreski removed. There's nothing there prejudiced against her, because she was mad because she said he, granted her the order to have communications with her assistant counsel during lunch, and she claimed that only happened like 5 minutes yesterday, and she was big mad about that.
Oh boy.
Yeah, she was so mad about that, wanted him recused again, and had to go back before the other judge, and she's like, nah, that's not happening, lady. Oh goodness, did JLR run amok with that new information and the Koberger stuff and call it what it wasn't? Why are people all mad at him all of it? I don't even watch that guy. I couldn't tell you anything he has said or done lately. Maybe I think he blocked me a long, long time ago. Even after using my shit in his videos and pointing out my comments that he liked, he goes and blocks me. I'm like, dude, why you do that for? Your girlfriend didn't block me. She likes me.
Who's his girlfriend?
Magnolia.
Oh, okay.
Yeah.
Mm.
He blocked me a god a long time ago on one of my accounts. Little does he know.
Hmm.
Dummy. Oh, he done put a picture out of the professor. Oh goodness.
Oh, wait, let me look.
It's on the Twitter. That
Oh,
place that place you don't ever venture off into.
yeah. Um,
I don't it's like 15 hours ago I see a post where he posted about the new subpoenas, but I don't see that he
hmm
has said anything like outrageous about it yet. I don't know. Maybe he went live and said stuff about it, right?
Could have. Let's see. Oh, I see.
Oh gosh, now he's done posted a photo of the other lady. Wow, the teacher. Oh, I just found out who the Vicio guy is, though, according to JLR. So there was a guy that's listed on this. We'll take a look at this subpoena. I don't want to get into him until lunchtime, but the one of the subpoenas is for a guy named Ralph Vicio, and that's going to be in the document. But he is apparently the president of Colonial Auto Sales. He sold Koberger his Elantra.
Mm.
I gotta write that down and do my own research. I gotta do my own research. I can't even take what JLR says to the fucking bank. God Lord, y'all shouldn't. It's been a hot minute since he's wreaked havoc anywhere that I know of. I don't watch him, so I don't know. And we knew that Harris was the boxing. She worked at or owned the boxing gym, I believe, where he. And y'all, do y'all remember back when Maddie Soto, they had the big uproar because the Osceola County Sheriff accidentally posted her crime scene photos on his little website.
Hmm.
They were supposed to upload photos of some senior citizens day activities stuff, and in the mix of photos happened to be one of, just how does that happen, but it happened to be one of Maddie's crime scene photos. He got in trouble because he posted that shit right out on Facebook. It was immediately taken down and scrubbed. He's been arrested for RICO charges. Yeah, and apparently they've been Butterfly and I saw the story a day or two ago. Butterfly, we haven't had a chance to really jump into it, but I did know that much about it. And apparently it was what was it, Butterfly? Some kind of gambling scheme. Yeah, I knew about JLR long before Sebastian's case, but Lord, he caused a lot of problems over there too. He blocked me long before Sebastian went missing because he didn't like my response one day about Dylan Mortensen to one of his crazy posts back when he was trying to throw shade at her and then decided to come to their rescue.
Well, wait a minute.
Wishy
He's
washy.
saying Ann Taylor has taken on two additional death penalty cases.
I just pulled up to that as my
Skylar Mead and Richard Ross.
I just saw that as well. We knew Skylar Mead,
Yeah, what in the hell?
Richard Ross, because is it really because she's the only one in that freaking area that can take on these cases?
She
Why do
can't
y'all?
be. There are more.
Mm-mm.
She got the case because she was the only one who was available at first for Coburger, but
Yeah,
there were other death penalty qualified
yeah, there are, but
attorneys in the state.
in the state, but they keep screaming about how that region, for those who are out of that area to handle these cases, she's like the top dog. But there's got to be more than just her. And I mean, that is what she does. That's her specialty, is death penalty cases. But they got a lot of DP cases in Idaho. Goodness gracious. I haven't looked into him yet because I didn't realize she had taken on a second one, or a third one, I should say. Let's see.
Yeah, she's one of 13 in the state. So,
Hmm.
yeah, if they only have 13, then that does make a difference.
Yeah, it does. And she's like one of the only ones out of that region.
Hmm.
Her and, well, Jay, but Jay took over her old seat when she moved to the state office.
Yeah, but he's co-counsel, though. He's
Yeah,
not for
he's not
lead.
listed as lead anymore. He never was really lead, but they kind of he's took a he and actually he filed some of the newer filings, even though he's taken a little bit of a back seat
Hmm.
to the other ladies.
Yeah, what I'm saying is he's not qualified to be a lead on a death penalty
No,
case.
no, he's
Hmm.
not. That's why he's always the co-counsel. But he may be moving up though eventually. So Ross is out of Lewiston, and he is charged with the murder of Edwina Devon and her son Michael Devon. Let's see. He was is this a retrial? He was sentenced to life in prison on 2 counts of first degree murder, convicted in 2021 of Devon killings. Let me share my screen with you guys and you can see what I'm looking at. Okay. Okay. A case that had been going on for more than 2 years came to a close Friday morning, February 2nd, when Richard Ross was sentenced to life in prison for 2 counts of first degree murder. As reported in the Lewiston Tribune, District Judge Mark Munson handed down the sentence at the Nez Perce County Courthouse in Lewiston. Ross, 58, of Lewiston, was charged November 1, 2021, with the murder and the death of Edwina Devon and her son Michael Devon. He pled guilty by way of an Alford plea. On December 7th of 2023. An Alford plea is a guilty plea that recognizes that the prosecution has enough evidence for a conviction beyond a reasonable doubt, but the defendant can maintain their innocence. Munson said at a hearing, the plea agreement avoided a trial during which the death penalty would have been on the table. Instead, Ross agreed to a life sentence. About 40 people were in the courtroom Friday morning, including members of the Devon family and officials from the Idaho County Sheriff's Office, Nez Perce County Sheriff's Office, and the Lewiston Police Department. The sentence I'm going to impose is not going to be a surprise, Munson said before announcing the sentence. The Nez Perce County Prosecutor's Office had facts and evidence presented at his change of plea hearing in early December that showed that Ross smothered, strangled, and inflicted violence on Edwina Devon at her home in Grangeville the night of September 30th, 2021. Ross then suffocated her or inflicted violence on Michael Devon in Lewiston on October 1 and then burned his body in a truck. Wow, September and then October? Edwina Devon was found in the basement of her home with her hands bound, a ligature around her neck, and duct tape over her mouth. There was flammable material around the body, some of it charred, including incense and items that smelled of diesel fuel. Her cause of death was determined to be from homicidal violence of strangulation, which was stated by prosecutors in Ross's change of plea hearing. In Lewiston, fire crews responded to a vehicle fire and found the body of Michael Devon burned in a truck. He had his hands handcuffed behind him. The cause of death was ruled homicide by unspecified means. The case was scheduled to go to trial January 16th, and the death penalty motion was filed in February of 2022. Taylor and other public defenders with Ross had been arguing against the use of the DP in the case, which resulted in the trial being delayed and numerous motions being filed. She papers the court to death. When Ross entered his Alfred pleas, the trial was vacated and the death penalty was dropped. So apparently Ann's had this case for a hot minute. Ross was also named as a suspect in the strangulation death of Bruce and Lynn Peebles in the Granger home in 1994, but he hasn't been charged in the case, according to previous Tribune reporting. This reads as if Ann Taylor's already been on that case, so I'm going to have to look
Okay.
into it a little bit
Nobody's
more.
been mentioning him though.
Mm-mm. I don't pay much attention to what all Ann's got going on the side unless I see something come up. You know what I mean? I don't think about her like that a lot, but I will certainly look into this guy a little more. I wonder how long she's actually been on that case, because if she's actively working 3 right now that we know of, right?
Mm-hmm.
So we don't want to hear about you crying about how busy you are. Yeah, Rachel's in the area. That one's 20 miles from your son. Goodness. So it was the RICO charges that the guy in Osceola, the sheriff, was brought up on. We do have the story about that as well. Yeah, so Ann needs to take a breath, Ann. Don't overwork yourself, honey.
Apparently, she's not.
She's just going through the motions of standard
Mm-hmm.
filings when a DP case comes up.
Mm-hmm.
We got our standard stuff, guys. Everybody get to work. I'm starting to get a little hungry. My usual time.
Yeah, I'm hungry too.
I always start getting hungry by the time they start their morning break. I usually will eat when they come back so that I've already had something to eat before lunch. You know, Kaylee Gonzalez's birthday's in 2 days.
Mm-hmm.
Mm-hmm. Okay, what was I looking? Okay, here I'm stalking something, guys. I'm looking to see if. Oh wait, let me see if it's here.
Mm-hmm.
Oh heck, I just got a message. I forgot I had to do something this morning. I'll take care of it later. It's just a little business. It's bad when you forget you have real life stuff to conduct sometimes.
Mm.
I hate real lifing. It's just irritating. Butterfly says she's eaten leftover French toast and made eggs and bacon. I gotta go get some more eggs and bacon. I made the last yesterday morning. Sure did. My grandson's huge on bacon, and I like my eggs. So he had waffles and bacon yesterday, and I had eggs and bacon. And this morning I was like, dude, you just get waffles this morning. I did not go to the grocery store.
Today is National Donut Day.
For real.
Mm-hmm.
What kind of donuts do we want? I love a good glazed. I also love, man, we got a good bakery down in town that makes the best donuts. I need to call my son and be like, go get us a donut.
Yeah, some are giving away free donuts here and there.
Oh, you bet Krispy Kreme is today.
Yeah.
They're we have a big Krispy Kreme store in town. It's been there since I can remember.
Oh, well, shit. You can get a dozen for $2
It's $2 dozen day at
right now.
Krispy Kreme.
Yeah, let me see.
I bet my
Participating
daughter's
locations, so double check. You can get a free original glaze, no purchase necessary, valid in store or drive through. Customers can also purchase a dozen for just $2 with the purchase of any other dozen donuts, and every day afterward through June 20th
through
at
June 20th.
participating Krispy Kreme shops.
All right, well, it's my son's gonna be like, "Mom, I'm not driving." Yep, we got him too. National Donut Day. Any donut free in the shop today only, and $2 man.
So they got
But
some
we
place
don't.
called Duck Donuts, Dunkin' Donuts, obviously, Honeydew Donuts, Krispy Kreme,
Ooh,
Come and
honey.
Go and Maverick, something called Sheets, Shipley Donuts, Tim Hortons, and Voodoo Donut
Okay, I got to get off the
are in
donut.
this News Nation article.
I'm gonna want to go get some Krispy Kreme donuts here, and I don't live close to the Krispy Kreme.
Oh, Voodoo Donut has pink raised glazed donuts.
Oh wait, we do have the donut shop in town that's really good. I wonder if they have anything going on today. I ought to call them and say, "Hey, I hear it's donut day.
Mm.
What you guys got down there at the donut store?" I know when I was still door dashing, a lot of people ordered from this little deli or bakery down in town. They were always busy. I've gotten donuts there several times. They were always good. But I don't know if anybody comes close to a Krispy Kreme donut.
I remember when one caught on fire here in Midtown, and
Uh-huh.
people were like out of their minds trying to like help put the fire out and everything,
Oh, no,
and
they
trying
didn't
to
want.
like see how much of it burned and all that. It was like, oh my God. Yeah,
Yeah, they don't want the donut place to burn. We
yeah.
cannot
People were in a
have that.
panic over Krispy Kreme.
This, well, not there's not like a ton of locations all over town. It's usually like one, oh, I don't know. Around here we only have the one Krispy Kreme location. It used to be in another spot when I was a little kid, and then they moved it and made a really nice big store, and it's been there for years now, where it's at now. And when you ride by, that "Hot Now" sign could be flashing.
Mm-hmm.
That's the best.
Oh, the chocolate iced ones look good too.
They are so good. Those are my
There's no way
favorites.
I even need a dozen donuts. That's like crazy.
Girl, I could do some damage if I'm not careful. Not that I'm not worried about gaining weight. I'll make myself sick eating those damn glazed donuts.
Mm-hmm. Oh, what are these four new beverage flavors?
Beverage flavor.
Lemonade chillers infused with strawberry or blackberry or s'more lattes, iced or
uh,
frozen.
Blackberry. That sounds
That
good.
does sound good. It looks good too.
I
I
love
might be
blackberry.
making a visit to Krispy Kreme today then.
Well, shoot.
Yes, yeah, there's one down the street. So,
She's got the convenience of one down the street. I'm an hour away.
girl,
She's
yeah, I couldn't live where you live because, yeah.
No, it's a little aggravating at times. I mean, I do love it, but damn, it's aggravating sometimes.
Hmm.
When I just want to call up and have my food ordered, or because I'm being lazy. And I like to be lazy, especially when it comes to cooking. It's like, damn, that chore again. I've been Actually, my son hasn't had to cook dinner in a hot minute. Maybe it's his turn tonight.
Hmm. Oh, I got something in the microwave. I'll be right back.
Okay. Hey, I think that guy who harmed his little girls, I think he's still on the run. I bet that dude is unalived somewhere. There's a bunch of noise happening in my house all of a sudden. Don't know what the grandson was in there doing. me see. I'm gonna have to go on the Idaho case page and look up this Ross guy and look at some of his documents. They took Skylar Mead off the case of interest page. You have to go to the Krispy Kreme in Washington, Rach. Yeah, it's 45 minutes to an hour. And I'm like, ha. By the time I get there, I'll be ate all those donuts on the way home and I'll be useless. I'll have to go straight to my bed and dive in.
Okay, I'm back. Oh, they're still not back? Dang.
No, they got the OnlyFans up spinning. They should be coming back any minute.
This was
Any
just
minute.
recess, right?
No, it was their morning break, yeah. It usually runs about 15 minutes.
Oh.
15 to 20 minutes. They're on Canton time. They live on Canton time. We're just here for it. We're just at their mercy.
Yep. Oh, it was so funny yesterday. One of my deer came and she kept setting off the camera in the back and kept coming by, like, I don't know, about every 15 or 20 minutes, right? And I was just like, man, she must really be hungry. So I finally got up and, I opened the door and I looked to the left and she was standing over off to the side of the patio, just staring at me, right? Big old wide eyes. So I was like, hold on. So I scooped up a whole bunch of food, put it in a little brown paper bag, and then I went out there and dropped it in the bin. And then as soon as I walked off, she went walking over to the bin. I was like, gosh, this deer, they are tripping. But oh, what made me get up too was she was looking, towards the door, right, towards the sunroom door. And then, she kind of like, looked up in the air and she kind of like looked around. And then I swear she walked over to my car door and sniffed my handle. Okay.
Shoot.
I was just like, and like stood there for a minute. I actually recorded it. I put it on my YouTube.
Did
It
you?
was hilarious.
She's gonna make sure you didn't leave. She's like, "Is her scent on this car? Is that a
You
fresh?
know?
Is that a fresh scent?" I
Yeah.
know she. I know she came home the other day, and we haven't left since. No, or
Yep.
whatever it
Yeah.
was.
Next thing, it's going to be a hoof on the hood of the car trying to feel if
Yeah,
the engine's warm, right?
yeah. She's like, "I know you're in that house, lady. I know you're in there."
Yep, she got me. And then she ate, until she got full, I guess. And then, went off to the side. And then here comes a squirrel. Squirrel got right down in the bin and was like sitting there for about 30 minutes, just scarfing out. I was just like, so yeah, I've got a squirrel that comes by too.
My old yard used to just be filled with squirrels. It was just like my cousin. We just sat outside. And we named them all. We had a whole squirrel family. This yard, and I've been here 3 years. We just have an abundance of birds. I don't have one single,
Hmm.
no squirrels whatsoever.
Oh
They're
yeah.
they're deep in the woods because the woods. Probably because I'm surrounded by these fields and not trees like I used to be. But
Hmm.
yeah, used to have tons of squirrels and big, huge hawks. I mean, the wingspans on these hawks was at least 6 feet. They
Oh yeah.
nested. They had this one tree that they loved at my aunt's property, and they were just there all the time. We would just, you could sit out back and you could tell when one was coming because it like the shadowy shade would come over the whole yard when he flew over. I'd look
Hmm.
up and oh my God, they were crazy. But all I get birds here.
Thanks, Butterfly. She put the link up for everybody.
Oh yeah, I want to watch it too. We got the feed up. Let's see. Let me pull it up. I was reading a little bit more about or trying to read a little bit more about Ross.
I'm
I'm like,
surprised she didn't go to the trunk because I had gone to Tractor Supply earlier when I had Pipsqueak with me and we
mm-hmm.
were running errands. And so I got a new bag of feed because I was almost out. And it's still sitting in the trunk.
Yeah, that's something you can buy around these parts all the time. Well, during this time of year, but there's always corn up at the corner store and deer feed for different things.
Yeah, they said something to me earlier about the season or whatever. They asked me a question
Mm-hmm.
about, the season, the deer season or whatever. I was like, hell, I don't know what deer season is. I was like, hell, they're
No,
always around.
it's not. Yeah, well, deer season meaning hunting season, and it's not
Mm-hmm.
hunting season right now.
Mm.
It's not in Florida. It's not anywhere that I'm aware of. Hunting seasons. It's fishing season now.
Mm-hmm.
Them deers are safe from. I'm watching your video on my phone.
Oh, okay.
Let me pull it up. I want to watch it on the feed. Let me pull up the court feed so I can keep an eye on it over here on
Okay.
the side, and then we'll play that real quick. Okay, yeah, they still have the.
I
Oops,
mean, they literally have the
it's not.
backyard.
I'm gonna have to do it this way. It won't let me click. Okay, come on here, pull up. Ah, okay, here we go. Okay, here's Dolphin's deer visiting the backyard. Like right at home, just chilling.
Mm-hmm.
Just chilling. She's like, lady, this container's empty now.
Yeah, she's like looking straight at the door. Then yeah, she threw her head up.
Well, we have some movement in the courtroom. Let's that is look, he's about to go over and smell your handle now.
Mm-hmm.
Okay, Welcher's back on the stand. That is so cute, Dolphin.
Mm-hmm.
It's like, lady, get out here and feed me. I know you're home. Okay, let me get this pulled back up. They just got Welcher back on the stand, or not Welcher. Sorry, I didn't mean to insult you, Crash Daddy. Okay.
Testing. Okay, initial analysis, which we talked about earlier this morning. Was ARCA paid by the defense for any of that?
No, not the report, testing, none of that.
Okay. What were you paid for last year related to the first proceeding?
My time to appear at the proceeding.
Travel?
Correct, travel,
testimony.
testimony. Yes, sir.
So the form, Mr. Jackson.
Sure. What about now? Have you been paid any additional sums by the defense specifically for your undertaking that you're testifying about today?
Yes.
About how much have you been paid?
I think when I spoke to accounting, I think they indicated it was around $50,000.
Okay. Let's talk about laboratory test B, as in Bravo. If I may have just a moment, Your Honor.
Sure.
What was different about lab test B as opposed to lab test A?
So the tests were essentially identical aside from the speed increase going from 10 up to 17.
Okay. Let's take a look at the next slide. Just so I'm clear, Doctor, I want to make sure I'm on the same slide as you. Is this slide 35 pursuant to your notes?
This is slide 36.
36, got it. Okay. We could be a little bit more brief, I think, because is this similar to the 10-mile-an-hour test, just with increased velocity?
Correct.
Okay. What about the purple hued taillight on the right? What is that?
So again, that is a thermal image depicting the temperature profile of the right tail light that was tested.
And I'm sorry, go ahead.
I was just going to note that the average temperature profile of the taillight here in this test was approximately 30 degrees Fahrenheit.
Is that below freezing?
It is, yes.
And the ATD, the test dummy, if you will,
Yes.
is it also clothed?
Correct, yes. With you may notice a difference in the sweatshirt color. We put on a new sweatshirt in this test.
Was it also an exact replica of the sweatshirt at issue worn by John O'Keefe? I'll ask it a different way. How did it compare to the sweatshirt that was worn by John O'Keefe?
It was made by the same company and had the same material blend as the previous test and the one that Mr. John O'Keefe was wearing.
Next slide, please. What are we looking at here?
So this will be a video. You will see, much like you did in the other one, where the taillight will be accelerated up to 17 miles an hour, impact the arm. And one of the things you'll see is actually an artifact of the test, if you will, where the taillight, due to the fact that the impactor stops at the end of the stroke, that force actually causes it to decouple from that polyurethane foam that we use to adhere the two.
What do you mean by decouple? What does that mean?
So, as I mentioned, it once the linear impactor reaches the end of its stroke, it stops instantaneously, and the force of that stop just caused where we adhered the two together, just caused it to detach, basically break away. So, in essence, it doesn't matter because we only care about that. Remember, we're talking about that short duration of time, that 10 milliseconds. So once it breaks, it's already reached a common velocity to the taillight.
Okay. Can we go ahead and go to the next slide, please? What do you note about this impact?
So one of the things you'll see is kind of that dust cloud that you see. Again, that's all the particulates from the expanding foam that we use. So that's kind of what you see in the background there, kind of going over kind of the arm and the taillight there.
Do you note more damage or less damage to the taillight at 17 miles an hour versus the 10 mile an hour test?
There is more damage, yes.
Let's go to the next slide, please. What are we looking at here?
So you're looking at a top-down view from the high-speed camera. You'll see the taillight enter from the left, impacting the arm at about 17 miles per hour.
Okay, go ahead and play it. Can you describe the decoupling that's shown here?
Absolutely. So as you can see where the two are basically married together, right? It's kind of actually coming back together now. So that bond that we had, right? This is the most effective way that we could mount it to the impactor. It just became detached due to the force of that impactor stopping at the end of the stroke.
Understood. Next slide, please. What are we looking at here?
So in this slide, you're looking at another high-speed video. This is just a side view. Again, you're going to see the taillight enter the frame from the left, impacting the arm at 17 miles per hour.
Is this in slow motion as well?
This is in slow motion, correct, not real time.
Okay. What do you note in terms of the deflection on the arm?
The arm, as we saw in the previous one, is accelerated up, so it's moving now at roughly a common velocity with what the impact speed was.
And what did you note about the damage to the taillight?
It was more significant than the 10 mile an hour test, which, again, there was very minimal damage to that, where several fragments of that red outer lens fractured as well as the clear lens.
Okay, next slide. And what is this depicting?
This is extracted frames from the previous video just showing right at contact, during contact, and post-contact.
Next slide, please. What is this a photograph of?
This photograph is depicting the damage to the taillight at the conclusion of the test, where, again, it's missing fragments of the outer red lens. I will note that the interior diffusers and plastic components are intact in this test.
When you say intact, what do you mean?
They are not damaged or broken.
At all?
Correct, at all.
Next slide, please. What is that a picture of?
Another photograph showing the taillight post-test. Again, no damage to the underlying diffusers in terms of being cracked, shattered, or broken.
And what did you note in terms of the damage to the outer acrylic, the red piece?
It broke into a few fragments, and I think on the next slide I depict those in a photograph.
Let's take a look at that. What is that?
So this is a photograph depicting the collection of the fragments post-test. I will note there's one clear piece, one red piece, another clear piece, and then there is one more red piece in this bag. So the outer lens broke into approximately 4 pieces in the 17-mile-per-hour test. And I'll point out one other thing just because you can see it in the photograph. This is that 3D printed bracket that we used to bolt it onto the linear impactor with the foam on the other side that mounted it to the taillight.
Thank you for that. Next slide, please. What is this a picture of, or pictures of?
This is a side-by-side comparison showing a depiction of the 17-mile-an-hour test impact to the test taillight, comparing it to that of the subject taillight.
Were you able to reach any conclusions or opinions as to whether or not the damage to the subject taillight on the right is consistent with striking an arm at 17 miles per hour?
It's inconsistent from a damage perspective.
What's the basis of that opinion?
The test that I've just showed you all.
Was that testing that we've just talked about conducted in accordance with the scientific literature and generally accepted methodologies that you've earlier described?
Yes.
Is the damage to the right rear taillight consistent with striking John O'Keefe's arm at 17 miles per hour?
No.
Do you hold that opinion to a reasonable degree of scientific certainty?
Yes.
Slide 45, please. What is this?
You're looking at photographs post-test of the sweatshirt that the ATD was wearing at the time of the impact.
Is this the 17-mile-an-hour impact?
Correct, yes.
Did you note any defects in the fabric of the right arm?
There were no punctures, holes, or fraying of the material during this impact test.
Based on this testing that you conducted in this case, is the damage that you saw of the shirt that John O'Keefe was wearing consistent or inconsistent with the shirt that's on the ATD?
It was inconsistent compared to the sweatshirt that Mr. John O'Keefe was wearing.
Based on that, do you have an opinion or a conclusion as to whether or not the damage on Mr. O'Keefe's clothing was consistent with being struck by the right rear taillight at 17 miles per hour?
It is inconsistent.
Next slide, please. What is this graph depicting?
So going back to these terms that we've talked about, this is the acceleration trace of the 17-mile-an-hour impact test. And you can see that we reach a peak acceleration at around 5 milliseconds, and that's at about almost 270 Gs.
You said 270 Gs?
Correct.
Or 217?
270.
Thank you.
70.
Did that have any significance on your analysis?
Yes.
What was that?
Well, we can use that to estimate. Obviously, we can integrate that to get the speed, but we can also estimate the force applied to the taillight with that information.
Can we go to the next slide, please? What is the delta V as it relates to the 17-mile-an-hour lab test?
So you can see, again, the arm initially at rest is accelerated up, increasing in speed, and then reaches just about 16 miles per hour, so reaching nearly a common velocity with the taillight at about 8 milliseconds in time.
Next slide, please. Did you conduct additional tests other than the 2 lab tests that we've talked about?
Yes, sir.
Describe just in general, and then we'll talk in more specifics. What were the tests that you undertook after the lab tests?
So we conducted 2 tests with a suspended ATD arm that was impacted by an exemplar 2021 Lexus LX570. We then conducted a test where the arm was then attached to a test dummy, and then our final test was a full-on impact to a test dummy.
Can we go to slide 48, please? What are we looking at in this slide?
This is the exemplar 2021 Lexus LX570 that was utilized during this test program.
Was this the same vehicle that was utilized in all the tests, C, D, E, and F?
Correct, yes.
If we could go to slide 49, the next slide. What's depicted in this photograph?
Well, so there's a number of things here, so I'll try to point them all out. So obviously, we talked about just now the Lexus here, the exemplar vehicle. We have a forklift that was hoisted up that ultimately was suspending the arm. I think I have an additional photograph that shows it close up. But the arm was suspended from the forklift at the correct height to interact with the taillight. We have our high-speed cameras set up under this umbrella. There's another one over here. Another thing you'll note is we brought out the chest freezer when we were installing these in the Lexus to, again, keep them at that steady state temperature for as long as possible.
If we could go to the next slide, please. What are we looking at in this photograph?
So this is the approximate position that we plan to have contact occur in these tests. So as you can see, the forearm is in contact with the lift gate and the quarter panel taillight along with the elbow.
Why did you choose this configuration for the arm, the forearm, the hand, the elbow?
It was based upon my review of Dr. Welcher's work, and that he did through his static and dynamic test or paint test that this is how the arm was roughly oriented when the alleged contact occurred.
What were you trying to replicate in positioning the arm this direction, this way, as it relates to the SUV?
Well, I think as I stated earlier, it was to understand, okay, let's get beyond just simple geometry, aligning things. What happens to the arm, right? What are the accelerations? What's the damage, right? What we want to answer some of those other questions that Dr. Welcher didn't answer.
Does this...
So I'm going to strike the last part of that answer.
Does this configuration align with your understanding of Dr. Welcher's alignment of the arm as it relates to the vehicle?
Okay. Sustained.
May we approach, Your Honor?
Yes.
Trying to control it. You're trying to control what the defense can do and say. That's as bad as not allowing the defense to even have a defense. Such Delphi vibes right there, lady. Mm-mm. Turtle Boy's in the courtroom.
Oh, where?
He's sitting behind that lady with the black shirt on, blonde hair. Back there on the very back press area.
Is that him bending forward?
He's sitting right behind her with a blue shirt on.
Oh, okay. I don't know why I thought he was bald.
I think he was there yesterday, too. Or not yesterday, but the day before.
Mm. My deer is back.
I saw that.
Yeah. Yeah, I got up to get some more Mucinex and I saw her
Your Honor, may I inquire?
standing really close to the door.
Okay. Let's go to the next slide. It's maybe self-explanatory. What was the speed of your first test out in the field?
15 miles per hour.
Next slide, please. What are we looking at in these two photographs?
So on the left is a photograph of the installed preconditioned taillights just after the install, and on the right is a thermal image of that. And if I may just point out with the temperature. So one of the things you may see here is that due to the reflective chrome here, this is just an artifact of that being really reflective. So when we look at the average temperature profile of the taillight for this test, the average was approximately 17 degrees Fahrenheit for the taillight.
Was it important in this testing to account for the temperature variance of the taillight assembly?
Yes, absolutely. And I will note we certainly strive to maintain that. One of the things you actually may see in this photograph on the left are these pellets on the ground, and that is due to the fact during the installation process, one of my colleagues was positioned adjacent to the taillight fixtures, applying a compress of dry ice to help mitigate any heat transfer during the install process.
Let's move on to the next slide. What are we looking at in this overhead view?
This is it's a drone video, so you're going to see the Lexus accelerate from left to right, impacting the hybrid suspended arm in the area where you could see the umbrella.
Can you use your spotlight and orient us? Where are the vehicles and the testing locations?
Yes. So the Lexus is starting here. You will see it accelerate in reverse with the hybrid arm suspended in this area here.
Okay. Is this a video or just a still shot?
This is a drone video.
Let's go ahead and play that. Dr. Wolf, is that in real time or slowed down, sped up?
This is in real time.
Okay. Next video, please. What is this?
This is a camera that was mounted on top of the forklift that was suspending the arm.
Is this a still shot or is it a video?
It's a video.
What is the orientation of that arm as it relates to the vehicle that we'll see?
So it will make contact with the taillight, although I will note in this test, ultimately the contact ended up being more of a clip or a side swipe in this test.
Go ahead. Did you see the impact area?
It's quick.
Right. What did you mean when you said more of a side swipe or a clip?
So I think the next couple of videos will help demonstrate that.
Let's move on to the next one. What are we looking at in this video? Or, I'm sorry, in this photograph?
So this is going to be a high speed or a slow-mo video. You're going to see the Lexus come in from the right and then move across the screen to the left, and you'll see contact occur between the taillight and the arm.
Okay. Can you explain for the jurors using this video what you meant by more of a side swipe or a clip?
Right. So this is where the hand and the wrist are kind of in the area of the quarter panel taillight, and then a portion of the forearm in contact with, what I previously said, the wrist and the hand in contact with the lift gate portion of the taillight, and then on the forearm is more in contact with the quarter panel taillight.
Okay. Can we move to the next slide? And what is this angle?
This is, same test, just a different angle with the high-speed cameras in slow motion.
And this is at 15 miles per hour, correct?
15 miles an hour, correct.
Can you explain for the jurors, given the fact that this is suspended, does that have any impact on the ultimate analysis or reconstruction, rather than being attached to an ATT?
Effectively, mass is mass. So whether we have an arm that is suspended or attached, again, it's the arm is on a joint, right? So the arm can accelerate freely of the rest of the body, right? So if anything, even if it is attached to the body, there may actually be some additional force associated with that, just because there could be more mass attached to it.
Understood. Okay, let's go ahead and play this video. Can we go to the next slide, please? What are we looking at in these three photographs?
So you're looking at, on the left, starting from left to right, just at contact, and then just after contact, and then post-contact. So as I mentioned, you can see that in this first one at contact, again, we don't have, the hand isn't and the arm aren't positioned as far out on the previous tests, and the hand is in the area and the wrist of the lift gate taillight with part of the forearm in contact with the quarter panel taillight. And as you saw in the video, essentially the arm just kind of just moves out of the way of the vehicle as it comes by.
Understood. Next slide, please. What are we looking at here?
This is a photograph of the test vehicle subsequent to the test, depicting the, I'll say, lack of damage to the taillights.
Describe what you did see in terms of damage or lack of damage on the taillight.
There was no damage or fracturing to the taillights.
Describe the orientation of the arm in this particular test that you said was more of a side swipe. What was the orientation of the arm to the taillight in terms of how much of the arm touched the taillight? It's probably a clunky question, but I think you understand it.
I don't know if I could break it down into, I think just qualitatively speaking, like I said, it appears to be the hand and the wrist and kind of the lower portion of the forearm, maybe to the mid forearm or so.
So nothing on the upper arm?
Correct.
Making contact?
Correct. Nothing on the upper arm, yes.
Okay. If we could move past this slide and onto the next slide. What is this depicting?
So this is depicting the test taillights of the 15-mile-per-hour impact into the hybrid arm compared to that of the subject taillight.
Was there any notable damage at all on the on the exemplar taillight following test C at 15 miles an hour?
The only thing there may have been was some very slight abrasions maybe to the plastic, but there certainly was no breaking or fracturing of the lens assembly.
Were you able to reach any opinions or conclusions as to whether the damage to the subject taillight is consistent with striking an arm at 15 miles per hour?
In this test, it was inconsistent.
Even in a side swipe?
Correct.
Was that testing that we just saw done in accordance with scientific literature and generally accepted methodologies in the area of accident reconstruction?
Yes.
Is the damage to the right rear taillight of the subject vehicle consistent with striking John O'Keefe's arm at 15 miles per hour in a side swipe configuration?
It's inconsistent.
Do you hold that opinion to a reasonable degree of scientific certainty?
Yes.
Can we move to the next slide, please? What are we looking at in this graph?
So you're looking at the hand acceleration over time, so you can see that because, as you saw in the previous video and slides, the hand initially made contact with the taillight, so that gets accelerated up first. So we're getting peak accelerations in this test for the hand of about 254 Gs. And yes, over a period of about a little over 6 seconds or 6 milliseconds or so.
What was the arm or the appendage outfitted with to determine the data on this graph?
Right. So if you think back to the lab testing that we did, right, because we didn't have, and again, this is kind of why we did the testing incrementally as we went about it, but in the lab test, we didn't have a way to mount the lift gate assembly to also evaluate that interaction. So when we moved outside the full-scale vehicle testing, we had a lift gate taillight, obviously the full vehicle, so we also instrumented the hand with an accelerometer as well as the forearm. So we were able to measure the acceleration of both the hand and the forearm in these tests.
Can we move to the next slide, please? And what are we looking at here?
So this is the, the acceleration of the arm. So you can see that it reaches a peak around 5 milliseconds at about, looks like just under 200 Gs.
And the next slide. What's depicted in this graph?
So this is doing, again, the integration of the acceleration data for the hand to determine what speed did the hand get accelerated up to. And you can see that at the onset of this, it's at rest, it's impacted, and then gets up almost to 15 miles an hour in 4 milliseconds. Ultimately does reach at about 18 milliseconds, it does reach that 15, but it's nearly at 15 at contact.
Thank you. The next slide, please. And what is this delta V showing us?
So this is showing the change in speed of the arm. And again, because the hand was, and the wrist was more of the central impact to the ATD arm, this ultimately saw less acceleration, therefore less of a change in speed. So at around 6 milliseconds, well, roughly actually about 1 millisecond after it started to increase in acceleration, it's at about 5 miles per hour.
Is that reflected in the fact that the arm pivoted?
Yes.
It spun?
There's some rotation going on, so it's not translating or accelerating.
Understood. Can we move to the next slide, please? Test D. What was the speed that you undertook in test D as in Delta?
So this is a 29 mile per hour impact into the suspended hybrid arm.
We move to the next slide. What are we looking at in this series of photographs?
So on the left is my colleague, again, compressing the tail light while we install the upper tail, the liftgate tail light to, again, try to maintain that steady state temperature. Over here on the right is the thermal image of the tail light after the install. So the average temperature of this tail light during the test was approximately 17 degrees Fahrenheit.
Next slide, please. Staying with test D, what is this depicting?
This is a drone video showing a top-down perspective of the test with the Lexus starting on the left-hand part of the screen, accelerating in reverse into the suspended hybrid arm over here at the location of the forklift.
Okay. If we could watch this video, please. Do your next slides show, there you go, the suspended arm. What are we looking at here?
So this is a video camera that was positioned on top of the forklift looking down at the arm, so you'll see the vehicle move from bottom to top as this video plays.
By the way, Dr. Wolf, what are the purple and white lines that we see have predominated? I'm sorry, I was talking over that.
Sorry, I
That's
didn't.
okay. What are the purple and white lines that we see?
So those are guidelines to help. I will note that this is kind of like a needle in a haystack. It's very hard to hit this small of a target. So just served as a guideline to reference as we're accelerating rearward into this.
Is this in real time?
This is in real time, yes.
What's the speed that the vehicle is entering the frame at?
29 miles per hour.
Thank you. What happened to the arm in terms of its suspension?
It actually gets ripped off from the mounting location.
Is there a reason you believe physically that that arm was ripped off from the suspension tethers?
Well, certainly there was enough force to break the tie lines to the forklift.
Was there a test value of those tie lines?
I think they were rated at 150 pounds.
What does that suggest in terms of the force that was exerted, just before we get to the other testing, the force that was exerted on the arms to tear off the tie lines?
Well, it indicates that the arm saw at least 150 pounds of force.
Okay. Next slide, please. What are we looking at in this video?
So this is going to be a slow motion video. You'll see the Lexus accelerate in reverse, making contact with the arm. And again, this is the 29 mile per hour impact test.
Okay. Next slide, please. And what is this?
This is a video, a high-speed video, so slow motion, of test D at 29 miles per hour into the ATD arm that is suspended. So you'll see the Lexus enter the frame from the right and impact the arm.
Okay. Was this strike more reflective of what you were attempting to replicate?
Yes, this was a more central impact to the arm, yes.
Thank you. Next slide, please. And what is this?
So this is a high-speed or slow-motion video depicting the test D at 29 miles per hour, just a different perspective than the previous video.
Okay. Next slide. And what are we looking at here?
So this is extracted frames from the high-speed video. So starting out left to right, this is roughly at first contact with the majority of the hand, well, the hand and majority of the forearm in contact with the liftgate taillight, with a portion of the elbow in contact with the quarter panel taillight.
Can I stop you right there on that far left frame? Does that fairly replicate what you were attempting to approximate in terms of the orientation of the arm versus the taillight?
Yes, more of a central impact compared to that first test at 15, yes.
Is that more or less consistent with what you saw in Dr. Welcher's test where he had his arm in that still shot associated with the geometry of the car?
Sustained.
Is this consistent with what you were trying to replicate after your review of Dr. Welcher's report?
Yes.
Sustained. Can I ask it differently?
What were you trying to replicate, or why were you trying to replicate this at the 29 mile an hour test in this particular orientation?
We were trying to see, based upon Dr. Welcher's orientation, what happens to the arm in terms of the acceleration and the damage to the taillight at that configuration at contact.
Okay, next slide, please. What are we looking at?
So this is a photograph depicting the damage to the liftgate taillight as well as the quarter panel taillight.
And what do you note in terms of that damage?
So on the liftgate taillight, a significant portion of that thick 5 millimeter red outer lens is fractured and broken off. The underlying diffusers are still in place. There was a small crack in, I believe it was the upper diffuser here. The quarter panel taillight had the clear section damaged with the outer lens missing, along with some fragments from the outer portion of the red part of the lens.
Next slide, please. What are we looking at in this slide?
So this is another photograph depicting the quarter panel taillight. As I indicated, there is portions of the red lens cover missing. The interior diffusers remained largely intact in this test.
Next slide. What is this side-by-side depicting?
This is showing the results of the 29 mile per hour impact test to the test vehicle compared to that of the subject taillight.
Given that orientation of test D, were you able to reach any opinions or conclusions as to whether or not the damage to the subject taillight is consistent with striking an arm at 29 miles per hour?
It was inconsistent.
What's the basis for that opinion, Dr. Wolf?
The results of this test.
And was that testing conducted in accordance with the scientific literature and generally accepted methodologies in the field of accident reconstruction?
Yes.
Is the damage to the right rear taillight consistent with striking John O'Keefe's arm at 29 miles per hour? When I say the right rear taillight, I mean of the subject vehicle.
Sustained as to that.
With regard to your opinion concerning whether the subject taillight is consistent with striking an arm at 29 miles per hour, do you hold that opinion to a reasonable degree of scientific certainty?
Yes.
Next slide, please. What is depicted in this graph?
So this is looking at the acceleration of the hand in the 29 mile per hour impact test with peak accelerations close to 800 Gs at 2 milliseconds.
Next slide, please. What are we looking at in this graph?
This is the acceleration of the arm, reaching peak acceleration of about 500 Gs.
You indicated 800 Gs in the last graph. What's the difference? What's the difference in the delta between the 500 and the 800?
Between the hand and the arm?
Understood. Which one suffered or was subject to 800 Gs?
That would be the hand.
And which one was subject to the 500 Gs?
That would be the arm.
Next slide, please. What are we looking at in this graph?
So this is looking at the change in speed. So what speed did the hand get up to as a result of the impact? So we can see that in about 3 milliseconds, the arm is moving nearly at almost 25 miles per hour. And then a little bit later, again, this is still very quick in time, at about 14 milliseconds, it's at about 30 miles per hour.
Next slide, please. What's depicted in this graph?
So this is looking at the change in speed of the arm as a result of the contact. So starting here at about 2 milliseconds, the arm accelerates up to, by 8 milliseconds, we're at about 35 miles per hour. And this, you may be wondering, why are we getting more speed than what the input was? And that's because you get a phenomenon known as restitution. Basically, there's an elastic collision between the two where you can get almost a bouncing effect. So when you have something that weighs 6,000 pounds striking something that's much, much lighter than that, it can actually cause it to accelerate up to a greater velocity than the impact speed.
Next slide, please. Test E, 24 mile an hour impact test. What is that?
So this is a 24 mile an hour impact test to the ATD arm attached to a test dummy.
Next slide, please. Why did you utilize 24 miles an hour for this test?
So it's my understanding that this is the upper end. There is a triggering event of, I believe it's 1162.2, and I think at the end of that data, the speed is approximately 24 miles per hour. So we did a test at the end point, if you will, in that data set.
What is this photograph showing in terms of the orientation of the arm and the hybrid test dummy, or ATD?
So the orientation is to depict, again, the orientation that Dr. Welcher indicated in his static and dynamic test to show what happens when again, that ATD arm that we had is attached to a test dummy and is struck at 24 miles per hour.
Next slide, please. And what is this?
So this is a thermal image of the taillights just after the install with the average temperature at about just over 33 degrees Fahrenheit.
Next slide. And what are we looking at?
So you're looking at a top-down drone video with the Lexus here on the left that will accelerate in reverse up to 24 miles an hour, striking the ATD arm.
Let's watch that, please. Next slide. What are we looking at in this slide?
So this is a top-down video from atop of the forklift, or where the arm is suspended attached to the dummy. So you're going to see the vehicle enter from the bottom into going to the top of the screen.
Next slide. What is this view?
It's just another perspective. This is a slow motion video where you'll see the Lexus in reverse. I think this one actually has kind of a long build up before it starts here.
And could we go to the next slide, please? And what is this?
So this is a perspective from the high-speed camera, so a slow motion video with the Lexus reversing into the ATD arm at 24 miles per hour.
Before you play this, Dr. Wolf, I failed to ask this, it may be obvious. After each of the tests, C, D, E, F, were you replacing the taillight with new exemplar taillights that had been temperature accounted for?
Yes, every test had a new set of quarter panel taillights, as well as liftgate taillights. And even in the test where the taillight in the 50-mile-an-hour test where the taillight was not damaged, we still put on new taillights. We did not repurpose or reuse any of the taillights.
Okay, thank you. If you could play this for us, please. Next slide. In this configuration, was the ATD outfitted with the hoodie that you've earlier described?
Yes.
At the time you outfitted the ATD with the hoodie in this configuration before this test E, did you confirm that the sleeve, the right sleeve, was damaged or undamaged?
After this test?
No, before.
Before, it was undamaged before the test.
Okay. What are we looking at in this slide?
So this is still frames from the high speed. So starting out on the left here, just at contact. So the forearm making contact with the liftgate taillight, and then the upper part of the forearm and the elbow making contact, a direct hit into the quarter panel taillight. And the middle here is just after contact, and on the right is post contact.
Thank you. Next slide, please. What are we looking at in this video, or in this picture?
So this is a overall photograph depicting the taillights subsequent to this test at 24 miles per hour. I will note that there's no damage to the liftgate taillight, and then there is damage to the quarter panel taillight.
Is there any damage to the internal diffusers on this taillight?
So if I go to the next photograph, if I may.
Please.
So you can see here there is this kind of thicker, it's actually not a crack. So I'm looking at the clear diffuser here with the dots that you see. This line that you see, kind of opaque. I don't know if you've got a laser pointer to.
Donna, may I?
Yes.
Just so there's no confusion, thank you. So the line right here that's part of the assembly. So that's just a part of how the plastic is molded. There's a very small crack right here in the underlying diffuser, but all of the remaining part of the diffuser in terms of this portion here and here are all intact, and same with this portion of it.
What about the chrome piece that's running between the diffusers?
I don't believe that was damaged during this test, no.
And what about the clear acrylic toward the top left of that taillight housing?
It was partially fractured, but not the entire outer portion of it.
Next slide, please. What is this depicting?
So this is a photograph depicting the quarter panel taillight subsequent to the 24-mile-an-hour impact test with the ATD arm compared to that of the subject taillight.
Based on this test, were you able to reach any opinions and conclusions as to whether the damage to the subject taillight is consistent with striking John O'Keefe's arm at 24 miles an hour?
Sustained in that form.
Were you able to reach any opinions or conclusions as to whether the damage to the subject taillight is consistent with striking an arm at 24 miles per hour?
Based upon the test results, it's inconsistent with striking an arm.
Why do you, on what do you base that opinion?
I base it upon the test results that I've shown in terms of the video and the data acquisition.
Can you describe that in a little bit more detail?
So during this test, we had the instrumented hybrid arm outstretched from the test dummy with the accelerometer on the hand and the forearm. We had data acquisition on the vehicle, monitoring the speeds of the vehicle. We accelerated that vehicle into the arm at 24 miles an hour to conduct a dynamic impact test to collect data certainly about the acceleration that the arm experienced, but then also make observations about the damage that we observed to the taillight.
Do you hold that opinion that we've just discussed to a reasonable degree of scientific certainty?
Yes.
And were your tests conducted in accordance with methodologies that are generally accepted in the field of accident reconstruction in this particular test cycle?
Yes.
Next slide, please. What are we looking at in this series of photos?
So these are photographs depicting, excuse me, the test clothing. Again, prior to the test, there were no holes or damage to the sweatshirt. That was the same post-test. We did not make any observations with respect to any fraying, holes, punctures to the material of the sleeve.
Was there any damage whatsoever observed on the right sleeve of that ATD?
No.
Next slide, please. What are we looking at in terms of this graph?
So what you're looking at in this graph is the acceleration of the hand reaching a peak acceleration just after 10 milliseconds of approximately 435 Gs.
Next slide. What are we looking at here?
This is the acceleration of the arm during this 24-mile-an-hour impact test, reaching peak Gs of about 300 at 4 milliseconds.
And the next slide. What is this delta V graph showing us?
So this is showing the change in speed of the hand as a result of the impact, ultimately getting up to approximately 24 miles an hour, which again is the impact velocity of the Lexus.
And how fast did it get up to 24 miles an hour?
In probably about 10 milliseconds or less.
Next slide, please. And what is this delta V showing us?
This is showing the change in speed of the arm going to about just over, looks like about 22 miles per hour at about 10 milliseconds. So total window of time of about 8 milliseconds that it took to get up to that 22 mile an hour speed or so.
Understood. And next slide, please. Did you undertake, by the way, another question. On that, when the ATD was oriented in test E, as an echo, where it was standing with its right arm out, and the impact was on the right arm, what happened to the mass of the body of the ATD?
It rotated.
Was it projected at all off to the side?
No.
Was it projected rearward?
No.
Was that rotation expected based on your experience?
Yes.
What is the 29 mile an hour impact test in test F?
So this was a test that we conducted with a what's known as a rescue Randy, or a test dummy, that was a full-on impact to the right rear corner of the Lexus.
Let's take a look at the next slide, please. With regard to test E, if I could please ask you about that. I want to go back to that test, even though we're looking at this one. With test E, was that reflective of a direct impact on the arm itself?
Correct, right in the area of the elbow to the quarter panel taillight.
As opposed to a side swipe on the arm?
Correct, yes.
Thank you. Did you undertake to test a direct impact on the body of the ATD in this test?
Of the rescue Randy dummy?
Yes.
Yes.
What are we looking at here?
So this is the intended impact configuration with the rescue Randy suspended here by the forklift, and again, kind of in the path of the profile at that right rear corner.
How much does this test dummy weigh?
Approximately 200 pounds.
Next slide, please. What are we looking at in this photograph?
So this is a video. We had a little bit of a false start, so our high speeds weren't triggered, but thankfully we were able to pull our surveillance video to get at least an overall video of the test taking place.
Do you have, or did, well, let me ask you, did you intend to have high-speed video just like you've had in every other test?
Yes.
What went wrong? Something
Just
didn't get
miscommunication between the driver and the rest of the test engineers.
Got it.
So false start.
Okay. Was the taillight housing reassembled for this test?
Yes, it had a preconditioned new set of taillights on it.
And other than the taillight being damaged several times that we've seen, was there any other damage to the rear of that exemplar vehicle?
I'm sorry, can you repeat the question?
Sure. Other than the taillight damage that you rotated through in your testing, C through F, was there any other inherent damage to the the lift gate that existed when the exemplar vehicle was received by you?
When it was received, no. It was
Okay.
in good condition. No defects or damage were noted.
Okay. What are we going to expect to see in this video?
So in this video, you'll see in the surveillance video, the Lexus will come from the right to left, strike the rescue Randy, and then you'll see the rescue Randy projected and slide on the ground.
Okay. Can you play that one more time, please? Next slide, please. What are we looking at in this series of photographs?
So this is a extract from our VBox software and data acquisition system. So on the top, you'll see the video. On the bottom is the data. So this is another feed that we had of video. This was triggered, so we do have data from this perspective. So what you'll see is my colleague will move away from the assembly with the dry ice, and then the vehicle will accelerate in reverse.
That was my question. The blue, that's dry ice, gloves?
You can't, you don't want to touch dry ice with your bare hands. So
Okay.
it's, he's wearing gloves. He's capturing the thermal images now.
Next slide, please. And what are we looking at in this?
So these are extracted frames from that video you just saw from the data acquisition system. So on the left here is just before contact between the test dummy and the Lexus. On the right is just at contact.
Next slide, please. And what are we seeing in these series of photos?
So this is obviously during the collision sequence. The body now has loaded into the lift gate and the back window What you're seeing here is the back window shattering, and this is just a few split second later in time where, again, the body is continuing to move with the vehicle as it's contacted.
Next slide. And what is this?
This depicts the post-impact damage to the rear of the Lexus. As I noted, the rear window is completely shattered. There's deformation and crush to the liftgate section of the vehicle. The bumper step was popped out, and then there was some minor fracturing in the bumper cover at the lower level.
Did you note anything regarding the internal components of the exemplar taillight, even at this direct impact?
So the taillight, as you can see, it blew out the outer lens cover. I believe the part of the clear diffusers were actually still in place. I think the lower one might have been fractured here, but I think the upper one was still in place.
At 29 miles an hour with a direct impact, did the exemplar taillight exhibit the same type of damage to the diffuser as the subject taillight?
I'm not sure I understand your question.
More or less damage in this photo to the diffuser specifically than in the subject taillight?
Well, I think there was more in the subject taillight. As I mentioned, I believe the top diffuser
More
on this
damage?
was correct.
Okay. That was my question. And is there another slide at the on the back end of this one?
That's it.
Okay. We can have the lights. Dr. Wolf, you conducted tests at what miles per hour? Tell me the sequence.
It would be 10 miles per hour, 17 miles per hour, 15 miles per hour, 29 miles per hour, 24 miles per hour, and then a full-on hit at 29 miles per hour.
Regarding all of the tests you conducted, what did you observe with regard to the damage, if any, to the internal components of the quarter panel taillight? And I'm talking about the chrome pieces and the diffusers.
It was less in all of the tested taillights than that of the subject taillight.
Did you reach any opinions or conclusions as to whether the damage to the right rear taillight of the subject 2021 Lexus is consistent with an impact to John O'Keefe's right arm during a high-speed reversing maneuver?
Sustained in that form, Mr. Jackson.
Did you reach any opinions or conclusions as to whether the damage to the right rear taillight of the subject vehicle is consistent or inconsistent with an impact to a right arm during a high-speed reversing maneuver?
It was inconsistent.
What's the basis for that opinion?
All of the test data that we did from the laboratory testing, moving up to full-scale vehicle testing, all of the collected data in terms of the photographs, the observations, all of the acceleration data collected. So all of the testing that we've walked through in this PowerPoint, along with certainly that was based upon all generally accepted and peer-reviewed methodologies in the accident reconstruction community.
Do you hold that opinion to a reasonable degree of scientific certainty based on your experience, training, and education?
Yes.
Did you reach any opinions or conclusions as to relating to the punctures, holes in the hoodie that you saw that was related to John O'Keefe?
Yes.
Do you have an opinion or conclusion as to whether or not the damage that you saw to the hoodie related to John O'Keefe is consistent or inconsistent with a impact from a right rear taillight of the subject SUV?
It was inconsistent.
And what do you base that opinion on?
Based upon all of the impact testing that we did with the clothed ATD arm in the laboratory as well as the field.
In any of the testing that you did you ever see taillight pieces cut, puncture, or fray the sleeve of that hoodie?
No.
The exemplar hoodie, I should say.
Correct.
Did you reach any opinions or conclusions as to whether the rear taillight of the subject SUV was involved in a center of mass strike of a pedestrian at a high-speed rearward maneuver.
Yes.
What is your opinion?
That the damage to the subject Lexus is inconsistent with a center of mass hit.
What do you base that opinion on?
The testing that we conducted in that last test that you just saw.
Do you hold that opinion to a reasonable degree of scientific certainty, Dr. Wolf?
Yes.
Thank you. That's all I have.
All right. Is this a good place for a break, or do you want to get started?
What's preference? Lunch is on here.
Jurors, why don't we let you have your lunch? Okay? So we'll come back. We'll come back ready to go at 1:30.
All rise in court, please.
All righty. So we are on lunch break officially.
Okay.
And let me see.
I'm still knee deep in Quicken stuff.
Are you?
Yeah, 4 months of not doing it, so yep. Yeah, but I'm still here.
Okay. I was looking at something, trying to save something for in a few minutes.
Oh, okay.
I think it went the wrong cancel. Okay. Okay, guys, they're just checked the Twitter feeds, and they're just entering the courtroom over in Lori's trial. Lori's in the courtroom now. She's up and about this morning. No need to strap her down and wheel her in. Her advisory team hadn't arrived yet. It's a couple minutes ago, but everybody else is in place. And they've come out and called for any of the family members from the defense side, and of course, there's nobody there as usual. There wasn't anybody there in Idaho trials either. Okay, let me pull this up. We're gonna look at this. Hey, what happened there? There we go. I gotta slide my screen over and make this one a little bigger. Get all my stuff together here this morning.
Oh, my watch is probably charged up. I was like, let me turn down my phone. And then I just realized I'm not wearing my watch.
Okay, so this is an article that just came out. The top of it here. When was this? June 6, 20. Well, it says it was published originally in 2023, but it's been updated. Okay. So I went outside a few minutes ago to get a little bit of fresh air, and my sinuses just decided they didn't like that. Okay.
Yeah.
They sure didn't. They've been out here working these fields again the last few days. Okay. This says, Idaho student murder suspect Brian Koberger once boasted of his daily boxing routine while describing how he cut fish and worked as a meat wrapper in a security job application obtained by Fox Digital. Okay, so we've known about that for a while. We also knew about his job at the fish factory,
Right.
the fish hatchery, or cutting up the fish. Okay, so 28-year-old criminology PhD student who is now a quadruple homicide suspect previously wrote that his special skills included rigorous punching workouts and a year of youth law enforcement training in 2015 in a 2015 job application to work school security. So in his own words, he has special skills, including rigorous punching. All those folks trying to say he's not coordinated and such.
No, yeah.
He says, I boxed after school every day at the Jesse Harris Boxing Gym on 209 next to Big Cheese Pizza when it was still open. I also attended a year of law enforcement program and a year of HVAC. He was vying to work as either a fill-in custodian, a courier, or security guard for the Pleasant Valley School District in his Pennsylvania hometown of Effort. We know his dad was a custodian at the school, um, and Brian did end up getting a job as security guard at the high school.
For like 5 years, right?
Yeah. Okay. His employment history showed only 2 previous gigs: 7 months at Big Brown Fish and Pay Lakes in 2011, and 4 months in the butcher and produce departments at BJ's Wholesale Club in Stroudsburg in 2015. He added that he did some side work for his father, a district maintenance worker, learning how to do pipe work and HVAC. No mention of a pizza gig. Koberger, pictured in yearbooks as a chubby teen, also appeared to be proud of his weight loss, writing about it in a section where he was asked to describe professional and civic activities. I was a boxer. I'm still a runner, he wrote. I believe dedication and perseverance are the most important skills learned from my activities. I lost 130 pounds at age 15 into age 16 whilst attending school at PVHS and MCTI. I believe this is proof that I have the required dedication to be successful. Before and after photos. He also claimed to have been a champion extemporaneous speaker, a competitive improvisational speaking style. Is he a good debater? Yeah.
On the
Koberger wound
spot.
up. I know it would be. I could imagine the exchange between him and his attorney. Koberger wound up getting the job for the Pleasant Valley School District, starting out as a casual security guard and then earning a promotion to a part-timer. The district outfitted him with size 13 boots. Still like to know what size that shoe print outside Dylan's door is. Several XL shirts, a jacket, and pants with a 34-inch waist. This thing's in my way. However, his employment came to an end in June of 2021 when he submitted a resignation letter acknowledging that I understand that if I do not resign, I have a right to a school board hearing to determine if I should be dismissed from employment with the school district.
I remember
So,
looking into that.
yeah, we looked into that, and he did have to resign from his job.
Yeah, he was in the meeting notes.
Yes. Gosh, I gotta find where I have all that. Damn, I gotta get my other phone out too, probably. There's so much in it. The district declined to disclose further information about his departure, stating that records related to non-criminal investigations, complaints, written criticisms of an employee, and disciplinary materials are exempt from disclosure under Pennsylvania's public law records. The district declined to disclose further information about his departure, stating that the records related to non-criminal investigations, complaints, written criticism of an employee, and disciplinary materials are exempt from disclosure under Pennsylvania's public records law. The records do show, however, that Koberger was placed on leave without pay for at least 1 day in February of 2021 due to expired clearance. Some of Koberger's claims in the application may have been exaggerated. It says, watch, Brian's former boss says Idaho suspect didn't last long. He got a little video. It's been a minute since I've watched this guy talk. Is it going to play? Yeah.
Don't upload your videos to YouTube. Upload to Restream, where we will live stream it to YouTube and
We've had hundreds of kids come through here and mentored them, and they've gone on to do wonderful things. Pharmacists and teachers, and have their own electrical companies, and almost everything you could imagine. We're so proud of all those kids, and for us to be painted in some kind of light along with this terrible tragedy is very disturbing. And truth of the matter is, he's here a very short time, 12 years ago, young kid, did our best to mentor him, and mutually decided the job wasn't for him. That was all there is to the story.
Okay, because people were coming out on the internet and saying, because his job there was literally to fillet fish, and people were saying all kinds of stuff, and the guy's like, no, we're just a regular little fish hatchery here, guys. Okay, so Charles Conklin, who founded Big Brown Fish and Pay Lakes in Effort, Pennsylvania, 35 years ago, told Fox News Digital in March that Koberger didn't last long on the job and never got any training with a filleting knife. When kids come in here, their jobs are to keep the place clean, pick up paper all day long, help customers catch fish, fix poles, and then we try to train them on how to fillet fish. And if they get good at it, if they get good at it, then they can fillet customers' fish. He never got good at it. Koberger wasn't around long enough to get to that point. Conklin said they parted ways with him just after 3 weeks is all he worked there. I couldn't remember how long he actually worked there. Koberger on his application claimed to have worked there from March to October. Oh, you got to embellish a little bit about your job at the fishing lake. Oops, come back.
No, yeah, there you go.
Okay. I cut the fish to the specifications of the customer, he wrote. According to your boss, you didn't get that far, Mr. Embellishment. You remind me of some of them witnesses over here in Canton. His reason for leaving, he added, was needed one season. Needed one season?
He was only needed for one season.
Well, they are a seasonal operation, buddy. They'd have brought you back in next year if you'd done any good at it. Koberger went on to complete a master's degree in criminal justice at DeSales University and began his PhD studies at Washington State University in Pullman last fall. Shortly before the Thanksgiving break, 4 students at the neighboring University of Idaho were stabbed to death during a 4 a.m. home invasion, according to the Moscow Police Department. The victims were 21-year-old Madison Mogan, Kaylee Gonzalez, 20-year-olds Xana Kernodle and Ethan Chapin. It would be roughly 7 weeks before police arrested a suspect, Koberger, at his parents' home in Albrightsville in the Poconos in Pennsylvania. He is being held without bail on 4 charges of first-degree murder and another on felony burglary. Well, we know about the death penalty. Now, this one gets down to, where'd it go? Because it has, wait, is this not my one?
Look at all those ads.
I know. It's ridiculous. I ignore it. I try my best just to overlook all that and ignore it because they want me to pay attention.
Yeah, that's why I was still saying you should probably turn on ad blockers because it'll get rid of all that mess on the screen.
Yeah. I had to make myself a note to sit down and do it. I got a lot of notes I need to put down here to make sure I'm doing. Okay, let me pull up this one. I thought that was the article that I had that had a little more information about what we're going to talk about as far as these new witnesses.
Oh, okay. That was Daily Mail and New York Post, Fox.
What we just did was the new foxnews.com or whatever they call themselves, and the one we're going to look at now is also, this is a different one from Fox News, and it has more, and I also have the one from the Daily Mail as well. Okay. Let me pull this one. Okay, here we go. Fox News Digital, that's the one we were looking at a minute ago. Okay. So this one is also from Fox News, and this is talking about the subpoenas that were coming in. All right. Key figures from Idaho student murders Brian Koberger's Pennsylvania past may have been summoned as witnesses in his upcoming trial, according to the documents. We'll look at the documents in a minute. They include Jesse Harris, whose name is on the boxing gym where Koberger used to train, Ann Parham, an advisor at the school Koberger attended, Marie Bolger, a former professor who taught Koberger at DeSales. Koberger wrote that he boxed daily at Harris's gym in 2015, which we just read through that. Get this shit out of my way again. Okay. I gotta order a new mouse. I don't like this one anymore. In 2023 interview with the Daily Mail, Bolger said Koberger was one of her brightest students and one of only two who she had recommended for the PhD program in a decade. We talked about that recently, guys.
Mm-hmm.
However, she explained she never met him in person and only taught him over email and Zoom during the height of the coronavirus pandemic. She helped him work on his graduate thesis, which centered on how and why criminals commit their crimes. Okay. The other witnesses are Ralph Vecchio and Maggie Sanders. Their connections to the case were not immediately clear. Now, we looked up, so Vecchio, according to JLR, owns the dealership where he bought the Hyundai. Maggie Sanders, I have not even had the time to look at her yet. I don't know who she is in this case. I'll get to Maggie in a moment. The documents were made public in a Pennsylvania court days after the defense filed an amended witness list in Boise. Now, I don't know if these are related to defense request or prosecution. Wouldn't it depend on what they testify to? What it?
Yeah, but don't you have the actual one of the court docs?
Yeah, I got them. Yeah. What I'm wondering though is what we don't know is who's trying to call them as a witness yet. All right, so let me pull up the actual documents. We have the Commonwealth of Pennsylvania's website, my Discord. Okay. But I also moved a copy to my PC because if I go pull shit up out of Discord, it does not like to work right on my share screen. And for some reason, it didn't move this to the top of my list. That figures. Where'd you go? Uh-oh, grandson's watching TV. I need to close my door a little bit, probably. You guys can probably hear it. Okay. I'm getting to my list, guys. It moved to the bottom of my list for some reason instead of the top. Hang on, guys. I got to go get it again. It moved it for some reason. Now I can't retrieve it. Let me go grab it again. I just want to grab the link out of the Discord because if I don't, it won't let me pull it up right. Okay, now I got it. Okay. It took my screen away from you guys. I hate when it does that. That's why I cannot stand messing around in Discord when I'm streaming. It don't want to act right. All right, now, I don't know why I tried to bury it in my list. Okay, this is the docket from Pennsylvania. and here's the documents. Hold on, son. 1 second, baby. Hold on, guys. Okay, sorry about that. Grandson had to come show me something he built on his Legos. All right. So they had a scheduling order on the 5th. We're going to start with the ones on the 4th. The last thing they had in the docket on the Pennsylvania case file is from December 29th, 2022, and it was a search warrant inventory return on the Hyundai. This is a summons for order scheduling a hearing on petition for summons, and this is for Ralph Vecchio. And that's all this is just standard forms, guys. There's not really a lot we can even read into them. A lot of it's not even filled out. And on this day, which is blank, blank, is consideration of the petition for summons directing witness. What, Mason? 2. I'm sorry. Attend to testify out of town criminal proceeding filed
Are
in the
you
above.
trying to show something? Because I still just see the list of selected
Oh wait, I
postings.
clicked it, so I got to click out of it, and then every single time if I click the document, it doesn't pull it up unless I click it first. Let me go out and back up. Sorry,
Oh,
guys, my grandson's a little bit distracting at the moment. He is a child, and he is at home from school, and I don't live in a perfect world. Hold on 1 second. Let me pull it back up the other way, and I got to click each individual one. I can't just pull it up and then click them. It won't show you guys. It was showing me. Just 1 second. I need to be able to move that back to the top of my list. It's aggravating my brain. Okay, let me pull up the individual because I'm going to start with the first one that came up, and it was petition for Vecchio. Okay, now let me pull it up this way, see if it shows. Now the grandbaby's good to go for a moment. All right. Okay, so this again, like I said, this got a lot of blank stuff, so we don't even know who sent these, who's requesting them at this time, if it's the defense or prosecution. Um, and this is to give them a chance to have a hearing on whether or not they think they should have to be subpoenaed. So a hearing on the petition shall be held on, and the days are blank, and in the courtroom and time and all that is blank. And it says 610 Monroe Street, Strasburg, Pennsylvania. Petitioner shall promptly serve a copy of this order upon Ralph Vecchio. Ralph shall appear at the hearing to show cause why he should not be compelled to attend and testify in an out-of-court criminal proceeding. And again, it's not even signed. Okay. Now they have this attached to it, and this is like 14 pages on just him alone. All right. Ralph is a material and necessary witness in a criminal proceeding pending before the District Court for the 4th Judicial District of the state of Idaho. Compelling the attendance and testimony of Ralph Vecchio will not cause undue hardship to him. The laws of the state of Idaho where the prosecution is pending, and of any other state through which Ralph Vecchio may be required to pass by ordinary course of travel, provide protection to him from arrest and from the service of civil or criminal process while traveling to, attending, and returning from the proceeding. For these reasons, it is hereby ordered as follows: a summons shall issue with a copy of the certificate issued by the Honorable Judge Stephen Hibbler of the District Court of the 4th Judicial District of the state of Idaho, directing Ralph Vecchio to attend and testify in the criminal proceedings pending in the state of Idaho on the dates of the trial, which begins August 11th and ends November 7th, with the specific date to be communicated to Ralph by the court. So they're wanting him to come in, I guess, to lay foundation on verification that he bought the damn Hyundai, if this guy really is who owned the Hyundai place or who sold the car. So they want him to come in, and that'll be what that is for. I have to take that whole thing down. Okay, so now the next one was for, let me pull it back up. Okay, and this
I
one,
do remember writing on somebody's. Was it, oh God, what's her name? Anne?
this is Ann's now.
Okay. Who did you show me earlier? I saw some writing on somebody's.
The one I sent that screenshot of?
Mm-hmm.
Yeah, that was the scheduling order thing, I think. I haven't looked at it yet or
Okay.
shown it yet. I don't remember which one it was from. It was just a screenshot I grabbed early this morning.
Yeah, it
So,
was.
yeah, I haven't looked at that yet. Okay, so, well, not here anyway. Order scheduling a hearing of petition for summons for Parham, for Ann Parham. And same standard verbiage here. Blank notes. Let's go down and see what it says. Blank lines. Ann Parham is a material and necessary witness in the criminal proceeding pending, and it's the same thing. So they're going to order her to do the same thing. August 11th through the 7th is the trial dates so far, and they'll give her the specific dates, I'm assuming, on which she needs to be there. I'm not sure who she is either.
She is somebody from his school, like his high school.
Because we have Bolger, and then, yeah, because Harris
Boulders
is,
from
yeah,
DeSales. Mm-hmm.
yeah, Bolger's from DeSales, and Harris is from the boxing gym. Okay, and this one was for Jessie Harris. Let me pull that up. And we know, allegedly, she's from the boxing gym. Okay, so this one is the same standard procedure stuff, calling for her to testify. And it's going to be the same order, handing down to her to also be there as well. So it's, we knew you had to have, well, I mean, the logical sense would you would think they would bring in people from that knew him from Pennsylvania to testify, either at mitigation or somewhere through that process, maybe to establish a few things about him, but not so much as far as a defense goes. You know what I mean? Character type stuff, maybe. Childhood upbringing, the way he was as a child, because Anne's definitely going down that road. I got to get back to the damn document, guys. It fell off the face of the earth again. This sensitive little thing. Oh my goodness. My folder for Coburger is 3 years long, so damn near, so it shouldn't. I got way too much. I need to go through some of this and weed out what isn't even relevant. But there's a lot of good information stored in this damn folder that I forget about sometimes, that is old. And then usually it puts whatever I'm doing recent at the very top of my list, but today it's not. It's like, no, we're just going to give you a fit. There it is. Nope, that's not it either. Because I want to show that one thing we were just talking about. Let me get back to it, guys. Bear with me, please. Thank you. Here we go. I have to remember it's very close to the bottom for some damn reason. All right. So we know they have an order in like that for Maggie Sanders, Jessie Harris, Bolger, Michelle Bolger, his former professor, Brandon Andriola, and Parham, and then let's see the scheduling order. I think this is what, yeah, this is what I sent off in a screenshot of this morning that she was referring to that had the handwriting, and they just wrote in some dates and stuff. They did not do this on the other documents though. This is a order scheduling a hearing on a petition for summons for Anne. We just read hers a second ago. So for her, they are having a hearing, and it says it was supposed to take place.
Yesterday, or no, the
No,
30th.
it'll be held on the 30th. It was filed,
Oh,
yeah. So the 5th day of June, 2025, upon consideration of the petition for summons directing witness Ann Parham to attend and testify the out-of-state criminal procedures, filed the above captioned matter. A hearing on the petition shall be held the 30th of June, and that will be held in Monroe County. Petitioner shall promptly serve the order upon Ms. Parham. She shall appear at the hearing to show cause, while she should not be compelled to attend and testify the out-of-state criminal proceeding. And she is the only one to do this so far. Wait, yeah. Nope, here's the what same one for Michelle Bolger. All these are in there now. Okay. So there's also one for Michelle Bolger as well. I guess if they want to come to court, they can do so. If they want it, somebody, Abigail Parnell Esquire. This one is for Jess Harris. Again, they're all going to be on the 30th at 9 a.m. And this one is for Maggie Sanders. And then Ralph Vecchio. And that's it. So that we know there will be a hearing on June 30th. And I guess if they want to argue their subpoena at that time, that will be the time for them to do it. What did
I
I say?
doubt that they'll make them come all the way to Idaho. They could just probably show up on Zoom.
A lot of times they will these days. Shit, we've had it happen here in Idaho. In this case, occasionally, there was times that different people come in through Zoom. It all depends. I mean, if they're not like super relevant testimonies to establish certain things, yeah, they can absolutely come in through via the Zoom. But if any of these people feel like they're not relevant and they want to fight it, they'll fight it. It's up to them. Now, when you're subpoenaed, you're subpoenaed, but there is going to be a hearing held on it anyway, and they can come in and discuss whatever they want to discuss about it, whether they feel like they need to be in there or not. Makes you wonder, besides the dealership guy, I wonder what all they will attest to, come in and testify to as far as the gym lady. I can see why she's going to be in there to give a backstory on how much Koberger actually boxed, how good he was at it, how much time and effort, all of that. Brian XNT says, I remember the Brian story. It's pretty, yeah, pretty recent. Well, 3 years now. You liked the Greek society narrative. Yeah, nothing come of it. Nothing come of that one. Still being floated from what I understand, but we have nothing to back it up. So I'm curious about some of these people, what else they may know about his particular background, how they played a part in what they know about him, or what could we know what the professor would probably testify to, and the teacher from the school.
Yeah, that professor has information about the Reddit surveys.
Yeah, because that was under her class when he was doing that stuff. The teacher at DeSales. Sanders. I wonder if that'll be the only people they try to talk to out of his past and background. There may be some of his friends come in and speak at no telling who all the defense has actually spoke with, trying to get them to see if they have anything to, add to his defense. I don't know, how well it'll work out for him.
Yeah. See, Joy says, yeah, nobody wants to be in attendance. I mean, you get a subpoena. It's not a matter of a choice, you know.
Yeah, no, it's not. People can dodge subpoenas if you can show just cause. There wouldn't be a hearing on it if there was a way to get around them, because there is. It's just not the norm, right? And nobody
There's
wants to.
probably a hearing because it's in another state.
Yeah, well, a lot of times they'll do that. It depends. If there's if somebody is subpoenaed and they just downright don't want to do it, they can get an attorney and try to fight it. It don't usually
Hmm.
work out in their favor though. Um, they'll make accommodations for these people. I'm not worried about their accommodations. I know they'll make them. I mean, this is
Yeah.
2025. God dang, this is not rocket science. If it's got to the point where we don't know how to get these witnesses across the state, then I'm done with. I'm just walking away from true crime. Um, it's not rocket science. Get them on a Zoom. It's what are they going to testify to that I'm more. That's where my curiosity lies. And who are these people and what do they know? That's the kind of stuff that I'm thinking about. Because I understand the law part of it. Their little hearing is, I don't even care about it. I just want to know who the people are. Been waiting long enough for a lot of information about this case. It's like I get why they want to keep a lot of it close to the vest and keep a lot of things quiet because there's all that speculation out there. Y'all don't want to speculate what really about the real evidence. That's what the defense problem is. Yeah, so Joy, 9 times out of 10, people aren't just jumping up and down for joy. They got to go to court, right? It's normal to not want to go or not to want to be involved or whatever. Sometimes you're like, hell yeah, let me at it. But I'm not about to treat adults with kid gloves anymore. I feel like that's that part of. I'm kind of over that. You don't want to be a witness. Well, don't. I don't know what to tell you. Stuff happens in life, you know? Stuff happens. I wonder if that's the only teachers they'll call in. And because that's not the teacher's name that taught the class. Remember when we watched that special with Nancy Grace? What was that teacher's name? I can't. Camilla.
Yeah, that's the other one that we were talking about, but I don't see a subpoena for her.
No, there's
It's
not one for her. That's what I'm wondering.
Carmela Beers
Yeah,
is
Carmela
her
Beers.
last name.
Yeah,
Hmm.
because there's not one for her. So just the other lady. That's interesting to me. Unless this lady had more to do with it, the actual incident, and the other lady just signed off on everything, right? Because that's what her. She was an administrator. We've got that article somewhere as well that we just reviewed it recently with her, I believe.
Yeah, I've got the video saved somewhere.
Yeah, we reviewed it a while back here on the stream. It's been a minute because some people didn't know about her or anything about the story of what unfolded there at the school um, with her. But I think she was more of an administrative role, so she would have signed off on everything. So I don't know if she wasn't a actual teacher, during the actual incident. So I don't know if that's the reason for the other teacher being on there or not. I need to,
Like one of the women
because there
was like
was,
his guidance counselor or
yeah,
whatever.
there were two
And I
mentioned.
think that's Ann Parham because she looks familiar.
I
And
think,
then Carmela Beers, it's Tanya Carmela Beers. She was like the program director for the vocational
yes,
training program that he was in.
yeah, she had the administrative part. That's why I think she signed off on everything. But the other lady was the one that probably actually dealt with him in the
Hmm.
classroom on the daily and was a part of what, not a part of, but witnessed or whatever, direct knowledge of what the complaint was. Um, Whatever that is I had saved, it won't even pull up anymore. Oh. What was this? Hold on. Oh, that's right. Somebody filed a civil action suit against her and the Monroe Career and Technical Institute. Filed it against them, Thomas J. Rushton, and Tanya Camilla Beards. Um, when was this? Let me pull it up and I'll show you guys. I've had it for a long time and I forgot about it. When I was researching her once, I found it. I was like, oops. Didn't expect to find that, but I did. Okay, so this was an order, and there you can see the names of the plaintiff, Sharon Throughout versus the Technical Institute, and a couple of the teachers there. Okay, in accordance with the memorandum issued in this same day, and upon consideration of the defendant's motion to dismiss, the report and the recommendation of Magistrate Judge Joseph Saporito, the plaintiff's objections and defendant's brief in opposition. It is hereby ordered that the report and recommendation of Judge Saporito is adopted in its entirety. It is further ordered that the defendant's motion to dismiss is granted in part and denied in part. The defendant's motion is denied with respect to the plaintiff's perpetrated failure to comply with procedures set by this court's this is in 2015. The defendant's motion is denied with respect to all claims asserted against defendant Monroe Career Tech Institute. The defendant's motion is granted with respect to all claims against the defendants Thomas Rushton and Tanya Camilla Beers, acting in their official capacities. All claims against the defendants Rushton and Camilla Beers are dismissed with prejudice. The clerk of court is directed to remand this case to Judge Saporito for further proceedings. So I just stumbled across that one day on the internet when I was looking into things. I was like, what in the world? Shady stuff about people, but I don't know. Where'd my article go? All right, let me pull up this other thing on the side because I got to keep an eye on a couple of things at the same time. Let me see. What is this? Huh. I gotta send you something, Dolphins. I don't know what this is. Maybe you can look at it while we're. Hang on, guys. 1 second.
Okay.
Yeah, I literally have no idea what it is. I just saw it, and I just need to get another set of eyes on it.
Yeah, somebody just sent me something. I'm like, oh man.
I'm doing enough multitasking right at the moment. Just hang on. The information's coming out fast. And I don't know what half of it is sometimes until oh, I'm on my phone. Never mind. I got too many devices going at one time, and I'm trying to upload something on the wrong device. Goodness. Okay. Take a look at that, and I don't know what that is. I just know the names at first glance. All right.
Okay, I'm looking.
All right, thank you. Okay, guys, let me get the chat box. And thank you, Al, for hanging out with us throughout the lunch break here as we're trying to get some of these updates going. All that good stuff. Oh, I need something to drink. My chat. Okay. Yeah, Rachel, it'd be interesting to see if some are for the coming up for sentencing phase. X and T, you were dismissed after 5 questions. They didn't like your answers? Didn't like your answers. Oh, thank you, Rachel. I appreciate that. He's usually pretty self-contained. He keeps forgetting how long to cook his popcorn for some reason. Like, dude, you make it all the time. How do you keep forgetting? Yeah, he's a pretty good kid. Thank you guys for understanding. Um, yeah, crazy shit, right, Dolphin? Okay, we're checking into something, guys, that we can. Um, I think you're right, Dolphin. That name,
Yeah, I'm
that
checking right
name.
now.
Okay, good. That name is very familiar. She's checking on some documents, guys, that I need to verify before we even say anything about it, because I
Yeah.
don't know what it is. And so she's checking on that for us, and I
Oh.
will. Did you find some information? Okay, let me go over here and check something real quick. You're rearranging your closet when you get done. Well, mine's arranged, but I need to kind of pull everything out, and I need to put some stuff back into a crate that's on the bottom, and I just don't feel like doing it. Like, maybe I won't get anything out for Christmas next year, because then I have to put that shit back up. That doesn't mean I got Christmas stuff everywhere. I just have this one thing I forgot to put up, and it's just like in my way now. And I'm like, I got to get in the closet and pull this out to get to that. And I'm just like not feeling it. Okay. Let me pull up let me pull up Bev's stream, Bev's courtroom on the side, real quick. Like, I feel like they have about another half hour. If so, well, they have the OnlyFans is spinning now, guys. So we'll keep a lookout for that. Um, Lori's trial is underway. For today. Day 2 over there. Okay. Y'all want to, why does it do that? I'm going to let a little bit of this play while we're waiting, guys, because I kind of want to hear it in the background while I'm doing something. Okay, let me get that to play. Look, we get to see where's she at. Look, she's moving around.
Yesterday, Mr. Abernathy, one of the advisory council, said he would be late today because he had a child care issue, but that Ms. Hicks, the other advisory council, would be here and ready to start at 9:30. What time did that email come in?
Her advisory council's bailed on her for like.
All right, so we got an email at 9:20 saying she's still at her office.
Yeah, Rachel, we
printing
didn't
off
expect
pictures,
anything
which
less than
is
that, right?
wholly unacceptable. Ms. Daybell, you represent yourself. You do not need your advisory council here, but I'm going to split the difference. She's being sent an email.
Get on the mic,
because
my
if she's
guy.
not
Come
here
on.
At 9:50, 9:50, we're going to start. If there's pictures that need to be printed off, staff can do that. Staff can bring it over later, but should have been here at 9:30. If this were federal court, she'd probably be going into custody. I mean, this is ridiculous. All right, I'm just letting everyone know what the holdup is. We're going to start at 9:50.
Judge, at 9:50, I do need to make a record regarding character evidence and the defendant opening the door before she questions.
Look, I'm not going to struggle to hear these people.
Okay.
They got me messed up with somebody who's going to try.
So she's aware of that.
We'll do that at 9:50. Stay out here or go back?
It's not our fault her attorneys don't want to come to court.
Why he was in so much fear for his life, why he was, is clearly what she was doing. Assuming she does, then the rules would permit
Assuming she
does
does.
not allow the defendant to bring in character evidence to
I need to. Hang on. Let me do this.
towards people, and then she also spoke
All right, the
about
sound is on,
bringing in
guys, but it is not loud.
hiring a private investigator. I want to start with the fact that the defendant is appearing to try to bring in
You see what I linked you?
404 character
I was
evidence
just about to
about
look that
herself.
up, and I was like, thank
Rule
God she did.
404A does not allow the
Thank
defendant
you.
to bring in character evidence to prove action in conformity, which is clearly what she was doing. Assuming she does, then the rules would permit the state to then bring in specific act evidence of this defendant. The defendant is trying to say she is a peaceful person, she has no malice. I believe that will open the door to allow the state to bring in the fact that she is a 4-time convicted murderer. Next, the defendant, in terms of bringing up information about Brandon hiring a PI and trying to make it appear that he has some vendetta against her, we have worked very hard to try to say there is an incident in Chandler. Brandon Boudreaux was very aware of the fact that this defendant and her brother had shot and killed Charles Fallow. And this is why he was very afraid for his life and trying to realize where she was and where Alex was. So if she wants to go into all of that information, then again, I believe she will be opening the door to allow Brandon to then explain why he was in so much fear for his life, why he was hiring a private investigator to locate this defendant and locate Alex Cox. So I just want to make it very clear that should she go into those areas, I will be asking to then bring in the fact that she has been involved in the murder of Charles Fallow.
Look at the way
her
Lori's
children,
looking at her.
and her current husband's wife.
All right.
And I believe 405 will permit that, Your Honor.
So I had literally the same thoughts during her opening statement, especially when she started talking about I'm a person with good intent, kindness, peace and love, etc. And I was thinking in my head, wow, she's opening a big door right here. Now, it's not witness testimony. The jury has been instructed specifically that that's not evidence or testimony.
Wow.
But I think the notice that the state is putting out right now is well taken, because if you elicit testimony through a witness or you testify yourself along those lines, there's several doors that would be opened in that instance. Do you understand that?
I understand what you're saying, Your Honor.
Okay. The schedule.
I also understand that the state also withdrew their 404B, that they had no intention of doing that. So
that doesn't mean you get to say whatever you want.
I'm not saying that.
Okay.
I'm just saying they did give a notice for 404B, and then they did withdraw it.
Yeah,
so
did.
They didn't have any intention. I didn't have any intention.
The issue is if you bring in your good character as a reason of why this didn't happen, they're going to be allowed to rebut that type of testimony if you open the door to it. The schedule for today, I'd like to finish the witness that was on the stand yesterday, if he could come up.
And then, Judge, just for scheduling, I have one civilian witness who only had a Ring camera. She is very fast. I would like to, after Detective Ferrer is done, put her on quickly before we recall Brandon, just so she isn't waiting around.
All right, so it'll be the witness from yesterday. We'll conclude with him. The defendant was in the middle of her cross on him. We'll do that. Civilian witness. At some point in the morning, we'll take a short break for the court reporter in about an hour. And then we'll recall Mr. Boudreaux to complete your cross, or start and complete your cross. All right?
Y'all think her glasses are clean enough yet?
Go ahead and line them up.
I've been sitting here watching this lady clean them glasses since this feed has been up. And they're still at lunch in Canton.
Welcome back. Please be seated. Thank you for your patience. All right, the defense can continue with its cross of this witness.
Okay, Detective Ferrer, yesterday we were talking about you collected the evidence, is that correct?
That is correct.
Okay, so what all evidence did you collect yourself?
The projectiles from a bullet.
Is there any other evidence that you collected?
At the scene or?
Yes, at the scene.
Yes, just the projectile.
Okay. And then, was there a cigarette collected at the scene? Is that correct?
I don't recall that.
Okay.
I did not impound that.
You never saw it?
I don't recall it.
Okay. And you had collected the items that were in the Ford F-150, is that correct?
Yes.
And you collected the earplugs that were in the truck?
Yes.
And you stated that those were common among people who frequent a shooting range, is that correct?
Yes.
And during the course of your investigation, did you learn that Alex Cox frequently visited shooting ranges?
No.
Okay. You mentioned that you remembered Alex Cox's vehicle license plate because it was personalized, is that correct?
That is correct.
And then in the course of your investigation, did you discover what his license plate stood for?
No.
Okay. Or what it was a reference to?
I do not know.
Okay. Did you learn in the course of your investigation that Alex did stand-up comedy?
No.
Okay.
She wants everyone to know about Alex and his comedy. Lori said, I'm a nice person and I want to please everyone. The judge says, if you're going to bring up your good character, we're going to show it's not so good.
The hole in the Tesla, is that correct?
Yes.
And you said it was consistent with a bullet hole, is that correct?
Yes.
And so that could be a bullet from a rifle or a handgun?
Yes.
Okay. So either one.
Either one.
And those fragments weren't tested to find out if that was from a bullet or, I mean, the bullet was from a rifle or a handgun?
I did not send it for testing.
Okay. You also said that you were the one that canvassed the neighborhood for videos?
One of many.
Okay. But in your report, you said that at 3854 Phelps, that the individual had heard a loud bang but did not investigate it, said it didn't sound like a gunshot. Is that correct?
Can I object to hearsay?
Sustained.
And you had stated that you did collect the fragments, is that correct?
Objection asked and answered.
But the majority of the bullet was never located, is that correct?
Let me rule on the
sorry.
objection. It's sustained. Next question.
And the majority of the bullet was never located, is that correct?
We had a projectile. That's what we found. Just pieces of it.
Okay.
Fragments.
Are they all afraid to
put in your
talk?
report
Man, I
that
know
you
my
believed it
headset's
had fallen
it's
out
ridiculous.
When the victim drove away?
It's a possibility. There's a lot of possibilities.
So my question is, how would it have fallen out? How could you explain it falling out? Could you explain that to me?
It depends where the bullet hole or the projectile goes into a vehicle. There's several.
I'm like, no, not today, girlfriend. They can't even talk loud. Let me get the court feedback up because they are coming back into the room. And I'm on mute just talking to you guys. Yeah, butterfly. Volume at Lori's trial is low. I don't care. It's just not as high as some other ones. My headsets are crappy low. But anyway, guys, Joe will do a full recap tonight if you guys want to go over and check that out later. And you can find Lori's trial all over the YouTube.
So jurors, we are going to stop today at 3:45.
3:45.
All right.
Be 2:45 my time.
Group.
Plus, I'm partially deaf, guys.
All right.
Loud.
So, okay, great. Thank you. All right, do we have the actual? Okay, great. Yep.
Y'all got your popcorn ready?
So,
216.
thank you. All right, Mr. Brennan.
Good afternoon, Dr. Wolf.
Good afternoon.
When you testified in direct, you shared with the jury some of the work that ARCA does. Do you remember that?
Yes.
And you had mentioned a couple interesting things, that there had been some work with the Department of Defense.
Correct. Yes.
The work with the Department of Defense, was that during your time or before you got there?
That would have been prior to my employment, yes.
So when you were telling them about working with the Department of Defense, that really had nothing to do with you. That was ARCA before you began working there.
ARCA as a whole, yes, the work that we do, yes.
Not you.
As I said, I wasn't involved specifically in that project, no.
And you mentioned that you did some stuff, or the company does some things for the NHL?
Yes.
You didn't tell us much more about
Too
what
late,
you do.
buddy.
There's other things that ARCA does as far as clients, right?
Certainly.
Did you share with us that you work for lawyers and law firms?
Yes, we do.
And you do litigation, insurance companies?
Yes.
Okay. Is there any reason why you highlighted the Department of Defense that you don't do, and the NHL, but didn't share the rest of the stuff with us?
That's just some of the prominent clients that we have.
I see. You provided us a CV, didn't you?
Yes.
And that's like a resume, tells us a little bit about your education experience. You get to highlight some of the things, your accomplishments.
Yes.
You shared with us you've been the Director of Accident Reconstruction at this company, ARCA, since 2017?
No, not since I started.
You started with ARCA in 2017?
Correct, yes.
When did you become the Director of Accident Reconstruction?
I think that would have been in January of 2024, so about a year and a half.
About a year and a half ago?
Yes.
And you received your certification from ACTAR?
Yes.
Did you pass the test on both parts first time?
I don't recall if it, I think it was I had to retake, I think, the practical section in the afternoon.
Well, you would recall something like that, wouldn't you? Did you pass both parts on the first try?
Like I said, I think it was the second part I had to retake.
Well, this is a pretty important test, isn't it?
Not really.
It's your certification.
It is, but much of the concepts that are covered in it are very elementary.
Well, not so elementary. You had a hard time with part of it, didn't you?
Well, with respect to the portion that I had to retake, it's a practical exam where you have to reconstruct an accident, where you have to determine approach angles, departure angles, and it can be very sensitive to those inputs. And unfortunately, if you mess up one of your first angles and you carry out that calculation, then the whole problem is graded wrong, even if you did all of the math correct.
So we understand there's a multiple choice question part that's the easier part, correct?
I don't know if it's easier, but there is a multiple choice part.
There's a more practical part where you actually have to go out in the field and do assessments, kind of like the things that you did today.
You don't go out into the field, no.
And, when did you first take that second part that you didn't pass?
I don't recall.
You don't remember when you took the test?
No, I don't.
Suffice to say you took it again.
Correct.
And ultimately you passed both sections of that test?
Yes.
In your CV, you list your schooling and you list your degrees, don't you?
Yes.
You mentioned some of the things that you focused on in your academic experience, don't you?
Yes.
And you have publications.
Correct.
Recently, you did a publication regarding vehicle control history on Toyotas.
Correct.
Vehicle control history is data that is stored in a vehicle,
Yes.
and Toyota owns Lexus, correct?
Correct.
So you have familiarity with vehicle control history. In fact, you have a publication on it.
Yes.
In your entire resume, you only mention pedestrian collisions, or that you're involved in pedestrian-type events 3 times. Is there anything specific in your resume or your publications that show a published accomplishment, for example, in pedestrian collisions? Do you have any publications that have been peer-reviewed or published in that area?
No, I don't have any publications in pedestrians.
You write or you note areas of specialty, and you list a bunch: accident reconstruction, human factors, EDR, commercial vehicle, HVEDR, pedestrian bicycle accidents, nighttime visibility, and a number of others, correct?
Correct.
Is there anywhere in your resume that notes particular classes that you've attended and completed regarding pedestrian collisions?
No, I haven't taken any classes in that.
You haven't taken any classes on pedestrian collisions?
No.
Have you ever taught regarding pedestrian collisions?
No.
Have you ever been a speaker in a presentation about pedestrian collisions?
Yes.
Okay. Is that listed in your resume?
I don't list lectures or presentations, no.
You were asked questions about your involvement in this case. Yes?
Yes.
And you had shared with us that you, at the beginning, were working for a separate party or a third party, you said?
Yes, another agency.
Another agency. And at some point, you came into court and testified last year.
Yes.
And during the time before you came in and testified, you weren't wholly independent of the defense, were you?
Well, certainly before all of our testing, at the point at which we did all of our testing, report, and analysis, as I mentioned on direct, I didn't know the Commonwealth or the defense in this case.
My question, more precisely, before you testified, before you came into court and gave your testimony, you weren't totally independent from the defense, were you?
No, I mean, I had to communicate with them to be able to determine when to appear for testimony.
So you were communicating with them, yes?
Yes.
And in fact, some of the time that you spent, ARCA actually billed the defense for, and they paid that bill, didn't they?
Eventually, after the trial, yes.
During that time, you know what a sequestration order is, don't you?
Yes.
Do you think that you're under a sequestration order today?
Yes.
Did you talk to anybody about any of the prior testimony in this case before today?
No.
How'd you get here today?
How did I get here today? I took a car ride over from the hotel.
Who drove you?
It was a driver. I don't know his name.
Stupid. Did you
It
crack
was
anybody?
would have been someone on the defense team.
Was it like a window, like a limo?
It was an SUV.
Was there anybody from the defense with you on the ride over?
There were 3 young ladies in the back seat. I think they might have been interns, and Mr. Woke.
And who?
Mr. Wolk, I think is it pronounced? Am I saying it wrong?
Have you discussed anything about this case before your testimony today as far as the trial?
Before today?
Yes.
Yes.
Have you discussed anybody's testimony in this case?
Nobody's testimony, no.
That was different last year, though, because before you testified last year, you did have discussions about testimony, didn't you?
Not with the Commonwealth or the defense, no.
But I'm asking, though, you did have discussions about testimony before you testified last year, right?
Correct, yes.
And you know what a sequestration order is, don't you?
Yes.
After you testified last year, the court ordered you to provide all of your text messages, all your communications with the defense, didn't they?
Yes, earlier this year.
And when you were ordered to provide all of the actual verbatim communications with the defense, did you provide those communications?
Yes, all of the records that I had at the time I provided.
Well, not the records. You know what I'm getting at. Did you provide the communications?
I provided everything I had in my possession, sir.
A text message isn't just a time and date. It's actually substance when you text somebody, isn't there?
Correct.
And when you texted, how many texts do you think you had with the defense?
From what I recall, I think it was around 50 texts that I sent.
It wasn't 100, I think it was 50.
Well, I think it was around 100 total in terms of back and forth, but it was, I think, 50 that I sent.
And during those texts, communications, conversations, correct?
About logistics, yes.
Did you provide the content of those text messages when you were ordered to by the court?
Well, those text messages spanned from, I guess it would have been April or so of 2024 through May to June of 2024. Ultimately, I think I received the court's order in May of this year, April of this year. So it was a year after the fact, and I had already deleted the text at that point.
How many of those text messages did you delete?
I just swiped the conversation, so it would have been the whole conversation.
Not how you did it. How many of those 100 or so text messages did you delete, sir?
It would have been the whole text chain. I didn't individually delete them. It just, when you swipe, it just deletes the text chain.
After you deleted them, did you go into the recently deleted and then delete them so they were unavailable?
I don't recall doing that.
Well, you were asked to search your records of the text messages. Did you do a thorough search to see if you still had them or whether you had destroyed them all?
I checked my phone, and I also checked with my phone carrier.
So do you know if they were still under the recently deleted part of your phone, or did you go and take that extra step and totally destroy them?
From what I recall, I did not find any of the text messages, no.
Is there any reason why you deleted all of your text communications with the defense?
Well, it's something that I routinely do. I work with attorneys and clients all the time, whether it's appearing for trial or inspections, and I don't have a habit of keeping a text chain that talks about logistics and things. It's just I routinely delete them after that communication is over with, and certainly after the prior proceeding, once it had concluded, there was no reason for me to preserve those.
Okay. And so, at some point, you switched from text messages to another form of communication, didn't you?
Yes, earlier this year.
Tell us a little bit about this new form of communication, not text messages.
So, Mr. Jackson had indicated that he and his defense team utilized an application known as Signal for their communications amongst their defense team. Ultimately asked if I would also use that application to communicate, which I agreed to.
Is Signal an encrypted app?
It's a secure encrypted app, yes.
It doesn't leave any records, right?
I don't believe so, no.
Well, you have it. You're using it. Do you have any records from your signal use?
I'm going to allow that.
Do you have any records from your signal use?
I do not, no.
So you know full well that Signal as an encrypted app leaves no record.
There may be a setting that you can change. I just know that the way that it was set up, there was no record.
Well, who set yours up to have no record?
I don't know. I think it was default.
Have you ever checked your Signal app to see if you have any record of your communications pursuant to that court order?
Well, I don't have the application anymore, but at the time I did check the application.
Out of all these clients that you've had, how many times or how many clients would you use Signal with?
This was the first time.
Have you used it since with other clients?
Not yet, no.
Before you testified last time, at the last proceeding, or should I say when you testified at the last proceeding, kind of like today, you attempted to portray yourself as totally independent, didn't you?
Sustained enough.
When you testified at the prior proceeding, did you attempt to portray yourself as totally independent?
Yes.
The truth is, before you testified, you were communicating with the defense and attempting the best you could to assist their cause, weren't you?
I wouldn't characterize it that way.
So before you testified, you wrote out questions that you thought could help, that you should be asked when you testified, correct?
So something I routinely do before testifying is prepare an outline of topics and questions that would best help be able to get out my opinions and the analysis I undertook, ultimately so that you all have an understanding of what I did.
So I'm asking you a question. You gave the explanation, but you're skipping over the answer to my question. So I'll ask you again. Before you testified, did you write out a list of questions that you wanted to be asked?
Yes.
And when you listed out the questions, you also listed out the answers, didn't you?
A general response. It wouldn't be verbatim to that.
I didn't say verbatim, but did you list out the answers to each and every one of the questions that you had prepared?
Yes.
So for every question, there's an answer that you provided so that you could follow a script, so to speak, yes?
I wouldn't characterize it as a script.
One of the questions asks, so not being able to inspect vehicles is something that is not uncommon in your line of work? And your answer, absolutely not. Remember writing that out?
Yes.
And you put a footnote, a comment. And you said, not sure if you want to put this somewhere in the direct examination. I have a feeling they are going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. If you need to show the jury, it doesn't matter in this case. Did you write that?
Yes.
When you're talking about they, I have a feeling they are going to argue I didn't personally inspect the vehicle. Who's they?
That'd be the Commonwealth.
And so when you were writing out these questions as is your routine with the answers, is this the mark of independence to you?
Well, I think, again, whether the Commonwealth asked me that question or the defense asked me that question, my response would be the same. It wouldn't change depending on who called me to testify. There are a number of cases, by the time I get involved, the evidence is gone from the roadway, the vehicle is gone. So it's certainly not necessary to inspect a vehicle. And I wanted the jury to have an understanding that because I didn't physically inspect the vehicle, it didn't affect my analysis in the case.
So you think that showed independence?
Yes.
Then you also had another question. Would it be fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? Remember that?
Yes.
And you said, yes, unfortunately, there is a direct correlation between time of day and pedestrian fatalities. Is that true?
Correct, yes.
And do they happen more often in the day or at night?
More often at night, yes.
Statistically speaking, by the way, this case involves nighttime, doesn't it?
Correct.
Statistically speaking, most of pedestrian fatalities occur during the evening and night hours. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Did you write that?
Yes.
In fact, you testified, you shared that with the jury, didn't you?
Correct. I've testified to that twice last year as well as this year.
And in the notes that you wrote, when you shared it last year and this year, was it an important point to the jury?
I think so, because it helped gave them an understanding, I think, of my background and lighting and human factors. And as I mentioned earlier today, there's a direct correlation between time of day and pedestrian impacts, right? So my specialty in lighting and human factors results in me seeing many, many different types of pedestrian impacts.
So if it's important, why did you include a note? If you don't want me to say this, that's fine. Why did you include a note to the defense that if they didn't want you to say something that you thought was important, you would leave it out?
Well, I think because I didn't want to confuse the jury about a statistic, that just because we have inclement weather and dark lighting conditions, it doesn't automatically equal a pedestrian impact, right? We have to look at the evidence and the damage to the vehicle and the injuries to determine whether or not a collision occurred, not the visibility.
So you weren't trying to mislead the jury, you were trying to help them because they wouldn't understand something that you were trying to explain? Is that the way you're phrasing this?
I think at the end of the day, it was to help them understand my background, how it relates to seeing a lot of pedestrian impacts.
Something was important that helps the jury get to the truth. Why would you offer to leave it out?
Well, I didn't leave it out.
No, but you offered to. You would have if requested. Why did you invite, why did you invite somebody else to interject in your independence and guide you to leave something out? Why would you even provide that invitation to them?
Again, it's because I didn't want them to get hung up on a statistic that just because we have more pedestrian impacts at night and in bad weather, that this alleged incident happened at night under bad weather, to give it more weight, to weight the evidence more because of that statistic.
You done?
Yes.
If you make a mistake in court under oath, would you take the affirmative step on your own and correct that mistake?
Objection. I'll allow it.
I would do my best to do that, yes.
Well, when you say do your best, would you do that if you became aware of it?
Objection. I'm never allowing it.
Yes.
Before you testified in a proceeding last year, there was a hearing that you testified in front of Her Honor and other people that were here, correct?
Correct.
I wasn't here.
No.
You were.
Yes.
And you testified about your experience, didn't you?
Correct, yes.
When you were sharing your experience with the court, it was important for the court to have an accurate understanding of what your experience was because it was being evaluated in that hearing, wasn't it?
Correct.
When you testified to the court, you testified that you had been qualified as an expert to testify over 20 times, didn't you?
I don't have the transcript. I believe I said approximately 20 times.
The reality is you hadn't. You've only testified and been qualified 11 times at that point.
Correct. I misunderstood the question. I thought it also encompassed deposition, so I added those two and approximated at 20.
And at some point when you realized you had made a mistake in your testimony to the court, you had a chance to come back when you testified last year and fix it and clarify the record, didn't you?
Correct, which is why I provided a comment with the specific breakdown for clarification.
And when you came back and testified under oath the second time, on the record, under oath, did you clarify and fix the mistaken testimony that you had provided just days earlier?
I don't recall being asked a question, no.
No, it wasn't whether you're being asked. The question is, did you take the affirmative step to fix the misstatements under oath that you made?
Objection. I'm going to allow it. Move your vote. Sure.
Well, is he ever going to try to give up? Ever?
After your first testimony, you appreciated that you made a statement under oath that was wrong, didn't you?
Yes.
In fact, you made a note. I realized in my testimony I said about 20 times, when you asked me how many times I've been qualified, I misinterpreted your question, which was my fault, but in looking at my D&T list, it's 11 trials, 7 depositions, 18 testimonies total. Not sure if you want to clear it up or just leave it. Was
Correct.
that right?
Yes, sir.
Did you just leave it?
I'm not responsible for asking the question, sir.
Do you ever heard the terms confirmation bias?
Yes.
Do you know what confirmation bias is generally?
Generally, yes.
Do you think that you suffer from any confirmation bias in this case?
No.
Do you have any close family that supports one side over the other? Not the facts of the data, but one side over the other.
Close family?
Yes.
Not that I'm aware of, no.
Wife?
My wife?
Yes.
I don't really know what her thoughts are on the case.
May I approach?
Yes.
Take a look at that document. Have you seen that before?
No, I have not.
Never seen that.
No.
Bring it back. You're unaware of anything that may influence you to lean one way or another?
Correct.
When you first took a look at some of the facts in this case, you had some information. Since then, you've received a lot more, haven't you?
Correct, yes.
Part of your testimony today to this jury was to provide opinions that you do not think that the holes in Mr. O'Keefe's clothes are consistent with some type of collision. Is that fair to say?
Yes.
In coming to that opinion, you relied on some of your testing that we saw in those videos, didn't you?
Yes.
And that testing involves a hybrid 3-arm, doesn't it?
Correct, yes.
A hybrid 3-arm is an arm from a crash dummy.
Yes.
That's not the technical name, but that's what it's often referred to.
Yes.
And you and Dr. Renshaw have been working together on this case, haven't you?
Yes.
You've discussed ideas and shared thoughts.
Yes.
In fact, you've worked so intimately together, you know some of the things he's going to testify if he comes to testify, you've said many times today, right?
Yes.
And so some of the data that you've shared and some of the opinions overlap with each other, wouldn't you say?
Certainly. He's going to rely on a lot of that test data, yes.
When you were forming your opinion about holes in clothes and potential abrasions to somebody's skin, all of those tests, all of those that you did, were using a crash test dummy arm, weren't they?
Yes.
In your report, you cite, or Dr. Renshaw cites, 3 different sources regarding testing clothing and skin, correct?
I'm not sure.
Well, haven't you read his report?
I've skimmed it, but I don't know what the basis are for his opinions.
Did you see footnotes 24, 25, 26, 24 being skin tissue cutability and its relation to lacerations, severity, indices? Did you read that?
Let's see if there's a foundation.
No, I didn't read that reference.
Did you read 25, the book that is cited, Forensic Pathology, 2nd edition?
I'm going to have you come to sidebar.
Well, hopefully this sidebar won't be too long. You went outside with your coffee?
I almost spit my coffee out when you said that. I'm sitting on the back steps taking a sip of coffee, and she says, "You went outside with your coffee," and I about spit it everywhere.
Yeah.
I
So
did,
sorry.
ma'am. No, you're good. I walked out there with the dog for a minute and thought, it's nice out here. I'll sit down. And sure enough, as usual, Bev goes on the sidebar. But they're back.
Let me again ask you about this book that is cited in Dr. Rentschler's report. By the way, have you read Dr. Rentschler's report?
As I mentioned, I skimmed through it.
So in all of your preparation with Dr. Rentschler, you merely skimmed through his report? You didn't take time to read and study it?
Well, none of my opinions are based on work that he did. He's undertaking a completely separate aspect in the analysis.
But that's not the question. The question I asked you was, did you, in working closely with him, take the time to study his report?
As I mentioned, I skimmed it. I didn't read through, as you mentioned, all the references or what he cited. I didn't do that.
Did you read his report?
I did read the report, yes, but I didn't in depth go through each reference and look at what he was citing.
So you read his report?
Yes.
And when you read his report, did you see there were footnotes for a number of different propositions that he made?
I know that there were footnotes in the report, yes.
Well, on the issue of whether or not crash test dummies should be used during experiments as a basis for an opinion of whether abrasions can happen through cloth or an arm, wouldn't that particularly interest you since you were going to come here and testify about it multiple times in front of this jury?
I'm not sure I understand your question.
You knew you were going to come in here and suggest to the jury that you thought that these tests were inconsistent with causing any type of holes in clothing similar to Mr. O'Keefe's or abrasions on his arm. You knew that was going to be part of your opinion today, yes?
Yes,
and
yes.
as part of forming a valid opinion that people can rely upon, wouldn't you want to do as much study as possible on the background for that opinion before you give it to a jury?
I suppose, yes.
Well, you suppose. Don't you think if you come in here as an expert, the jury is relying on your background and education?
Yes.
And they're relying on the fact that you're representing something definitively or with an opinion to a reasonable degree of certainty? You understand that, right?
Yes.
And don't you think when you do that, that it's important that you have proper study and foundation before you just come into court and give an opinion?
Well, I will note that the ATD crash dummy is a generally accepted test device to use for not only assessing occupant forces in motor vehicle crashes, but also to assess impact forces. So that the use of that device is certainly generally accepted.
When you get uncomfortable with my question, you generally tend to answer a different question.
Sustain, Mr. Brennan, next question.
Oh, that's a strike.
Strike that, Jules.
Let me ask you again. Don't you think, as an expert, it's important when you come in and you're going to present an opinion based on science or engineering or whatever you want to do, that you study the basis for that opinion before you give it?
Yes.
When you saw in Dr. Rentel's report references to this very issue about what should be used when you're doing demonstration or study of what can cause tears to clothing, weren't you interested in the basis for those opinions?
Well, again, it was something where Dr. Rentschler and I worked together, and we were in agreement that we could utilize the ATD arm clothed.
When you decided to have an agreement that you could use that arm, did you read the book that he cites as support, Forensic Pathology, 2nd edition, Vincent J. DeMaio? Did you read it?
No, I did not.
Did you brief it?
No.
Did you peruse through it at all?
No.
When you decided to come to this agreement that's going to have a foundation for your opinions, did you look at footnote 26, understanding the acute skin injury mechanism caused by player surface contact during soccer, a survey and systematic review? Did you review that?
No, sir.
Have you seen any articles that support the proposition that a hybrid 3 arm of a crash test dummy is appropriate to use when you're trying to provide a foundation for an opinion about whether or not tears can happen to clothing or abrasions to skin? Do you have any support for that in your report?
Well, again, Dr. Rentschler is going to be addressing the... You're shaking your head.
So I'm going to let him answer the question first, Mr.
So as I mentioned, Dr. Rentschler is assessing the injuries to the arm, okay? He indicated to me that we could utilize the hybrid arm to assess the injuries to the arm.
So you have no independent experience or research or knowledge, not Dr. Rentschler, you don't have any independent research or science or knowledge to support your idea, your theory, your opinion to this jury about the tears to the clothes into the skin.
I was relaying the observations from the testing that we conducted with the ATD. Ultimately, like I said, Dr. Rentschler, it's my understanding that he will testify to the abrasions or the lacerations to the arm.
You've given multiple opinions about this to this jury, didn't you?
Correct, yes.
I'll ask you one more time. I'll ask it this way. Name, other than someone called Dr. Rentschler, name the papers, the studies, the learned treatise, name the resource material you relied on as the basis for those opinions, that a hybrid 3 arm can be used in these type of demonstrations as a basis for that type of opinion.
I certainly, ATD crash test dummies can be used for impact testing, yes.
Not impact testing. You're talking about tears to clothes, abrasions to skin, and I'm asking you for the 3rd time. Name one journal, one paper, one study that supports your proposition that you're relying on for the basis of your opinion in front of this jury today. Name one.
I did not cite any in my report, no.
Can you think of one that you didn't cite?
Not that I'm aware of, no.
You had mentioned on direct examination that when you first started looking at materials some time ago, at the beginning, you were unconstrained in the scope of your study. Is that fair to say?
Are we talking about 2023?
Yes, we are.
Okay, yes.
You were unconstrained. You could have done anything you wanted to.
I don't know about anything.
When you said unconstrained, what did that mean?
Well, the agency that retained us didn't ask us to do specific work per se or specific tests.
You didn't do any type of crash test at that time, did you?
Not like was demonstrated today, no.
Instead, you started a working theory that perhaps a glass was thrown at the rear taillight of the defendant's car?
Yes.
Did someone suggest to you that was a theory?
No.
It's just something that you and Dr. Rentschler thought up together?
Based on the evidence that we had, yes.
When you thought up that as a potential theory, that's why you built the potato cannon?
The pressurized cannon, yes.
Yeah, pressurized cannon. And you shot a glass at the rear taillight, yes?
Yes.
You determined that at 37 miles per hour there'd be similar damage?
Yes.
And then you came into court last year, didn't you?
Yes.
And you provided that opinion of consistency to the jury, didn't you?
Yes.
You got up and you said that something to the effect that that speed is consistent with the damage?
Yes.
Now, when you gave that theory last year to the jury, did you know about other evidence in this case? For example, if a glass was thrown at the back of the car, how would the bottom of the glass bounce off the car and land near Mr. O'Keefe's body?
Objection. Ask it differently.
Did you consider, when you came in last year and opined, gave your theory about a glass being thrown at the taillight was consistent with damage, did you think about how, if a glass was thrown at the rear taillight, the bottom would have bounced off the vehicle wherever it was and landed near Mr. O'Keefe's body?
I'm aware that it was found near his body, yes.
And knowing that it was found near his body, well, you knew his body was about 7 or 8 feet off the road, didn't you?
Yes.
Knowing the bottom of the glass, the broken glass was found near his body 7 to 8 feet off the road, did you consider if somebody threw a glass and broke that taillight, cross your mind how would the bottom of the glass bounce with him to where his body ended up?
No, I did not analyze that part of it.
If a glass was thrown and bounced off that car, did you consider how its speaker would be left at the curb?
No, I did not evaluate that.
If glass was thrown at the car and broke the taillight, did you consider how the debris field would end up on the lawn?
Well, it's my understanding, I think that there were plows that came through that night, so I don't know that where the debris field was eventually found, if that's where it would have been at some point earlier.
Did you ever talk to Lieutenant O'Hara or anybody from the state police to see if the plows went all the way to the side of the yards or were just down the middle? Look into that at all?
No, I did not.
So did you give any careful consideration to if the glass was thrown and hit the back of that taillight, how there would be a debris field on the front lawn of somebody's yard?
I don't think that was a part of our scope. It was more or less to determine whether or not, if the taillight was impacted by a projectile like a glass, could you get generally consistent damage to that taillight? That was the objective of the test.
So when you came in and testified last time, you weren't considering all of the other evidence that may not support that theory, were you?
I think our objective was to determine whether or not the damage was consistent with an interaction with Mr. John O'Keefe, and could there be another mechanism to cause the tail light to break.
Is there a reason why you were backing off that opinion on direct examination today?
Objection. Sustained.
You weren't fully embracing that theory today, were you?
Objection. I'm going to allow that.
I don't know if I agree with that.
In this case, you provided reports recently?
Yes.
When did you provide your report? Was it April 6th?
April 6th?
Or was it May 6th?
I think it's May 7th,
May
if I'm
7th.
not mistaken.
So you provided a report May 7th, yes?
Correct.
And do you know when this trial started?
Early April?
You provided your PowerPoint. When did you provide your PowerPoint?
I think it would have been Thursday of this week.
Well, it wasn't last night.
Sorry, maybe Wednesday. Wednesday or Thursday.
Wednesday. Is that fair?
Yes.
In looking at pedestrian accidents, it's important to try, if you can, understand the exact positioning of the body, isn't it?
If a collision occurred, yes.
And if a collision occurred, you can't always identify the exact position of the body, can you?
No, oftentimes it can be very difficult, yes.
You would want to know if it is a collision between a car and a pedestrian, whether the person was fully impacted or it was a clipping type incident. Wouldn't you want to know that if you could?
That would certainly affect the trajectory, yes.
And you would want to know, if you could, the body posture, whether the person was standing up straight or crouching.
If a collision occurred, yes.
Whether they were turning or standing straight or they had their arm out. That's helpful information, isn't it?
It can be, but when we're talking about how quickly this impact duration is, right? If you recall back to the PowerPoint, right, we're talking about a 10 millisecond window. So however the body is positioned at contact, that's how it's positioned. It's not going to be able to have any significant movement or change in orientation in that 10 millisecond window.
The position of the body can change the trajectory of the person who's hit, can it?
Sorry, can you repeat the question?
The positioning of the body, the way they're positioned, that can change the trajectory if they're hit, after they're hit, can it?
It can, yes.
Whether they're moving towards the vehicle or away from it could affect the trajectory, couldn't it?
If they have some relative velocity, yeah.
Trying to determine the point of impact when you're looking at a scene, it's important when you do trajectory studies to know where the point of impact is, isn't it?
If you're going to utilize studies that look at projection of pedestrians when you're contacted at the center of gravity and you get projected some distance, you can rely on those studies, but you have to have an understanding of where the point of impact is and where the point of rest is.
If you don't have the point of impact, if you don't know the point of impact, you don't know the exact body position, that creates variables in your studies, doesn't it?
Well, again, talking about those studies, they're not applicable when you are contacting, for instance, just a limb or you don't have a center of gravity hit. Those when you're talking about how far will a pedestrian get projected, if it's like a forward projection or what's known as like a wrap projection where the pedestrian wraps onto the hood and then becomes decoupled, those studies are applicable there. But when you're talking about where there's minimal overlap between the body and the center of gravity, then you can't utilize those studies.
So you would not want to know where the point of impact is?
In this particular case, no, I don't think it would be helpful.
You would not want to know the body position?
I don't think that it would be helpful in determining, because again, we have to start with, is it consistent with a collision?
So you would not want to know the body position. That's what you're telling us. You don't want to know that.
Well, if the evidence indicates that the contact is inconsistent, then that's kind of where the reconstruction stops. You can't go to a point of impact and a point of rest if there was no contact.
So you don't want to know the body position.
Objection. Can you answer that?
I don't understand this question, Your Honor.
When you're doing studies, you don't want to know the body position?
Objection. Can you answer that, Dr. Wong?
Again, it depends on the type of impact. For the alleged contact in this case, you can't rely on those studies about impact location and point of rest. They're not applicable to
I was
this.
talking about studies as far as data, information. You, as the person doing tests, would you want to know the body positioning?
Objection. This is 5 times. And this time we'll get an answer and that'll be it.
We've got an answer every single time.
Can you answer that, Dr. Wong?
I feel like I've answered it the best I can, Your Honor.
Okay, next question.
You don't like that question?
Sustained. Strike. Jurors disregard.
Okay. When you were doing these video demonstrations, was it important to be as accurate as possible?
Yes.
Data changes if information changes, right?
I'm not sure I understand your question.
That's a tough question. You want to be precise as you can in ultimately having a conclusion regarding data, don't you?
Yes.
Could I have PowerPoint page 12, please? Now look at force on the bottom. The first letter F signifies force, correct?
Correct.
And the last two letters, MA, signifies mass, yes?
Correct.
That's a very important part of that equation, isn't it?
Yes.
If you change the mass, it can change the whole analysis, can it?
I'm not sure I understand your question.
Let me make it more simple. When you did these tests, you chose a arm from a hybrid 3 crash dummy, didn't you?
Yes.
You can take that down, Ms. Gilman. Now, when you made that choice, you knew that John O'Keefe's arm, based on the statistics and his weight of being 216 pounds, you knew that his arm weight would be 11.8 pounds, didn't you?
Yes.
And you knew that he was 6'1" tall.
Yes.
When you decided to choose an arm, in this case, you didn't choose the arm closest to his weight, did you?
It was representative enough, yes.
It was representative enough.
It was close enough, yes, sir.
Close enough. Wouldn't you want to get an arm most closely related to his actual weight?
I don't know that you can have custom-made ATDs.
You probably can't custom make them, but they have one that's 12 pounds. You know that, don't you?
Are you referring to the 95th percentile?
Yes, I am.
Yes.
So there's a 12-pound arm. Mr. O'Keefe's is 11.86 according to the statistics. You know that, right?
Yes.
You looked it up.
Yes.
You didn't tell us that on direct, though, did you?
I don't believe I was asked that.
No. Instead of choosing the 12-pound arm, which is 0.12 difference, you chose a much lesser weight, didn't you?
It was about 10 pounds, yes.
No, it wasn't about 10 pounds. It was less than 10 pounds. Let's be exact. You're a scientist. Let's be as precise as possible when we're talking about data. It was less than 10 pounds, wasn't it?
I think according to the spec sheet, I think it's 9.4 pounds total.
How about 9.38? You keep coming up a little bit. 9.38 pounds.
Sustained in that form.
May I approach?
Yes.
Showing you a photograph. Is that a photograph of your materials in this case?
Yes.
And in that photograph, it shows the arm that you used in your studies, doesn't it?
Correct.
And it shows that that arm weighs 9.38 pounds, doesn't it?
Yes.
And that is less than the 11.86 pounds of Mr. O'Keefe's arm, yes?
Correct, yes.
You didn't put that photograph in your PowerPoint to make it clear to everybody you were using an arm that was a much lesser weight, were you?
No, I didn't put that photograph.
Can we get some evidence, please?
Okay. Any objection, Mr. Jackson?
Board's permission, I'd like to show this to the jury.
Just give us a minute, let Madam Court Reporter mark it.
217.
Yes, now you can play it.
This is the arm that you used in all of your videos, right?
Correct, yes.
And you can see, could you zoom in, Ms. Gilman, on the weight? 9.38 pounds.
Yes.
Right. There's a bigger difference between 9.38 and 11.86 than there is 12 and 11.86, isn't there?
Correct, yes.
So when you do the math, and have you done the math before on this? When you do the math, it's 26% difference, isn't it?
In terms of more force?
No, of mass, weight, 26% difference.
Okay.
Right?
I'm going to trust you, yeah.
Well, do you have a calculator?
I do.
Can you do it?
Sure.
Okay. And before you do that, you took this from a You know, Mr. O'Keefe's 6'1". You used a crash test dummy that, what is the height on it?
Well, the ATD, I believe, is 5'7". The Rescue Randy, I think, is 6 feet tall.
We'll talk about the Rescue Randy later. We have questions about Randy. But let's talk about this. 5'9". You said 5'7". It's actually 5'9".
Sorry, 5'9", yes.
5'9". And it's 170 pounds?
171, I believe.
Mr. O'Keefe's not 170 pounds.
No, not his whole body.
He wasn't 5'9".
Correct.
Okay. So when you do the math and you take the 9.38 pounds based on the 171-pound doll, and you look at the percentage, doesn't it come out to 5.48% total body weight?
Yes.
Okay. And so the difference, when you look at it, it's a 26.3% difference from his actual weight, isn't it?
Correct, yes.
And so I'm probably at the 6th grade level on this, but isn't it very basic that the more something weighs, the slower something has to go to have damage? And if something weighs less, the other part that collides with the force has to go faster?
The force is going to be greater if the mass is greater.
So if you throw a 5-pound rock into a window, you can throw it slower to cause the same damage if you have a 2-pound rock.
I don't know if I agree with that analogy.
So you agree that based on the 26% difference, in order to actually be accurate, to be specific, to be scientific, you then have to adjust the speeds that you presented on your demonstrations, and you have to reduce the speed by 26%.
I don't agree with that.
You don't agree with that. You think that having a lighter arm, so what you're telling us is having a lighter arm would cause the exact same amount of damage to the taillight studies as a heavier arm. Is that what you're telling us?
Well, if you look at, for instance, the 29-mile-an-hour impact test, that's significantly more kinetic energy. So the momentum of a 6,000-pound vehicle moving at 24 miles an hour, 29 miles an hour, that's going to overcome whatever the mass is that it's hitting at that point.
You're sidestepping my question.
Objection. Sustained. Ask a question, Mr. Brennan. Just ask a question, no more.
My question is, are you telling us that having a lighter arm does not impact the damage in these tests as opposed to using the heavier arm?
Certainly not in the field test, no.
And so you disagree that when you look at the weights of those arms, do you disagree there's a 26.3% difference?
Yes.
You disagree?
No, I'm sorry, what was your question?
Do you agree there was a 26.3% difference in the arm weight that you used opposed to John O'Keefe?
Yes, the hybrid arm compared to Mr. O'Keefe's arm, yes.
And you are denying that there needs to be an adjustment to your calculation because the mass, MA, is different. You're denying that.
I think, again, if you're, and this is something Dr. Rentschler, I believe, will
No, I want
touch
to
on.
talk to you. I don't want to talk to Dr. Rentschler.
Well, because when you're addressing the forces for injury and the mechanisms for injury, right, you would account for the difference in the weight.
So you're saying that it makes no difference that you use an arm that was 26% lighter. Is that what you're saying to us?
No, I don't think it would have made a significant difference, especially if you look at, for instance, if you're looking at the 95th percentile hand and the 50th percentile hand, they both weigh 1.25 pounds. They're the exact same weight. There's about a pound more roughly in the forearm and a pound more distributed in the upper arm.
But that's not my question. It's not whether it's significant or not. I'm asking you, are you saying under oath right now that a 26.3% difference had no impact on the calculations in that study? It would have no impact at all?
The calculations, yes, but in terms of the damage, no, I don't think that 1 pound difference, when we're talking about something that's 6,000 pounds, striking something that's, quite frankly, whether it's 9.4 or it's 11 something, it's not, you're not going to get a difference in the damage.
So why don't you have a 3-pound arm up there?
Well, I think that's unreasonable, sir.
What's that?
I think that's unreasonable.
What's the difference? It's a 6,000-pound car, according to you. What's the difference between 26% or 40%?
Well, I don't even know that I agree with your percentage because, again, you're accounting for the whole part of the arm that goes up to here, which we did not strike that part.
It's, how much lighter? 2 pounds and what? How many ounces?
Sorry, what was your question?
How much lighter is it? The arm that you used?
In terms of a percentage?
No, in terms of weight. The weight. 9.38.
Right.
And Mr. O'Keefe, 11.86, right?
About 2.48.
And you're saying that makes no difference? None.
Not in the observed damage at those speeds, no.
Why didn't you use a 5-pound arm, sir?
I'm sorry, what was your question?
Why didn't you use a 5-pound arm?
Again, I don't know that they make a 5-pound ATD arm.
You didn't tell us when you did these studies, you didn't disclose in your PowerPoint that you used an arm that was much lighter than Mr. O'Keefe's arm, did you?
I don't know that it was, I didn't give the weight in the presentation, no.
Let's take a look at some of your testing. The first one was at 10 miles per hour, test A. You remember that test, right?
Yes.
Now, 10 miles per hour, if you had taken 26% off, would you agree it would change the actual speed from 10 miles per hour to 7.67 miles per hour? If you did out the math, if you did it specifically, accurately, precisely, would you agree, using the wrong arm, you make the deductions and the calculations, that that 10 mile per hour test would actually be 7.67 miles per hour? Would you agree with that?
I would allow that.
No, because, again, the arm is going to get accelerated up to that speed. So that the speed would still, that mass would still be accelerated up to 10 miles per hour. Same thing in the vehicle testing. It's going to be, given that weight difference, it's going to be accelerated up to that speed.
Now, can we see the video of test A, please? Now, this is your study, 10 miles per hour, you claim, with a arm that is 9.38 pounds, correct?
Correct.
Mr. O'Keefe, 11.86 pounds, yes?
Yes.
Yes. Okay. Now, this light on the end of this, you're trying to replicate the light on the back of a Lexus?
Correct.
If a Lexus at 6,000 pounds hits a person, the Lexus isn't stopping automatically, is it?
No, it would move at a common velocity with the arm.
It would continue to push forward through the arm, yes?
It may, yes.
And the arm can push into the light before the body turns, yes?
I don't know that I agree with that, no.
If the light on the Lexus, not at this speed, but if the light on the Lexus was broken or breaks and it hits the arm, it's not going to bounce off the arm, it's going to push through, isn't it?
It's going to move at a common velocity with the arm.
And that will move not only the arm, it will move the person's body, won't it?
It may, yes.
It may push the body, it may throw the body.
I don't know about throw.
And the light, if broken, will continue to press against the arm until there's separation. Isn't that fair to say?
It could. In some instances, again, it could bounce.
It could, because it's not always the same. It's a dynamic process, isn't it?
It is dynamic, yes.
You could do the test many times and get very different results, couldn't you?
I don't know that I agree with that.
Would you get the same result every time?
I think you would certainly get similar results.
Every time?
If you had the exact same impact location and speeds, yes.
Well, that's my point. What if the impact location moved a little bit? Could it change?
Well, is Dr. Welcher changing? I don't know if, again, I was relying on what he provided in his report.
This isn't on Dr. Welcher. I'm asking you.
Objection. It is on Dr.
No, it's not.
Okay, so jurors, disregard that exchange between counsel. Next question.
If the body position changed, you may get a different result. Isn't that fair to say?
I was going after what Dr. Welcher had represented in his report and analysis. So we did testing to analyze his orientation that he had demonstrated in his report.
You don't like that question either?
Objection.
Sustained.
If the body position changed, it could change the result. True?
I don't know what you mean by body position. Do you mean the whole body, the arm? What part of the body?
Okay, let's start with the arm. If the arm position changes, it could change the result, couldn't it?
Well, I'm not aware of any other orientation that Dr. Welcher provided in his analysis report as to alternative orientations.
If the arm position changed, could it change the result?
Yes, I mean, I presume if you don't have your arm on the taillight, then yes, you'll probably get a different result.
What if it's bent in a different way? Could that change the result?
Again, I haven't reviewed anything that indicates that there was a different orientation that Dr. Welcher suggested.
You're a scientist, right? You can think. I'm asking you. Just a general question. Over here. If you bend the arm, could it change the result?
It could.
Thank you. Okay. When a pedestrian is struck, they are not held stationary on a harness, are they?
No.
In this case, the crash test dummy is on a harness?
Yes, he's supported.
Strapped?
Yes.
By its hips or pelvis?
Yes.
That's not real life. That's not how a pedestrian is usually when they're hit, right? They're not strapped to a harness, are they?
No, and again, the purpose of this test was to evaluate the arm. We're not looking at the whole body here with this test.
And when we talk about injuries, part of injuries is not just the impact, it's the drag, in this case, from the car, isn't it?
It could be, yes.
But when you put the dummy on a harness, restricting or restraining its movement, it is not going to replicate hitting somebody and their movement, including the drag, is it?
I don't know that I agree with that, because it will replicate, again, when we're talking about that impact pulse of 10 milliseconds, it will replicate that. And that's ultimately what we're after, is what's happening in that 10 millisecond window in terms of the contact and the damage and the acceleration.
I know that's what you're after. What I'm asking you is when you end it, when the light stops, unlike a Lexus, and the dummy is stationary, unlike a person, it affects the aftermath, the drag and the push after, doesn't it?
Yes, the kinematics would be different, likely, if it's not restrained like that.
In real life, a pedestrian usually is not restrained, are they?
Correct.
In real life, a 6,000-pound Lexus, upon contact with an arm, doesn't usually stop on a dime, does it?
No.
Could I have the photo from test A, please? And so there is no break, but there is a crack in this light that was a result of this experiment where this light hits that restrained dummy, yes?
Yes.
And this is at 10 miles per hour in your world and 7.67 if you take off the 26% weight.
Objection.
Sustained as to that form.
If we can move to test B, please. Now this test B, a similar test, it has the same limitations, doesn't it? This dummy is restrained at the pelvis.
Yes.
Could you show the video, please? There's two videos. We can see the first one. And was the dummy restrained by its head as well?
Yes.
Was its arm restrained in any way?
It was tethered, but it was free to move.
This test you have is 17 miles per hour with the arm that's 9.38 pounds. Mr. O'Keefe, 11.86 pound arm. If you consider that 26% difference, wouldn't it be fair to say that this test, rather than replicate 17 miles per hour, would actually replicate 12.6 miles per hour?
Objection.
No, can you answer that?
Not the way it's phrased, no.
And so looking at this test, test B, which you say is 17 miles per hour, can you do a calculation for the 26% difference, or is that something that you don't think is fair?
I don't think that'd be a fair way to characterize it. Again, if no matter what the mass is there, if you're accelerating it, if you're impacting at 17, that arm is going to move at 17.
Well, not just the movement, the damage. If this arm was 5 pounds, do you think the test would have the same exact result?
If it's 5 pounds?
Yes.
Probably would be less damage.
It'd be less damage. So to get this amount of damage, you would have to increase the weight, right?
Sorry, what was your question?
To get this amount of damage, you couldn't use a 5 pound arm. There would be less damage with a 5 pound arm.
Correct.
Right, because the less weight you use, the less damage at that speed. That's basically how it works.
Correct.
Okay. So, in this test, if we could run that back again, you have a restrained dummy at the hips and the head. There's no follow-through of the light or the body that's attached to that arm, correct? And at this speed, you can see the shards of taillight. You can see them move, can't you?
When you say move, you mean just
Not stationary.
Yeah, I mean they're moving from the taillight as they break.
Detached from the taillight.
Correct, they're broken.
That could create a debris field, yes?
Yes.
And you can see them floating in the air, some of them actually floating and then touching the sweater. Do you see that?
Possibly. Some of it might be, again, some of that polyurethane foam.
Yeah, some might be. And why don't we play it again so we can see clearly? Some might be taillight shards too, right? That black object spinning, that's not poly foam, is it?
No, it would not be.
That'd be taillight shard, right?
Correct.
And so, even at this speed, you can see in this type of collision, there is significant, bless you, significant amount of taillight shards that are broken from the taillight and spewed into the air, yes?
Well, I think on the one of the slides I had, I think I showed the fragments that were left, and from what I recall, I think there was 4 pieces from the taillight, from the lens.
If you could put that back a little so Dr. Wolf can see it again, to the point of the collision. Even at this speed, go ahead. Stop. You can see pieces, large, small, medium, maybe even microscopic, are now breaking off from that taillight and being littered into the air, aren't they?
Yes, there are pieces coming off.
If we can go to test C, please. Now, in test C, you actually use only an arm. Isn't that fair to say?
Correct.
You don't use a body or a crash test dummy.
No.
You don't, in fact, this is not the 12-pound arm either. This is the 9.38-pound arm.
Correct.
And when you do this test, you have the arm. It's basically just an object suspended in the air, isn't it?
Yes.
And you said, I think on direct examination, I think you said that this is the same as if it was on the dummy. Is that your testimony?
Well, in terms of, again, the amount of weight that would be interacting with the taillight, whether it's attached to the dummy or not, what's in direct contact is going to be the same.
Well, the fact that it's just floating up in the sky like that, it's very different than if it was attached to a person or a dummy, isn't it?
In terms of how it moves immediately after the impact, yes.
Not just how it moves, as far as the impact. Isn't it different?
I don't know that I agree with that.
Okay. Well, wouldn't you say that in addition to the arm, if you had another 200 plus pounds being held down by gravity, that would affect the force that's acting on the arm?
Well, the arm, again, is going to be accelerated, but the center of mass of the body is not going to see that acceleration.
Have you testified before in this case about the importance of the full body and gravity?
I'm sorry, what was your question?
Have you testified before in this case about the effect of gravity and the full force of a body as opposed to just an arm?
Yes.
Okay. And do you remember whether you thought it important on a previous time you testified that there was significance to the arm would be attached to a 200 plus pound body and there was the issue of gravity that would affect force?
From what I recall, I think that had to deal with whether or not the pedestrian would be projected based upon an interaction with the arm or a full-on center of gravity hit, right? When we're only hitting the arm, we're not hitting the CG of the body.
You did test B, and you claim it was at 17 miles per hour, test B.
Correct.
And we saw the damage. This is at 15 miles per hour, test C. Could you play this, please? It might be a delay, so you could fast forward a little bit, please. How many times do you think that arm spun around?
I don't know.
That's not what would happen to a person who got hit. Their arm wouldn't spin through their body like that, would it?
Correct, it
Their
would
arm
not.
wouldn't spin that many times.
No.
There'd be the pull of their body weight, yes?
I'm sorry, what was your
There'd
question?
be the pull of their body weight.
The body weight, yeah, would affect the movement afterwards, yes.
Gravity, yes?
Yes.
Yeah. And so there's a reason why you do this test at 15 miles per hour. Is there a photo related to this, to the damage to the taillight? There is a reason why at 15 miles per hour the damage is much different than the other tests at 17 miles per hour, isn't there?
Correct.
Right, because at 17 miles per hour you have a dummy that is strapped by a harness in its pelvis. When it's hitting the arm, it's affecting it much differently than just a arm floating in air. Yes?
No, I don't agree with that. The primary reason there's a difference in the damage is because of the amount of the arm that's outstretched and interacting with the taillights. There's a difference in those two tests.
Mm-hmm. And so the body and the weight of the body, you're saying, has nothing to do with the amount of damage?
Not in these tests, no.
So when somebody gets hit, does the body weight have anything to do with the damage? Not just the area that gets hit. Does the body weight affect it at all?
Not in terms of the impact. Like the rest of the body, it's not going to matter if, for instance, only my hand, like in that last test we just saw, it was the hand and the wrist. How much my stomach weighs, my head weighs, is not going to affect the damage to that taillight in that interaction.
And by the way, this test, you said 15 miles per hour. If you consider the 26%, you're only at 11.1 miles per hour. Is that the right math?
Again, I don't agree with that because if you look at the data and you integrate the acceleration data to get the speed, right, that we saw in those plots, the hand basically gets up to, I think it was 14 or 15 miles an hour. It reaches that common velocity of the vehicle.
Let's go to test F. On test F, you placed the dummy more behind the vehicle, didn't you?
Correct.
And when you test it, you put it more behind the vehicle. This is more of a full impact than it is a clipping, isn't it?
Certainly, yes.
And when you put this dummy behind the car, this was not a legitimate crash test dummy. It was a different type of dummy, wasn't it?
Yes, it's called a Rescue Randy.
A Rescue Randy. And that is not typically the type of dummy that you're going to use for crash tests, is it?
I wouldn't agree with that.
When you did the Rescue Randy in crash test F, did you use the 12-pound arm or did you stick with the 9.38?
The hybrid arm wasn't attached to the Rescue Randy.
The hybrid arm was not. Is that what you said, or it was?
It was not. No, not in the full impact test.
Okay, so what was the weight of the arm on the Rescue Randy?
I don't know specifically the weight of the arm. I know that the total mass of of the rescue Randy was 200 pounds.
Isn't the weight of the arm important when you're talking about impact with the arm?
I don't think relative to the rest of the mass of the body.
So now the mass of the body counts, but before it didn't.
Objection.
Sustained enough.
Okay. If we can see in test F, we have some photographs. Start with the first one, if you could widen that, please. Now, this is a direct hit.
Correct.
Okay. Is this simply a photo or a video? Could we go to the next one, please? So the rescue Randy's placed much further in the car than the other type of test that would be more similar to a clip, yes?
Correct.
Next photo, please. Okay. And that is the result of the impact?
Correct.
Do you see the debris field?
Yes.
Is it near rescue Randy?
Some of it is, yes.
Yeah. It's spread out a little bit, yes?
That's fair, yes.
But it's not right on his body. It's a distance from his body, yes?
There may be some, I can't tell from this photo, there may be some around his body, but yes, there's also debris close to the Lexus as well.
And could we, and this is the demonstration where you didn't turn on the videotape, so we don't have a videotape?
Correct, we had the false start, yep.
What's that?
We had the false start.
The false start. Is there another picture after this? Those clothes. Are there holes or tears in the clothes?
Yes, there's damage that's consistent with road rash when clothing or a body makes contact with the pavement and is grinding into the pavement.
Pavement's hard. Right?
Yes.
How about frozen ground, frozen dirt?
Is that hard?
Yeah.
I suppose it can be.
Well, do you have any doubt whether frozen ground in the Northeast in the winter is hard as a rock?
I haven't done any analysis to assess that.
And so seeing holes in those clothes is what you would expect after Randy hits that hard ground, right?
Mm-mm.
Are you talking about frozen grass?
It's on the surface.
We're talking about Randy right now. These holes in the clothes are what you would expect after Randy hits the hard ground, correct?
Objection.
I'm going to allow that. Is that what you'd expect?
Your Honor, I need a motion.
All right, jurors, feel free to stand up.
It
and
would
stretch.
depend on what Randy slid across when Randy landed on said surface. End of story. Randy slid on the freaking asphalt, therefore getting holes in the clothing versus a tiny hole from an exploding taillight lens. Just give me a fucking break. Like, y'all, it's getting toward the end of the day. I'm like this late. Hank, oh my God. You're like that doctor that's a really good doctor, potentially, but has a horrible bedside manner. That's Hank Brennan. You got potential because you asked the right questions. God damn, you're an asshole, man. Asshole, straight up. Yeah, they can keep bringing up that card hold ground.
So holes in the
They got me
clothes
flustered.
is
Hold
what you would
hard
expect
ground or floor.
after Randy hits the ground, yes?
If there is prolonged sliding contact with the asphalt, certainly you could expect to see tearing, large holes, material fraying, and even transfer of pavement material onto the clothing.
You've done no studies on hard ground like a front yard, have you?
In terms of a pedestrian sliding on the grass?
In clothing tears, yes.
No, sir.
Frozen
And if you could
grass
go
will
back
tear your
one slide.
clothes.
You see the debris field is near but not on Randy? Can you tell if there's any small pieces or microscopic pieces on or in Randy's clothes in the study? Did you look?
No.
Right, butterfly?
If I could go to test E, please. Test E you cite as having a speed of 24 miles per hour, correct?
Correct.
And that's with a arm that is 9.38 pounds. Yes?
Correct.
And to remind you, Mr. O'Keefe's arm would be about 11.86 pounds. Yes?
Correct.
If you would reduce 26%, you'd be at 17.8 miles per hour, wouldn't you?
Objection.
Are you doing the math, Dr. Wolf?
I don't agree with his characterization, Your
Okay,
Honor.
next question.
I understand you don't agree, but if you took 26% off
She
to
said
24
next
miles
question.
per hour, you would come out to 17.8 miles per hour, wouldn't you?
I'm going to allow that. I'm going to allow that.
That's what the calculation would yield.
Okay.
What's wrong, Bev?
On test E, there are some differences between your test and what would happen in real life. For example, there is a harness, correct?
Correct.
And the harness prevents the dummy from being thrown naturally.
Correct.
The harness affects your ability or one's ability to see the study and see what the trajectory would be after impact, correct?
Well, that wasn't the purpose of the study, to assess the trajectory, sir.
I understand. I'm not trying to criticize, but it affects the ability to see the trajectory when the dummy's on a harness, doesn't it?
Yes.
Could we put up the first video on this, please? A photo 115, if we can start with. If you could stop it right there. And you can see the feet aren't as firmly planted on the ground as a person would be in most circumstances because of that harness, yes?
Correct.
And that affects gravity, doesn't it?
Affects gravity?
Well, when the car hits, the gravity, the weight of the dummy is less because it's held up by a harness, isn't it?
No.
Right. So gravity really is suspended at this point, just above the ground.
The arm that's extended, is there a glass
Wade doesn't
in that hand?
understand the assignment.
No, there's not more weight in the hand.
So there's no object in the hand in any of these tests?
No, because ultimately what would happen is, because of the accelerometer being mounted on the palm of the hand, if you had a glass there, it would interfere with those measurements.
I understand why you didn't do it, but would you say it's fair to say that if a glass was in the dummy's hand on these tests, it could affect or change the damage?
Well, if you add another, I think that the drinking glass we utilized for the testing last year, I think was 0.7 pounds. So if you add another 0.7 or pound to the hand, that hand contacts the liftgate taillight, you certainly could see damage to that taillight, which we certainly didn't see on the subject vehicle.
So weight does kind of matter, right?
It can, yes.
Not just 0.7 pounds, the 2.5 pounds can matter too. Weight matters.
Yes.
Because that's kind of what we were talking about for the last half hour. Weight matters in these tests, doesn't it?
Correct, but you can't look at this in isolation, just between damage, and you can't separate it from the injuries, right? What's going to happen to the body in terms of the injuries in a 24-mile-an-hour impact?
Does weight matter?
In terms of the force?
And so we see this dummy with the arm stretched out, correct?
Correct.
Okay, can we bring this back?
Hank, you understand this was to demonstrate if the arm busted the taillight, not where
Stop
the
right
man's
there.
body landed up by the flagpole situation.
This isn't approved crash
So
test
stupid.
dummy, is it?
The Rescue Randy portion, no.
No.
It's not instrumented like a hybrid.
Is the arm the hybrid 3?
Yes, the arm is the hybrid 3.
So you took, in test F, you didn't put the hybrid 3 on the Randy, but on this one you did?
No, because you risk these AT devices can range from $100,000 to $150,000, and you run the risk of destroying that equipment in a test like that.
So in test F, did you put the hybrid on the Randy, or did you keep Randy's original arm?
It's just the Rescue Randy in the last test.
On F.
Correct.
This one, you have the hybrid arm on Randy.
Correct.
So you're switching up between tests what pieces you're using, aren't you?
I would say adding,
Right?
but
two.
adding and subtracting. It doesn't have two arms. There's one off, one on.
Fletcher
One's
didn't want to
Randy
get
and
hurt,
one's
remember?
Hybrid. So you're switching.
Yes.
Different result.
I'm not sure I understand your question.
Okay.
Are you trying to say a different result between test F and this test? Because they're not the same test.
Oh, I understand. I understand. If we can have this come back a little bit more. Okay, and let it run. Stop. You can see the shattered taillight moving, and most of it's moving in the same direction, isn't it?
Yes.
And that's what creates a debris field after a collision, doesn't it?
Yes, I mean, components will break off and fall to the ground, yes.
Mm-hmm. Now, since Randy is on a harness, he's not going to be thrown the same way as it would happen in real life, is he?
Correct, and that wasn't the purpose of this test, sir.
understand. When you chose 24 miles per hour without the 26% deduction, which would make it 17.8 miles per hour, when you chose 24 miles per hour, it's because you had looked at the text stream data that had been taken from the defendant's Lexus, right?
Correct.
And when you looked at that data, you understood that during that event, 10 seconds of data is captured, yes?
Yes.
But that doesn't define the whole event, does it?
That only encompasses what was recorded.
And you said you chose 24 miles per hour because that was about the speed at the end of that 10 seconds.
Correct.
You do realize at the end of that 10 seconds, the car, the defendant's Lexus, was going faster. It was still accelerating, don't you?
Objection.
I'm going to allow it.
From what I recall, the last data point, I believe the throttle was still at around 74%.
Well, ARCA specializes in text stream data, don't they?
Yes.
Okay. So you are looking at that, you would agree that at the end of the 10 seconds, the defendant's Lexus was increasing in speed.
Well, we don't know, again, beyond that data point what the data is.
At the end of that 10 seconds, the car was going up, not down, in speed, yes?
Correct.
And you can't tell how much longer that car traveled for after that 10 seconds, can you?
Correct, we don't know.
So when you chose the 24 miles per hour, it was just based on a data point. It wasn't based on you believing that there was an impact at a certain speed, was it?
No, and the triggering event itself it's not a collision by definition, and nowhere in that data can you parse out whether or not any contact even occurred.
We know that.
Okay.
The point is, you can't tell how fast the vehicle was going if it was in a collision from that data, can you?
Sorry, can you repeat the question?
If that vehicle was in a collision, you wouldn't be able to tell from that data what the speed was at the time of the collision.
If contact allegedly occurred at some point in that data set, no, you would not be able to pick a row in that data and say, this is where the collision occurred.
Or after that data set, you would have no idea.
Outside of the data?
Yes.
No.
Okay. And so when you look at this experiment that you did, if you were to add, you said 24 miles per hour, but that's not considering the 26%. If you were to add 7 more miles per hour to this collision, would you expect more damage to that right taillight?
Potentially, yes, but you're certainly getting into the realm of injury at that point.
I'm not asking about that. I'm asking you a simple question about damage. If you were to add 7 miles per hour onto this test here, would you expect more damage to that right rear taillight?
Yes.
Okay, can you finish the video? Okay, now I want to ask you some questions. You can stop there. I want to ask you some questions. Can you bring it back to right before the collision, please? Speed changes the result of this, doesn't it?
In terms of the impact speed?
Yes, the impact speed can change the result of this, of the damage to the right rear taillight, can it?
Correct.
And the angle of the arm can change the damage to that right rear taillight, can't it?
It can, yes.
Did you take any pictures of the debris field after the impact and damage in this Test E? Did you take any photographs of the debris field?
I believe so, yes.
Was it included in your materials that you provided us?
It should have been in all of the test materials that was provided, yes.
Was the debris field within a certain range? Was it within a certain circle, 10, 20, 30 feet?
That sounds about right.
And so a debris field, although it might scatter, it almost forms kind of a ring, doesn't it?
It can, yes.
And it can form that ring away from where the body lands, can't it?
It can, yes.
And in this test, which you say is 24 miles per hour, without the reduction to 17.8 miles per hour, in this test, upon impact, there is a number of pieces of taillight that shatter, isn't there?
Yes.
Did you count how many?
About 19 pieces.
19 pieces. Could you move forward just a little bit? And when they break and scatter, some of them go up, some go down. Stop, please. Yes?
Correct, yes.
Some of them come in contact with Randy's arm. Yes?
Correct.
Now, Randy being on a harness, it's not like real life when the Lexus goes by, could continue to push him with it, right? He can't go with the car or the Lexus because he's on a harness. Yes?
Correct. He's not going to move from that position.
If you can move forward, do you see Randy's feet?
Yes.
See the right foot?
Yes.
It's twisting, right?
Correct.
Turning. Stop. Could you show the photo of the sneaker, please? When you were reaching your conclusions that you offered to the jury today, did you consider this photograph?
No.
Did you know that this sneaker was up against a curb in the area?
Yes.
And you didn't consider this at all?
Wasn't a part of my analysis.
Okay. You can go back to the video. You see the spin and rotation on the foot?
Yes.
Can you keep going? And the turn of the sneaker?
Yes.
Okay. I want you to go back, Ms. Gilman, please, to the point of impact. In your studies, you would agree there can be a clip of a pedestrian that causes significant damage to a taillight where the pedestrian incurs no lower body injuries whatsoever. That can happen, can it?
Well, I don't know that I would describe this as a clip to the arm. This is a full-on impact to the arm, so it's not a clip. Again, you saw at the 15 miles per hour. I think that's more analogous to a clip or a side swipe where the arm just kind of gets brushed out of the way. This, I would say, is a full-on impact to the arm.
Okay. To use your words, in a full-on impact like this, a pedestrian could be involved in a full-on impact causing that amount of damage to the taillight that's reflected in this video, but suffer no lower body injuries. Isn't that fair to say?
I don't address injuries, sir.
Well, let's play it forward. Do we ever see Randy's knees hit the car? Hips? Ribs?
I see the foot getting run over, but I don't think there was contact with the legs, no.
Would you agree that a pedestrian could be in this type of collision and suffer no lower body injuries based on your presentation here?
Sir, I don't address injuries. Biomechanics is not my area of specialty.
You said it's common in vehicle-pedestrian collisions that there is some type of bumper displacement. You
Correct.
said that?
Yes.
Okay, bring it back to the beginning, please. Stop. Any bumper displacement in this collision?
In this specific test, no.
You said that on direct you would expect that there would be some panel deformation. What does that mean?
So if for instance, let's say the hand is not contacting the taillight or a portion of it is contacting the lift gate, you could see deformation to that body paneling.
You said that you would expect to see, not that you could. What you said on direct is you would expect to see panel deformation.
Yes.
And you said in this case there was none, right? Talking about the defendant's Lexus. You said, I would expect to see panel deformation, and in this case, the defendant's Lexus, there was none. That's what you told us on direct.
Correct.
Let's watch E. Let's watch your video. Play it ahead. Is there any panel deformation? Stop. In this?
No, sir.
Okay. So when you said on direct examination, relative to the defendant's Lexus, you would expect panel deformation, there was none. There are examples, one that you gave us yourself, where there is a collision causing this amount of damage to a taillight where there's no panel deformation.
I'm going to allow it.
Right?
If I recall, I think you're referring to my prior testimony in another proceeding where I had not conducted this testing yet. So ultimately, that's part of the reason why this testing was conducted, to evaluate that.
In this case, the damage to the right rear taillight, there's no panel deformation here, is there?
Correct, there is not.
When somebody is wearing a hat and they're involved in a collision similar to this, can their hat fall off?
Potentially.
Did you look at photos? Is there a photo of the hat, Ms. Gilman? Before you came to your opinions and conclusions, did you look at this photo and see a hat on the grass?
I did review this, yes.
And did you give any consideration when you did your tests to whether the hat would come off Randy or any crash test dummy when you hit it at that speed?
No, that wasn't a part of my evaluation.
Could I have photo 77, please? What's that, sir?
So I don't know if you'll be able to see it in the photograph, but there was some material transfer from the jeans that the rescue Randy was wearing.
And so as a result of that impact, there was scuffing from Randy's jeans onto this exemplar Lexus.
There was scuffing, yes.
Did you look at the defendant's photos of the defendant's Lexus to
Yes.
see if there was a...
Sorry.
It's okay. To see if there was any scuffing in a very similar area?
I don't recall it being at that portion of the vehicle close to the rear wheel.
Where did you see the scuffing on the defendant's Lexus?
I think there was some scrapes along the wraparound section of the bumper cover.
The bottom part?
Correct.
It's not claimed that's attributed to the collision, so I don't want you to consider that. But did you see other scuffs a little higher up on the Lexus?
I did, but I don't know that those could certainly just be normal wear and tear to the vehicle.
Is that normal wear and tear?
This, no, because we observed it in the test.
Could I have photo 153, please? Now, this is a photo without the hatch back up. This is just the lighting fixture, right?
Correct.
And could you close up in on that? And you would agree if you went 7 miles per hour faster, it would cause more damage to that, wouldn't it?
Yes.
When the taillight is shattered and it spreads through the air, does it have the potential to impale a person, for example, on their nose?
I'm sorry, can you repeat the question?
In your test, you saw that upon collision, there was a scattering of taillight that broke from the fixture, correct?
Correct.
Would those shards, as they float or fly through the air, would they have the ability to impale a person on their face or even their nose?
I think that would be unlikely.
And finally, we've discussed, you now would agree with me that weight does matter, doesn't it?
It can if it's significant, yes.
I have no further questions.
All right, Mr. Jackson. Yes.
Can we, Dr. Wolf, go back to your do you have your PowerPoint
Yes.
set up?
Your Honor, may I?
Yes.
You have that ready?
Yes.
Can you go forward, and I don't have them memorized, so bear with me. Can you go forward to test E? And I'm going to ask you a couple of quick questions.
Okay.
Okay, if you could scroll through, keep going, if you'd please, to the next slide, the next. Can you, is this a video or is this a still photograph?
It is a video.
Is this at full speed or is this slow?
This is full speed.
Okay, can you go to the next slide? Okay, go back one. This is a test at what speed?
This is the Lexus moving in reverse, contacting at 24 miles an hour.
All right. Let's go ahead and play this at full speed if we could. Dr. Wolf, can you, that's awfully fast. Can you get to a point where you're moving frame by frame just at the point of contact?
Am I able to display my screen without doing the... I'm trying to see how I can get this to work.
Oh, Bev won't allow that, sir. Y'all just...
If you could just move
Dr. Wolf, a
forward
second.
frame by frame rather than...
I don't know that I can in the...
There's Mr. Wolf and there's Dr. Wolf.
Oh, I missed it.
Okay. It may be more difficult than we thought. Let me ask you a couple of questions
Sure.
based on that. Did you review that video in slow motion as well as at full speed?
Yes, from a frame-by-frame perspective.
And in terms of a couple of different questions about that particular test, when there's impact with that right arm, what's the speed that the arm gets to upon impact?
In test E,
Right. If the car's going 24 miles an hour, what's the expected speed of the arm?
so the hand got up to a little over 24, the arm got a little over 21 miles per hour.
The debris that comes off of the taillight, the fragments, what speed would they be going at the point of impact when they crack and are released from the taillight?
At the impact speed or less.
In order to penetrate the sweatshirt and cut the arm across, would the shards have to be going faster or slower than the arm?
They would have to be going faster. If they're moving at a common velocity with the arm relative to it, they would somehow have to accelerate with more speed to catch up and go beyond the arm, essentially.
Is that physically possible?
No.
I also want to ask you about do you have in your PowerPoint the photographs of the sweatshirt at the what you call the full-on impact, test F, as in Foxtrot?
I don't have any of those in the PowerPoint.
Okay. The photo that you showed, if I could ask Ms. Gilman to show the same photograph that she showed earlier of the subsequent to test F, as in Foxtrot, with the holes we see.
If she can.
If she can.
Can you do that, Ms. Gilman?
Very kind.
Thank you.
Dr. Wolf, you're shown just the left arm underneath the, whatever you call the dummy, Randy, right?
Yes.
Did Mr. Brennan show you the rest of the sweatshirt?
No.
What did the rest of the sweatshirt look like after this full-on impact when he was launched on the asphalt?
Mangled. So there was not only significant road rash to the clothing all over the torso section, the left arm, the right arm. There was holes in many different locations of various sizes. There was also just on the skin of the dummy, there was road rash on the face had been scraped. The torso had been scraped. So there was significant body damage to the torso as well.
Taking just the sweatshirt, separating that out, what about the bodice of the sweatshirt, the front of the sweatshirt? Were there holes and frays and damage to the front?
It was covered in all of those, yes.
What about the back of the sweatshirt? Did that also have damage?
I don't believe the back, because I think he fell onto his stomach.
What about the other arm?
Yes, both arms did.
Were the holes and frays larger than the holes, the puncture holes that you saw on John O'Keefe's sweatshirt?
They were certainly larger and, again, spread out amongst the entirety of the sweatshirt, at least on the front side.
Was the damage to the sweatshirt that you saw in this experiment consistent with the damage or defects that you saw in just the right arm, those 9 puncture holes on the right arm of the sweatshirt of John O'Keefe?
No, this is distinctly road rash. There's a clear distinction between the two.
Showing, looking at this particular set of defects in the arm, is that misleading in terms of its comparison to John O'Keefe's sweatshirt?
Objection.
Sustain.
Your Honor, I'm going to ask to approach very briefly on an issue we discussed earlier.
Oh, man. I'm multitasking. Oh, goodness gracious. Yeah, so Dolphin, do you notice that too? How when they were doing the doing the test, how when the arm impacts the taillight, when it did break, it went into a couple of large pieces, not burst into 50 pieces that randomly flew everywhere.
Oh yeah, I was paying attention to that as soon as
Yeah.
they showed it.
You could see it in the first time around when they were showing it earlier, and then again when they showed it a few minutes ago. But I think Hank's missing the point of the experiment.
That's because he's pissy. That's what his
He
problem
is
is.
so pissy, girl. I can't with this guy. He is he's got a bad disposition. He's just
Yep.
is this a show for court, or is he just naturally like that? I think he's just
He's probably
naturally.
naturally like that.
I get that as well. Otherwise, he would be able to contain himself in court, and not be an ass in front of the jurors. But he doesn't seem to be bothered by it.
Yeah, she doesn't either, which kind of makes me mad. I'm just like, what is going on with
Yeah.
her?
So if we're gonna go with the corruption angle, is she on the take somewhere down the line? Has she
Yeah.
been on the take for years by the mob, by the whoever's, the dealers, the whatever, you know, the gun movers, you name it, whatever's out there doing their thing. Anybody can pay off a high powered or a judge or any law enforcement, anybody to
Yeah,
work in their
she's looking like
favor.
somebody on the take to me.
Yeah, she's giving off that vibe, isn't she?
May I, Your Honor?
Yes.
She better watch out. The feds are nosing around.
You were asked on cross-examination about some of the work that ARCA does on behalf of private lawyers, even insurance companies, correct?
Correct.
You were not hired by an insurance company. That's not who hired you on behalf of Ms. Reed or anything like that in the initial hiring, correct?
Correct. It was not an insurance company.
Thank you. A couple of more questions, if it's okay with the court, Your Honor, before we break.
Okay.
Thank you. You were asked several questions about the glass and whether or not the glass weighed in on your analysis of the damage to the rear tail light, correct?
Correct.
Did you consider that the glass on the rear bumper did not match the cocktail glass that was found close to John O'Keefe's body? Or were you aware of that?
I don't think initially I was aware that there was a difference between the glass cup that was found and the glass on the bumper.
You were asked a lot of questions about the difference in the weight of the arm, and I'm going by memory, 11.8 pounds statistically as it relates to Mr. O'Keefe versus 9.4 pounds. Have I got that right?
Approximately, yes.
Okay. Are you aware that anybody has ever measured the weight of just John O'Keefe's right arm?
I'm not aware of that, no.
When you were asked questions about whether or not his arm weighed 11.8 pounds, are you ever aware of anybody ever weighing just his arm?
No.
What is that based on? 11.8, where'd that come from?
I don't know.
Mr. Brennan mentioned the word statistic. Based on the statistics, his arm would weigh that much. Height, weight, etc.
Correct.
Does the statistic determine the actual weight of an arm?
No. Not conclusive of what Mr. O'Keefe's arm weighed, no.
As you sit here, do you know whether his arm, John O'Keefe's right arm, if weighed by itself accurately, because pounds and apparently half pounds matter, if it weighed 11.8 pounds or if it weighed 9.4 pounds? Do you know?
I don't know, no.
Do you believe that your testing, the totality of your testing, was dependent upon those 2.5 pounds based on the weight of the hybrid 3, or at least the arm of hybrid 3, and the statistic of 11.8 pounds?
Sustained.
In what way does that differentiation of 2.5 pounds or approximately 2.5 pounds, in what way does that make a difference in terms of your testing?
It doesn't, and that's part of the reason why we increased the speeds to almost 30 miles an hour to look at again, when you're bringing that much more kinetic energy from the vehicle, that's going to overcome any mass that that arm has. If it, like I said, if it's a pound difference, 2 pound difference, the momentum of that vehicle moving at 30 miles an hour versus 24 miles an hour, again, kinetic energy is equal to 1/2 times the mass times the velocity squared. So even if you go up a few miles per hour, you're exponentially increasing that amount of kinetic energy from the vehicle.
You were also asked a series of questions about reducing the speed of the testing by a certain percentage. Remember those questions?
Yes.
Did that make any sense to you mathematically?
Yeah. Sustained indefinitely.
What effect, if you could tell us, well, let me ask it this way. Is the speed of the testing vehicle tethered in some way to the difference of that 2.5 pounds that Mr. Brennan was asking you about?
No, and again, as you saw throughout the PowerPoint, when that vehicle is coming in at 24 miles an hour, 29 miles an hour, at those speeds, that arm, when it makes contact, is going to get accelerated up to that velocity. It's just going to reach that common velocity. It's not going to, you're not going to somehow affect the vehicle speed due to that, the fact that the arm weighing 10 pounds roughly, and you've got 6,000 pounds. It's not going to somehow scrub off speed of the vehicle.
Thank you. Your Honor, at this point, I would be going through a couple of photographs and videos that might be a good place to...
Okay, I understand you said it's on. So we'll stop it today. Dr. Wolf, you have to come out in a minute. All right, jurors. One question I have for you. So I know a long time ago we told you that Thursday would be a half a day. I'm told that we're nearing the end of this case, so I'd like you to think about whether you're able to stay all day next Thursday. Think about it over the weekend. If you've made appointments or anything like that, I'm not asking you. But think about it, and on Monday, if you let Tony or Paul, whoever's with you Monday, if you have an issue with it, just let us know, and we'll do that. All right, so please do not discuss this case with anyone. Don't do any independent research or investigation into this case.
This is going to the jury about Thursday morning.
If you happen to see, hear, or read anything about this case, please disregard it and let us know. And again, be very careful with your social media use. Have a great weekend. Thank you.
All rise to the court, please.
So, I wonder, does the defense feel ARCA alone is strong enough to be their closeout witnesses? Are they literally not going to call Jen McCabe back or anybody within that home, right? At this point, because of Hank's attitude toward the defense witnesses, the way he treats them, I would, out of vengeance, call them bitches right back up there and give them the hardest time ever about their lies and call them everyone out. But then again, I'd look like, tit for tat. That's crazy. If I heard to ask them if they were available all day on Thursday, why just on Thursday? We already heard Karen say they would probably wrap up around Tuesday, so I'm giving them midweek at the latest. So I wonder if they feel like they will be wrapped up by Wednesday and this will go to the jury. Where do you guys think they stand? Think it'll go on beyond Tuesday or Wednesday?
I don't know. How much of the list did they have left?
Girl, they haven't called a dent in the list they had. They had like 90 or 91 people. Of course, in Higgins and the McCabe's, Brian Albert, all of them were all on that list. But Proctor was on the list. They're not calling Proctor. That's why the whole point of getting those text messages in and read by his friend was to avoid calling Proctor, because it was a damned if you do and damned if you don't situation with him. But it's like, do they want to muddy the waters with too much information about their alternate theory, right? Versus leaving it at serious doubt about what caused the injuries. Because one of the two has to be super strong. And what I feel like they got strong evidence suggesting he wasn't hit by a vehicle, far more outweighs the suggestion that he was. Rebuttal witnesses. I don't know, Butterfly. We'll have to see if Karen makes any comments when she comes out of court today pertaining to what the rest of the case might look like, because with the gag order, the attorneys, of course, aren't speaking. She's the only one that can, and we know she will if she feels like it. That's something to look at, and everyone will have their updates tonight, I'm sure. And we will see if well, they have Welcher on the list, Butterfly. That's what I'm saying. They have a long list of people they have not gotten to. There's no way they're going to get to that list of people all by Tuesday. Not with the way this trial's going and the questioning goes. It takes forever to get through some of them. So they still have a lot of people left they need to call. And I don't think they'll have time to get to it all. So, or to all of them. I'll have to wait and see what some of the analysis come out over the weekend are like, right? Nose around the YouTube streets and get a gist of what people are thinking on the case. A few people. I don't. Okay, let me get to where in the world? Let me get this down. Okay. Back to reality for a moment. I felt like overall that was a much stronger witness than what they presented by the prosecution. And even when Brennan tried to discredit him in whatever kind of weird way he was doing, it didn't land. Because I
Yeah,
think,
I definitely liked him better than Dr.
oh yeah,
Welcher.
right. Wolf held his ground really well with Brennan. He did. He had nice answers to come back with each time. He didn't appear rattled by Brennan. Not in my opinion. It looks like they're still actually in the courtroom, but they're not. It looks like the attorneys are probably over conferring with Bev right at the moment. You know how they are. They'll come back and start talking and saying things. Family members are all still in the courtroom, I think, as well. Except for John's mom. She may have left. Okay, so let's take a look and see what happened with Lori Daybell before we do go out of here for the evening. Let me see. It's not a long clip. It's the actual where things went down. The judge didn't even sit down. Like, he just stood up the whole time he was talking to her. His aggravation meter has reached level 10, Lori. Okay. Let me pull this up. This was earlier this afternoon. And I think they just took a 15-minute break and went back at it after this, so we'll see.
Brandon Boudreaux was very aware of the fact that this defendant and her brother had shot and killed Charles.
Oops,
And this
sorry.
is why he was very afraid for his life and trying to realize where she was and where Alex was. So if she wants to go into all of that information, then again, I believe she will be opening the door to allow Brandon to then explain why he was in so much fear for his life, why he was hiring a private investigator to locate this defendant and locate Alex Cox. So I just want to make it very clear that should she go into those areas, I will be asking to then bring in the fact that she has been involved in the murder of Charles Vallow, her own children, and her current husband's wife.
All right.
And I believe 405 will permit that, Your Honor.
So I had literally the same thoughts during her opening statement, especially when she started talking about I'm a person with good intent, kindness, peace and love, etc. And I was thinking in my head, wow, she's opening a big door right here. Now, it's not witness testimony. The jury has been instructed specifically that that's not evidence or testimony. But I think the notice that the state is putting out right now is well taken, because if you elicit testimony through a witness or you testify yourself along those lines, there's several doors that would be opened in that instance. Do you
Okay, we were
understand
watching some of this earlier, remember? It was
understand
right
what you're
after all of
saying.
this.
that? Okay. The
I
schedule.
also understand that the state also withdrew their 404B, that they had
Well, that
no
doesn't mean-
intention of doing that. So
That doesn't mean you get to say whatever you want.
I'm not saying that.
Okay.
I'm just saying they did give a notice for 404B and then they did withdraw it. So they didn't have any intention. I didn't have any intention.
The issue is if you bring in your good character as a reason of why this didn't happen, they're going to be allowed to rebut that type of testimony because you've opened the door to it. The schedule for today, I'd like to finish the witness that was on the stand yesterday. If he could come up.
And then, Judge, just for scheduling, I have one civilian witness who only had a Ring camera. She is very fast. I would like to, after Detective Ferrer is done, put her on quickly before we recall Brandon, just so she isn't waiting around.
All right, so it'll be the witness from yesterday. We'll conclude with him. The defendant was in the middle of her cross on him. We'll do that civilian witness. At some point in the morning, we'll take a short break for the court reporter in about an hour. And then we'll recall Mr. Boudreau to complete your cross, or start and complete your cross. All right? Are they lined up? Go ahead and line them up.
And if I can go get the witness for you then.
Good, Rachel. I plan on getting my full update here in just a few minutes when I get off of here. This is the part where she gets hauled out of the courtroom, basically. And like I said, guys, Joe will be doing his recap tonight if y'all guys want to go over there and get a complete checkout on today's events. Girl, she couldn't get those glasses any cleaner. I don't know. She had to have something to do with those hands. Those idle hands, you know what they say about those.
All right, welcome back. Please be seated. Thank you for your patience. All right, the defense can continue with its cross of this witness.
Okay, Detective Ferrer, yesterday we were talking about.
Hang on, guys. I think I pulled up the wrong one. 1 second. And I'm still watching the feed from Karen Reed's case as well because they're still live in the courtroom, but you can't see anything. There's nothing happening. That was the court feed from this morning that we were watching. But I was going to show you guys when she got in trouble in court. Okay, here we go. This is it.
That sidebar again discuss similar issues of if the defendant brings in evidence or testimony that she was a good person and no ill intent and those sorts of things, and specific acts of her being a good person, it could open the door to other things that she may not want the door open to. The state, the defendant, and advisory council were at the bench when we had that short 1 minute sidebar, but I don't know if anyone wants to supplement the record on that. Ms. Kay?
Just, Your Honor, that again, the state did raise any issue of character evidence under 404A and 405, that if the defendant opens the door and tries to advise that she is a good person, a peaceful person, a kind person, a loving person, any of those other types of things, that we believe that would allow us under 405 to then bring in specific acts such as the murder of her children, her husband, and her current husband's wife.
All right.
Which would also be 404B that they withdrew.
No, it'd be 405.
Yeah, they withdrew it, but if you bring up 404 that you...
Then all 404B is in, or do we get a hearing on what 404B can come in? If I open the door, do I get a hearing? We stop trial and I get a hearing on...
Stop. We'll have a very short hearing, okay? If you're going to introduce how you have great character and good character, we're going to have a short hearing on what evidence that they can bring in to rebut that character, which could include being convicted of 4 murders.
Oh,
So
and would you
talk
like...
to your advisory council during the break. And
You don't need to yell at me either. I'm...
Okay.
Yeah, you are.
wait a
And
minute,
you do not
chick.
need to talk to me that way. I'm very
Take
courteous.
her out.
I'm very courteous to you.
Take her out. No, you have been nothing near courteous to me during the course of these proceedings.
Hold up.
Talk with your advisory council about the rest of your cross. We're going to resume in 15 minutes.
What'd she say? I couldn't hear her earlier. Damn it.
15 minutes.
Now that's how a judge handles his damn courtroom.
Thank you, ma'am. And then he's brought them back. I think he gave her like a 15-minute recess. And I don't know what happened after that. Of course, we've been streaming Karen. Boy, bouncing back and forth. But hold on.
Yeah, I don't know what grade of crack half these people in these trials are smoking, but you do not disrespect a judge in their court. You know,
No.
that's
Not the
just
way-
a no-no.
The way she's done this, Judge, is just insane. That Lori feels so wronged by this judge. I guess a second ago, Reed and her team came back from the judge's sidebar, and then I think they ended court, but I wanted to make sure because it was right when we were watching the rest of that Lori. Okay, here I go. I caught it right at the right time. Okay, now we'll check out the end of this, make sure we are up to date on this, guys. See if they had anything to say after their little sidebar. Looks like they're all getting ready to go home. Bev's packing up her shit. Nope, that was it. Okay, so I guess Lori got a break to calm down, and I'm assuming that they resumed proceedings because it looks like it is still going on. Let me check. It's Friday. I just realized, really realized in my brain, it registered it's Friday. My family might disappear on me tonight. I might go live tonight or maybe tomorrow. I don't know. I got some things I do want to talk about. But let me see if they... Oops, that's not what I was looking at. Clicked the wrong one. And I don't think Lori has cross-examined Brandon yet. I don't think they ever got that far yet. Oh, wait. Yes, I'm going to watch this. Hold on, guys. If y'all don't mind, I want to watch her. We already saw Brandon talk with the prosecution, and remember, Lori wasn't prepared to cross-examine him for whatever reason, and the judge gave her till today to get that done. So it looks like that's happened. All right.
The cross-examination.
Yes, and I'm just going to ask a few questions of clarification.
Go ahead.
I mean, when we get up there, that's fine.
Hmm.
I'm just going to clarify a few things and then I'll move on.
You mean with me or with the witness?
With the witness.
Okay, go ahead and get ready at the podium. Depending on when we finish with this witness, we'll determine when we break for lunch, I guess. It depends on who you have next. We could go to like 12:15 and then start again at 1:15. We can be flexible, but so I guess let's see where we are when we finish with this.
What are they doing? That's not the right one either. Hold on. Okay, here we go. I gotta mute out because my kiddo's screaming.
We could go to like 12:15 and then start again at 1:15. We can be flexible, but so I guess let's see where we are when we finish with this witness. All right, let's bring the jury in.
You prepared for this, Lori? Remember Kay and Nancy Joe? Brandon's a little nicer.
All right, members of the jury, please be seated. Thank you. I just had to take care of a legal issue. We'll continue with the cross-examination of this witness. Go ahead.
Yesterday in your testimony, Mr. Boudreau, you talked about your argument on July 25th. Is that correct? I mean, on June 25th with your wife. Is that correct?
Correct.
Okay. And you had marital problems in those 10 years or no?
Objection, relevance.
I'll allow it briefly. Go ahead.
Can you define marital problems?
Well, like a course of contention. Were there other courses of contention in your marriage during those 10 years?
If you've been married for 10 years, there's definitely times where you don't agree.
Absolutely. So would the fact that you traveled a lot during those 10 years been a course of contention?
Is there any way you can turn the volume up a little bit? Because I've already got mine pretty maxed out.
But there are other issues besides what happened that day on June 25th. Is that correct?
Can you re-ask that question?
Like you said, a marriage has issues if you're married for 10 years. That's correct?
No, I've tried everything. Is this court? This is.
I'm not sure.
Welcome to Arizona. They're not speaking into the mic. No one's telling them to. They whisper.
Oh, okay.
It's as loud as it was for Karen Reed. Nothing's changed. I've got everything on my end is turned up. I struggle to hear them as well.
Now, the Karen Reed trial was louder than this one.
Yeah, I know. It's on their end is the problem. Not, you know. So I listen to it on my phone sometimes or just the PC and turn it up because my headsets are useless.
Yeah, I'm on the PC with the headset on, and I don't want to turn it up any louder because then when you cue up your mic, I hear your background noise like super loud and stuff.
Sorry.
That's okay.
I can't say for certain I stated that to him, but she did go to the temple often. Yes.
And that she had prayed about it and God had answered her in a call. Is that correct?
I can't say for certain that I told him that she had prayed about it and God had answered her in a call. If you have a transcript where I could read, I would be happy to read that to verify.
Okay. That's line 240 and 241.
Thank you. That's not what I read there.
Okay. Do you like to tell me what you read?
I'm going to object to improper, I don't know, impeachment, refreshing.
Yeah, maybe, I think what you should do is look at it and maybe rephrase your question.
Okay.
Go ahead and hand it back.
So you had said that God answered her in a call.
In reference to the temple?
In reference to Melanie saying that she thought you were gay.
I did, in her saying that she thought I was gay, but that didn't have anything to do with the temple, which was the question you were asking me earlier.
Yeah, so I was saying she frequented the temple. Is that correct?
Yes.
Okay. That was a separate issue. So I was asking that she was convinced of this because God answered her in a call, is what you told Detective Pillar. Is that correct?
What is of this?
Of the fact that she was saying that you were gay.
I'm sorry, I'm not trying to be, can you ask that question again?
I'm trying to get to the fact that she had her own personal revelation of that idea about you.
I can't say what she was thinking. I can't say why.
But she had conveyed that to you, that she had a God answer her in a call.
I'm going to object to hearsay at this point.
Sustain.
Where did you get that information?
Which information are you asking?
Okay. The information that you gave to Detective Pillar that God answered in a call. What was that in reference to?
The line before it was me explaining that I'd have to read the line again. I can't say exactly, but my understanding is that you're speaking about me referencing her talking about me being gay.
Correct. And you're saying that she's the one that prayed about it and God answered her in a call. Is that correct?
Can I read it again? I would like to
Sure.
answer the question the best I can.
Yes. It's 240 and 241. So that's what where did you get that information that you gave to Detective Pillar that she prayed about it and God answered her in a call?
I can't tell you for certain. I'm guessing that what I was sharing with them there was pertaining to my thoughts on our conversation from June 25th.
Okay, so on June 25th, Melanie conveyed to you that she had this belief about you herself. Is that correct?
On June 25th,
Mm-hmm.
Melanie told me that she believed that I was gay. Correct.
That she herself had that belief.
Yes.
Not that that belief had come from me, but that belief had come from herself.
Are you asking me whether or not I think that belief came from you?
No, I'm saying, did she convey to you that she had that belief, period?
Yes.
Okay. And then later in the next line, you tell Detective Pillar, you convey to him that I convinced her of that fact.
Yes.
Okay. What made you believe I convinced her of that fact?
Conversations I'd had with Charles Vallow.
Okay. So did you hear me tell that to Melanie Boudreaux?
No.
Did you ever witness me talking to her about you?
Did I witness you talking to Melanie about me
Correct.
at any point?
About this topic, about being gay.
No, I did not witness you talking to her about this topic.
Okay. So you heard it from a third party, supposedly.
I heard it from Charles Vallow.
Okay. But not from me directly. Is that correct?
Correct.
Okay. So on this day, on October 2nd, you conveyed these things to Detective Pillar. Is that correct? That she has a friend named Lori.
Can you ask that question again?
Yes. To Detective Pillar on October 2nd, you conveyed to him that Melanie has a friend named Lori.
As I stated, I think that that's a typo. I believe I said aunt named Lori.
Okay. So she has an aunt named Lori, which would be me. Is that correct?
Correct.
And she's the one who convinced her that I'm gay. Is that correct?
That's, yes, correct.
But you didn't get that information from me or from Melanie. Is that correct?
I would not say that that's correct.
Okay. You got that information from Melanie?
Okay, so Dolphin, this is Brandon Boudreaux. He was married to Melanie, and Melanie was Lori's niece. Her mother passed when she was like 9 years old, and Lori, being her aunt, kind of like helped raise her, was a mother figure. So Charles Vallow and Lori were married. They were always hanging around with Brandon and Melanie. Charles had a good relationship with Brandon. They were sharing information about what Lori and Melanie were doing, following Chad and acting crazy and talking about God and all these things. Then they labeled Charles dark, which meant he had an entity within him, basically, and they killed him. Ned. They called him Ned. Now they're after Brandon because Melanie has 4 kids with this man, and he had to go put his kids in hiding because they didn't know who was next, and he had to get a private investigator. He was sharing information with Kay Woodcock. He testified in Chad Daybell's trial, and Alex Cox drove Tylee Ryan's van. I'm sorry, I don't know why I said van, but Jeep from Idaho over to Arizona to shoot and kill Brandon. He barely missed. And
Oh.
he drove the
So they
Jeep
tried to kill Brandon after Charles?
3 months after Charles.
Okay. So they
And
weren't together. Okay. He was
no,
just somebody else on her list.
yes, he was next on
Okay.
the list, and he knew all of the things that Charles was concerned about pertaining to Lori. And at that point when he was shot at, the cops hadn't. I don't think they had declared that a murder with Charles yet. It was still
So
a
attempted murder.
It was a self-defense situation at first.
Mm-hmm.
It took a while for an actual charge to come in, right? Versus a
So this
self-defense.
is a conspiracy to commit murder
Yes.
situation with this guy?
Conspiracy. Yes. Lori, her last trial in Arizona that she just had was for because Alex Cox is no longer alive. The
Right, the
trigger
brother. Yeah.
brother, he's gone. So she was charged with conspiracy to commit the murder of Charles just recently, last or April, and now she's on trial for the final time for the conspiracy to commit the murder of Brandon Boudreaux, and this is Brandon. So
Okay. Because,
that's
yeah, thanks. Because y'all just kept
yeah.
saying he's her victim. How? You know what I mean? That's what I kept like
And
trying to
the
get at.
reason Lori she continues to bring up God because that is the whole thing for Lori. God is the one that told her, in her mind now, allegedly, guys, God told her that Brandon and Charles were gay. That's not allowed in the Mormon church. These were Mormon men.
Oh, so they had to kill him because he was gay?
Part
Or
of
they
it.
thought he was gay?
Well, yeah, they were they're no longer worthy enough. You know what I'm saying? They're turning dark. They're
I
turning
see.
all these things. So you add being gay, and that's a serious accusation. And I know what it means because Elizabeth Smart's dad, after she went missing when the man was dragged through the mud, he was Mormon. It took him a couple of years. The one skeleton they could find in that man's closet is he was gay.
The one who took her?
No, her father, the one that was
Oh.
accused by everybody and their brother who had absolutely nothing to do with it.
Mm-hmm.
Totally innocent man, but he was gay, and it was a
Get
big
down.
secret, right?
Mm-hmm.
But that's a the accusation alone to a Mormon man is not, something you want spread all over town. And
Right.
Lori's sitting here, her whole point of that is that it wasn't me that turned Melanie against you. I didn't
Mm-hmm.
tell her you were gay. God told us you were gay. And
Mm-hmm.
that's Lori's whole point. She wants everybody to know God has set all this in motion. We don't buy it, lady. You're a freaking demon.
I gotcha.
I got what information from Melanie?
Thanks.
Did you get information from
You're
Melanie
welcome. I
that
was
I
sitting outside and I was
convinced
like, wait a
her?
minute, she doesn't know all this. Hold on.
Okay.
Too much to type.
I inferred from conversations that I had with her that you were the one convincing her that I was
You
gay.
inferred from conversations?
Correct.
Okay. But she did not convey to you. Lori's the one that convinced me, and I know this now to be a fact because Lori is the one that convinced me of this.
She never said those words to me, no.
Okay. And she showed you a video that she found on Facebook. I'm not going to say.
Again, to 404B evidence, to extrinsic evidence, to relevance, to 403 evidence.
Okay. Sustained. We're not talking about the video.
But she had her own reasons that she personally believed these things that had nothing to do with me. Is that correct?
Asked and answered.
Well, I'm
And
also going to
relevance.
sustain the form of the question on Melanie's belief.
Melanie conveyed to you that she had several reasons why she had this, why she was making this accusation to you. Is that correct?
I can't say how many reasons she said. It's been a long time. But I mean, we discussed it at length for a while, and both parties shared their reasons why it was confusing.
Okay. And so Detective Pillar had asked you if she had any sort of evidence to this. Is that correct?
I believe he did, yes.
Okay. And would you like to see your answer to that?
I would love to, yes.
Okay. It starts at line 675. And what did you convey to Detective Pillar at that time when he asked you what sort of evidence that you had?
I told him that it's silly evidence.
I'm sorry, what?
It's silly evidence.
You told him there was silly evidence?
Yes.
What did you tell him specifically?
Your Honor, I'm going to object again as to relevance.
Oh, it's also hearsay. Sustained.
So how are you aware that Melanie had this silly evidence?
And I'm going to object again to just relevance into this area in 404B again.
He can answer the question, how was he aware where he got this information? But other than that, the objection is sustained.
From conversations with her.
Okay. So she didn't show it to you? She just talked to you about it?
Again, object, Your Honor. I don't know how many times we can object.
Sustained. Let's move on.
So you called it silly evidence and vague evidence, is that correct?
I'm not sure about vague. I could have.
Is it contradictory for you to tell Detective Pillar on that same day, in the same interview, that I convinced Melanie and that she had her own individual evidence that she presented to you?
I don't believe that that's contradictory, no.
You don't believe that's contradictory?
No.
So how is it that you think I convinced her?
As I shared, I had conversations with other people who shared that that was something that you were doing.
But you never heard them from me or from Melanie, is that correct?
I did not.
Okay. When you were talking to Detective Pillar that day, he had asked you, have you ever seen that vehicle before? And I'm sure he's referring to the Jeep Wrangler. Do you remember what you answered him?
It would be great if I could read it.
Okay. It's line 597. Did that refresh your memory?
Yes.
Okay. So he had asked you if you had ever seen that vehicle before, and what did you convey to him?
Not that I could recall.
Okay. And then he asked you to tell him more about the Jeep, and you gave him a color. What color did you say that you thought the Jeep was?
I believe olive or puke green.
Okay. And that you had never seen that Jeep before?
Objection asked and answered.
Had you ever seen the Jeep in my household before?
Are you asking what I said that day, or are you asking me today?
I'm asking you today. Before October 2nd, had you seen the Jeep in my household before?
I might have. I don't remember for certain.
Okay. And what color do you think the Jeep that was in my household was?
Are you asking what I think it is today, or are you asking what I thought it was that day?
I'm asking what you thought it was before October 2nd.
I don't know that I thought a lot about it, to be honest with you.
And you had never seen it before?
As I said, I can't recall for certain whether or not I had seen it before.
And it had never been parked at your house?
Which house are you talking about?
Your Quinn house.
It could have been. I can't recall.
Okay. And so before October 2nd, you were aware that there was a Jeep Wrangler in my household, is that correct?
Before October 2nd,
Yes.
I believe that at one point, Charles had called me to have me run VINs on all your vehicles because he was looking at insurance at the time. And so I did get the VIN for that vehicle.
Okay, so you knew the details of that vehicle prior to October 2nd, is that correct?
I had received them from him. I hadn't thought about it again.
Okay, but when he gave you those, did you look up the VIN numbers before October 2nd in doing that research for the insurance?
When he gave them to me, I used those numbers to run a report that would allow me to see what options he could have for insurance.
And in that research, were you made aware of the details of the Jeep?
I didn't dive into the details, no.
Okay, so were you aware at that time that it was like a 2-door Jeep or a 4-door Jeep, any of those kinds of details before October 2nd?
I can't honestly recall whether or not he told me. I don't know that I needed to know that or that it was something I was thinking about at all.
Okay. But that day it came to your mind, is that correct?
Which day are you talking about?
October 2nd.
Can you give me a little more context on what you're looking for? Came to my mind.
Oh, on that day, you stated that it was a two-door Wrangler. Is that correct?
In my conversation with Detective Pillar, is that what you're talking about?
Mm-hmm.
It would be better if I read it, if that's okay.
Sure. It's 6:02. So you told Detective Pillar, or you conveyed to him that it was a two-door Wrangler. Is that correct?
When we're talking about the Jeep that I saw that day, yes, I saw a two-door Wrangler.
And so my question is, were you aware if the Jeep Wrangler in my household was a two-door Wrangler or a four-door Wrangler prior to October 2nd?
As I said earlier, I didn't think about the Jeep that was in your household prior to October 2nd. It wasn't something I had ever thought about other than taking a VIN and running it for insurance for Charles.
Okay. But that's how you acquired the VIN number for that vehicle?
That is how I acquired it.
And when was that about? About what time frame?
I couldn't even tell you. I can't remember.
When did you start doing that car insurance business, auto insurance?
The end of 2018, some point towards the end, one of the last few months of 2018.
Okay. So sometime within that year, he had you run all those numbers just to see if we could get a better insurance rate. Is that correct?
Yeah, I couldn't tell you when exactly.
Okay. Let's go to that day of October 2nd. In your interview with Detective Heller, you had mentioned that you saw a little boy. Is that correct?
No.
To ask for some foundation.
Yeah, can you narrow
Okay.
that down a
Sure,
little more?
sure. Sure. In your narrative that you're talking to tell what happened to Detective Pillar in your interview, okay? Can I just show it to you and have you?
Your Honor, if she could just ask a question and properly
Hold on.
question the witness.
I would suggest you just ask, did you see a little boy that day?
Okay.
If that's what you're getting at.
Okay. Did you see a little boy that day, right after the glass had shattered?
No, I did not see a little boy that day.
Okay. And why did you tell that to Detective Pillar if you didn't see a little boy?
I don't believe I ever said that to Detective Pillar.
Okay. Would you like to see your interview?
Sure.
It's 4:04. You might want to read that whole paragraph to get some context.
I believe that's a typo.
So what did you think that you said that that's a typo of?
In that context, I was describing the window breaking. Without listening to that conversation, I couldn't tell you what the final word I said was, but I'm pretty confident I did not describe seeing a little boy there.
Okay, so that isn't why you thought that it was a paintball gun, because there was a little boy there?
That is correct. I did not think it was a paintball gun because there was a little boy.
Okay. And so you didn't say you thought it was kids just being kids?
I'd have to review if there's a line where I talked about that.
Okay. .406 to 414. So you conveyed to Detective Pillar that you saw a little boy, you thought it was like a paintball gun or something?
I would object to
that
him
correct?
saying that. He did not say he said that.
Right, sustain.
So after reading that, do you recall saying something like that?
The context of what I was saying there was I was describing my thoughts that I was talking to the dispatcher when I mentioned the paintball gun. And the context that I was explaining was that my window was broken. And so without seeing a bullet, as I've described earlier, I thought possibly it could be a paintball gun.
Okay. And on your street that day, on October 2nd, were there kids on the street playing paintball?
No,
Oh. Were there kids anywhere walking around?
no.
And what time was this?
What time was what?
The time of this alleged shooting?
I can't say the exact time without looking at when I called 911 right after. So whatever time that was that I called 911.
Okay, so in the morning time, right?
Correct.
And it was like a bright sunny day that day?
Correct.
Okay. So you conveyed to him that you were thinking it was just kids being kids, you know, like a broken window?
I did not convey that to him, no.
You did not say that on line 416?
I conveyed to him what I was thinking when I was talking to the dispatcher.
So why were you telling that to Detective Pillar if you did not believe that?
I just explained why.
Which was what?
I was explaining my thoughts when I was talking to the dispatcher.
So he wasn't asking you a direct question, you were just going over what you said to the 911 dispatcher?
I was explaining in that context that you're referring to what I was thinking when I was talking to the dispatcher, when I said that I thought it might be a paintball gun.
But you had said before you were confused because you didn't even really know what was going on at that moment. Is that correct?
I would not say that's correct.
So you did not convey that maybe somebody really didn't shoot over here?
As I said, I was explaining to him in that context about why I had said to the dispatcher that I thought it might be a paintball gun.
But you didn't believe it was a paintball gun at that time?
Which time are you referring, when I'm talking to Detective Pillar or when I made the 911 call?
Both.
When I made the 911 call, I thought someone was shooting at me. But as I explained, I had the thought nothing had come through my window. So perhaps it was a paintball gun, which I shared with the 911 operator. And when I talked to Detective Pillar, I was certain that someone had shot at me. I could see the bullet hole in my car, and as soon as I saw that, I knew for certain that all of the other things made more sense, and that was exactly what happened.
Okay. So yesterday you talked about you kept driving, right? After
Yes.
you were shot at. Is that correct?
Correct.
And then you went up to where the park was and pulled over. Is that correct?
Correct.
And then you made a U-turn
Correct.
and went back to the house.
Correct.
So you didn't go around the block, but you went to the, just so I understand, you went to the pool, pulled over, turned around, and went straight back to the house.
It's a big loop. You can drive either way. I ended up driving the full loop. I think everybody has seen how those streets work. So
Correct.
I did a U-turn up by the park, and I came down around the other side and looped back.
Okay. So after the U-turn, you did the full loop around.
Yeah, I finished the loop.
Okay. That makes more sense to me now. Thank you. Then what? You drove back into the driveway? Is that correct? Did you go into the garage?
I did not go into the garage.
So you stayed out of in the driveway, is that correct?
I got out of my car, and like I said yesterday, it's a little bit hazy, but I waited and stayed on 911 until the police officer arrived.
Okay. Was your garage door open or closed?
As I explained, when you drive that Tesla, it automatically opens the door when you hit it inside of a certain range. It didn't trigger in the initial drive-through when I was shot at, but when I pulled in my driveway, it triggered, so the garage just automatically opens.
Okay. So when the shooting occurred, the garage door was not open, but after you came back around the loop and drove into your driveway, it did open that second time.
It opens the garage when you pull up, yes.
Can you imagine being questioned by the very woman you know set the wheels in motion? And you just got to sit there and deal with her ass. I can't hardly deal with her. I don't. Nothing she can say is going to change what happened that morning. She knows it. My God.
Okay. And you did not drive into the garage, is that correct?
Correct.
Okay. You stayed in the driveway.
Correct.
And did you stay in the exact same place where they took all the photos of the Tesla?
I put my keys up on the dashboard, and I didn't move the car until they were done.
Okay. And so we heard you on the 911 call where you stepped out and removed the window and then got back in. Is that correct?
Like I said, it's a little hazy. What happened is when you put that car into park, the door will automatically open. And the door automatically opened, the window fell, and from there I can't remember exactly what I was doing. I remember talking to the 911 operator. I may have walked a little bit towards the street a little or something, and then I just stood right there in the driveway and waited for the first officer to arrive.
Okay, so you were outside of your vehicle at that point when the window fell out?
I may have been. It's been 6 years, so I'm not 100% certain on that part of it.
Okay. But when you say that the window fell, did it fall to the ground or it just kind of crumbled on the door?
Well, it was shattered, so most of it you could see in that picture stayed together and fell, and then a lot of it fell all over my seat, all over me, into the door frame. I could hear it all fall down in there. It fell a little bit everywhere.
Okay, but it was removed from the Tesla over to the side, so did you pick it up and move it, or it fell out over where it fell?
That piece fell because you got to remember the door's swinging out, so it automatically opens itself. If there's no sensor, then it'll move further.
Okay, so the window fell onto the ground by itself without any assistance from you?
Yeah, I didn't want to cut myself.
Okay, and then the little glass shards came out as well at that time?
Yeah, they were all over.
Okay, so you never moved the window after it fell out, is that correct?
I didn't touch it.
Okay. So where we see it in the pictures, that's where it landed?
Most likely. I can't tell you for certain.
Okay. And you may have walked to the end of the driveway, is that that's what you're testifying to?
What I testified to was that I can't remember for certain, but I stayed on the phone and may have walked, may not have, I'm not certain.
Okay. You had testified yesterday that you thought that the 911 operator told you to stay in the vehicle and you were staying in the vehicle, but you had gotten out earlier. Is that correct?
When I listened to that call, I didn't hear her tell me to stay in the vehicle. So I don't think she did, but maybe she did. Maybe I'm not remembering correctly.
I think that you conveyed that she had told you that. I didn't hear that.
Yeah, so then that conveyance must have been wrong on that.
Okay. So did any of that glass cut you? How were you careful to get out of there without getting cut by the glass?
I can't say for certain. I just think that I would have been careful. I wouldn't want to get cut by glass.
So it fell when the window fell out, the glass fell in towards you onto your lap, or how did that work?
No. The big piece of the glass fell outward, which you can see, and then, I mean, I can't tell you how everything else fell. I don't have like a perfect memory of that. Just fell.
Okay. When you stepped out of the vehicle, the glass that was on you, did it fall to the ground?
I can't say for certain.
And when the police arrived, where were you located when they first drove up?
I believe I was located in my driveway or right near my driveway, and it was a woman who came.
Okay. And if you thought that you had just been shot at, were you not worried about standing there in the driveway where someone could drive by again?
The person that shot at me was in the Jeep, and I had seen them leave. Of course, I was scared for my life, but I was told to go back to my house, so that's where I went.
And I know it all happened quickly, but you were not worried about them maybe doing the loop and driving back around?
There's a lot of thoughts going through your mind when that happens.
Okay. And who arrived first? Who arrived first? Was it Officer Rob?
I can't tell you anybody's names.
Okay.
A woman.
Female officer.
Female officer.
Okay. And she began questioning you, is that correct?
Yes.
And you began to tell her what had happened.
I did my best to explain what happened.
And she, at some point, had taken her pin and stuck it in the bullet hole, is that correct?
I don't remember that.
And where were you standing when you were talking to Officer Rob?
I mean, at what point I talked to her for a little bit, so we moved around.
Were you on the driveway
We talked on the driveway,
initially?
I believe on the sidewalk, yeah.
Okay. So was she trying to get you out of the crime scene area where all the glass was?
I can't say what she was trying to do. I'm not a police officer.
When was it that you called your friends to come over?
After I saw the bullet hole, realized that I was really close to being shot. I think a little bit of shock kicked in. I remember feeling a little overwhelmed, and I remember they were very considerate. They, I think when my hands even started shaking, I remember. And then they told me, do I have someone that can be with me? And then my first thought was my dad, you know? It's kind of my strength. And then after that, I thought of my friends. I have two really good friends, and that's what I remember is they said I could call them. And so they just came and tried to make things lighthearted, make things easier.
So was that Officer Rob that gave you the permission to call your friends?
I can't tell you for certain.
So was that after she finished questioning you on the events of the day?
I can't tell you for certain on that either. I don't know.
Was it before another officer arrived?
Like I said, I can't tell you for certain.
And how long did it take for your friends to show up?
I don't know. I probably was in a little bit of shock. I don't remember how long any of those things were.
Okay. And you had two different friends that showed up. Did they come together?
I think they came separate.
And at that point, when they arrived, was the crime scene tape already up?
I don't remember.
And so they would have had to park outside of the crime scene tape, or you don't know?
I'm sure they did. I don't know, though. I can't testify to that.
And so they stayed with you during that whole day?
Yeah, they were awesome. They dropped everything and they just spent time with me.
And they stayed until the police left?
They did.
Did they stay after the police left?
Yeah, they did.
And you guys went into the house at that point?
Yes, I did.
Okay. Did any of the offers enter the house? Any of the officers or any of the detectives?
You'd have to ask them. I think they said they had to clear the house, but I can't remember. Like I said, I think I was in a little bit of shock for a little bit there.
And do you know if any of the officers entered the garage?
I'm sure the people entered the garage, yes, at some point. I can't tell you when.
And when you got on the phone and called your friends, did you call them or did you just text them?
I don't know. I'm not sure.
And who was it that came to help you that day, your friends?
My friend Mark Bell and my friend Chris Pierce.
Did either of them get interviewed by the police?
You'd have to ask the police. I'm not sure.
Did you see any of them getting interviewed by the police? Did the police ask them direct questions in front of you?
I can't recall.
So by the time they arrived, were you done with your interviews with police?
No.
So when you were having this interview with Detective Pillar, where were your friends?
When I left for my interview with Detective Pillar, we were all sitting in the shade over underneath the tree. I don't know where I was with Detective Pillar, so I don't know where they were at that time.
And where was your interview conducted with Detective Pillar?
Inside of his car.
In a police car?
Yeah.
And about how long do you think this interview lasted?
It's a long time ago. I don't know.
And then after you had your interview with Detective Pillar, you rejoined your friends?
I did.
Did you interview with anyone else besides Officer Rob and Detective Pillar?
Not that I can recall, but I may have talked to other officers. They might ask me questions.
So other officers were around there and they were asking you questions as well?
I didn't say that. I said I may have. I can't remember for certain.
So there were several people from the Gilbert Police Department in your vicinity, on your property?
It seemed there was a lot of police there because a shooting occurred, I assumed. I don't know the police process.
But you don't remember anybody else asking you any specific questions. Is that correct?
I don't remember any questions that anybody specifically asked, and I don't remember if they asked me questions or not.
Any follow-ups to what Officer Rob had talked to you about or anything?
Not that I remember.
Okay. Brennan, how many communications since October 2nd until now have you had with Detective Pillar?
I have no idea.
How many phone calls would you say over the last 5.5 years?
No idea.
More than 10?
I'm sure more than 10, yes.
More than 20?
Like I said, I couldn't testify to the exact number, so I have no idea.
A lot?
I talked to him about my case.
More than 100?
I honestly can't tell you. I have never looked to try and figure it out.
Okay. How about text message communications with you and Detective Pillar? How many times have you communicated with him through text message in the last 5.5 years?
I've never counted, so I don't know.
More than 10?
I'm sure it's more than 10.
More than 100?
That I can't testify to. I don't know.
How about emails to Detective Pillar?
Same
How many
thing.
email communications have you had with him in the last 5 years?
I can't testify. I don't know.
More than 10?
That I'm not sure. I couldn't even tell you if I have had more than 10.
Brendan, I'm going to show you what's marked as potential exhibit 192, defense exhibit. Can I see it first?
Look at her advisory council's face. Lori has her Pebbles hair on today. She tried to match Trina wearing that gray.
Do you recognize that as an email between you and Detective Pillar?
I can't tell you what this is. I can tell you what it says. I can't tell you if this is something that where it came from. I don't have any reference on it.
I am going to object, and maybe we can.
Let's break for lunch. Is the party's good with resuming at 1:15?
Yes.
All right, members of the jury, we're going to take our lunch break. Please remember the admonition. We'll resume at 1:15.
Who got in trouble for being late? Butterfly. Her advisory team. Yeah, probably did. You don't want to hold up court proceedings, right? Especially if you're like an attorney. She thinks she's getting somewhere for us. Little does she know, right? She believes her own bullshit. I've always said that. So, how confident does Lori feel right now? You just let the man tell the story all over again to stay right there in the jury's mind. Okay. Yeah, usually the defense brings in clothes for their clients most of the time. We'll see them walk in with the suit in tow. So I'm assuming her advisory council has to bring it to her. You know, she doesn't get to go out and go shopping. She has to get it somehow. And usually the defense team brings it in because they're the ones that request that they get to come in the street clothes. But it's up to them to provide all that. Oh yeah, I can zoom past lunch. I intend to. I was making sure they weren't doing anything here. I can barely see they're talking, but I can't hear that shit. Let's back up a minute. Okay, so I don't know what he's reading.
Please be seated. The jury is no longer present.
I can't tell you what he's saying, Rach. I got my headset on, and I can just barely audible on this headset. I was literally having to listen to it through my phone, and well, the phone's delayed, so I'm struggling right now.
All right, so I've reviewed Exhibit 192. The line of your questioning was to establish that this witness has had contact with Detective
He's
Pillar.
talking to Lori, and yeah, he's reading the exhibit, but I don't know what it pertains to because I can't hear a damn thing.
Separate emails in a string from February 12th of 2020. So what's the purpose of this? Yeah, are you trying to admit it? What do you?
I would like to ask him about it.
What's relevant about it?
A lot of things, Your Honor.
What?
Judge, I can't hear her.
Please speak into the mic.
It's relevant to his discussion with Detective Pillar from the October 2nd date until this date on February 12th.
What is relevant about it that is an issue for this jury to decide? That's what relevance.
I have it up on the
Something
PC
that
now,
this
so I can
jury
hear
either
better.
makes something more or less probable for some fact that they need to decide.
It's relevant in the way that this email communicates that the information that was being given to the detectives was directly from Brandon Boudreaux.
I know, but what in the content of that email is relevant for this case?
The fact that the last line.
Did I miss something? What's the last line?
You said, did I miss something? Court TV's got a louder feed. All right, thank you, Sajoy. We'll grab that one. I have it saved as well. I think I have it saved. This East Idaho News must suck on their feed. Who did we stream from? Was it Law and Crime? We did Charles's trial?
The last line was Detective Pilar writes, is it Pilar or Pillar?
Pillar, like a pillar in a building.
Pillar. Detective Pillar writes, this information is requested so we can see if Melanie has any financial gain from your death, basically, correct?
Correct.
Okay, so that creates motive for Melanie. It seems like I guess it's fair area for him to talk about in general, but it's also a fair area for you to talk to the detective about what areas they investigated. But let me hear the state's response. But as far as that particular email comes in, I mean, I suppose you could ask some questions about it, but let me hear from the state.
I see what was happening because Brandon's still up there. Let me pull up that other feed that Sajoy just mentioned, the court TV. We'll see if that's louder, and then we'll get past their lunch break. And see if we can catch up before the evening is done. All right, I got it, guys. 1 second. Let me get where we need it to be. When they come back from lunch. Okay, let me pull it up. Thank you. Yes, I got Court TV now. Let me get the screen back up and we'll give it a go. Let me put my headset back on and see if I can hear it. Okay, now that'll be fine. Okay, now let's go. Whoops.
You may want to write this down. In February of 2020, while this case was being investigated, did Detective Pillar ask you to provide any documentation?
Oh God, that's much better.
Which might
Shit.
support
Sorry,
whether
guys.
Melanie had a financial motive
Sorry, Dolphin.
for your murder or death, however you want to phrase that. The state may also ask follow-up questions on whether or not any financial motive existed, such as a life insurance policy. I don't know the answer to that, if she was the beneficiary of a life insurance policy. Additionally, the defendant has opened the door somewhat, and for now, the state may ask in redirect a question along the lines of, all the communication you had with Detective Pillar in the last 5.5 years was not solely about this case, correct? Some of your communications with Detective Pillar were related to a separate investigation, correct? To the extent the door gets opened further than that, I guess depends on where the defendant goes for the rest of her cross. I don't see any reason to actually introduce that Exhibit 192 because it has other information on there as well. So that's the ruling. Are we ready to bring the jury in?
In 1 second.
And just to get ahead of the ball, when Detective Pilar eventually testifies, you would also be allowed to ask if he sought that type of information and why he would seek that type of information.
Okay.
All right, you want to go ahead and get ready at the podium? We'll bring the jury in. All right, please be seated. The jury is present. You can continue with your cross of this witness.
Mr. Boudreau, in February of 2020, while this case was being investigated, did Detective Pillar ask you to provide any documentation to prove that Melanie, your ex-wife, had a financial gain at your death?
Yes.
And did you provide that information to him?
I believe I did.
How many documents would you say that was?
Can I get some more context around that?
Yes. So Detective Pillar asked you to provide him with some documentation of financial gain from your ex-wife Melanie. Is that correct?
Correct.
And you did provide to him some documentation. Is that correct?
Correct.
And so what were those documents?
What did I provide to Detective Pillar about that?
Correct.
I had a life insurance policy. I provided him with that.
What else?
I'm not sure there's anything else I provided him.
Okay, did you provide the rental agreement for Melanie's address?
Are you talking about on that specific day or?
Ever?
I can't say for certain that I did, but I may have. I believe I had it. I believe I helped her when we were signing that.
Okay. So did you provide your rental agreement with him?
At some point, I believe I gave him my rental agreement for my property at 3875.
And did you provide information showing your financial shared accounts?
If he asked me for that, I would have provided it to him. I can't say for certain which accounts I gave him, but I'm sure if he asked, I would have given him any accounts he needed.
And you gave him the information, the contact information for your financial person at Chase Bank?
I would have, if he asked me for anything pertaining to the case, I would have given it to Detective Pillar so that he could investigate.
Okay. So he could help demonstrate Melanie's financial gain if you were to pass away. Is that correct?
I didn't say that.
No, he asked you for that. Is that correct?
I can't recall him asking me that.
So he asked you for any documentation that would help him demonstrate financial gain for Melanie if you were to have died around October 2nd, 2019.
I can't recall if he asked for that specifically. If you're asking if I can recall whether or not I talked with him about the possibility that she had financial gain, I definitely talked with him about her having financial gain. If you're asking if I can recall the exact wording that he used, I can't tell you that I can confidently sit here and recall the exact wording.
Well, you looked at this exhibit, correct, a minute ago?
You showed me a document.
Would you like to look at it again?
If you're asking if you would like me to look at it, I can look at it.
Okay. It's the last line.
Did that refresh your recollection of your email with Detective Pillar?
I definitely read what you shared with me, yes.
And he had asked you to provide documentation to demonstrate Melanie's financial gain in case you were to die on October 2nd, 2019?
He asked me if I could provide any documentation that could have showed that there was financial gain for her if I had died on October 2nd.
And you did provide the information to him, is that correct?
As I said, I can't recall exactly, but I'm sure I did.
And did you provide screenshots to him?
I'm going to object or ask for foundation of what? Screenshots.
Sustained, please lay more foundation.
Okay. Did you provide to Detective Pillar 6 screenshots in response to this email where he asks you for that documentation?
I gave Detective Pillar my phone, so they had literally every conversation I ever had. So I'm sure he would have had access to any conversation I'd had with someone
Okay, and when was that you turned your phone over?
at the time of the shooting.
So on October 2nd?
Correct.
So in February of 2020, February 12th specifically of 2020, did you provide to Detective Pillar 6 screenshots of messages to him for this purpose of demonstrating Melanie's financial gain?
As I said, I had a lot of conversations with Detective Pillar. So if you're asking for one specific conversation, I can't tell you right now that I recall exactly what I would have given him in February of 2020.
Okay. Would you like to look at this?
If it would help, sure.
Okay.
For the Bates. Bar on this.
Okay.
That's incredibly ridiculous, whatever they're doing there. Look, I need to change my banner. Let's see. Yeah, the judge is probably stressed. That whole courtroom's probably stressed out. That's incredibly ridiculous. Oh, my phone is on again. Jesus. Phone is on a damn delay. Yeah, I had to go make the kids some food real quick, but I'm back. But man, Lori. Lori. So apparently, when they get on through this testimony and stuff here throughout the day, at some point during the trial today, Trina apparently confirms an open investigation into Melanie. Which Melanie they're talking about? It kind of leans toward it would be Melanice, right? Because that's who they're talking about here, not Melanie Gibb. Why would you go after Melanice for conspiracy? Right, Rachel? I don't know what the statute of limitations on that would be and why they waited. Like sneak attacker, surpriser. I don't know what they would wait for. Right, Forrest? Not many people left to throw under the bus. However, they're implicating Melanie, saying, oh, Melanie could have gotten your life insurance. Yeah, Lori. Well, Melanie was going through a divorce. Charles was changed you from his beneficiary, gave it to his sister Kay instead. You had no idea until you called to make a claim to that $1 million life insurance policy and found out you didn't have it. Remember that, Lori? She's a super freak, y'all. She's a super freak. I think I want pizza for dinner. Lori's gonna roll right into our dinner. She's gonna, goodness, lady. You know what? I guess her investigator finally showed up with all the documentation she needed yesterday, and they weren't able to get it into evidence. I guess that's what they're doing now, is discussing it. So Dolphin and I were doing some checking earlier, guys. It appears that the defense is probably the one subpoenaing everyone over in Pennsylvania. I found another document that confirms it, and they also have sent a subpoena out to Bethany Funk, one of the surviving roommates, who is residing out of state. Out of state subpoena. You too, Butterfly. It's grocery store time for sure. So I'm thinking about just grabbing pizza for tonight and dealing with it over the weekend, right? Get my order ready and get it placed. All right, Lori.
The life insurance policy that you provided to Detective Pillar, was that an active policy?
As of the date that
As
I
of
provided
that-
to him, or as of the date of my,
As of October 2nd, 2018?
yes.
Okay. And did you provide more than one life policy to him?
No.
To Detective Pillar? Did Melanie have a life insurance policy?
Protection relevance?
Sustain. Well, are you asking if she had an insurance policy separate from this on him?
Correct.
I'll allow it. If he knows.
Not that I knew of.
Okay. But in your agreement, did you provide also a copy of your mediation agreement to Detective Pillar?
Yes, I did.
And in that agreement, Melanie was supposed to get a life insurance policy as well on herself as you, the beneficiary?
I'm going to object to relevance at this point.
Sustain.
Who was the beneficiary on the policy that you provided to Detective Pillar
On what date?
on October 2nd? Who was the beneficiary on October 2nd on your policy?
Melanie Boudreau.
And did you change that beneficiary?
I could not. It's a whole life policy. It's not changeable without both parties.
And do you remember when you provided that to Detective Pillar?
I can't recall.
Did you provide any other financial information to Detective Pillar in regards to his email asking you for documentation?
Can you ask that question again?
Yes. Is there any other financial documentation that you provided to Detective Pillar after he requested it in the email to you?
Are you speaking like on that specific date or
Anytime
at any point in
after.
the future?
Yeah.
Your Honor, I'm going to object again as to extrinsic.
Sustain.
Brendan, did you meet with the prosecutor in preparation for this testimony?
Yes.
When was that?
I can't say which specific day, but I met a few weeks ago, 2 different times.
2 times?
Yes.
How long each time would you say? Or how long was the first time?
A couple hours.
And how long was the second time?
A couple hours.
Did you review documents at that time?
Yes.
To refresh your recollection of things?
To the best I could, yes.
Did you view any of the financial documents that you provided to police during those interviews?
I did not.
What documents did you review in preparation for your testimony here today?
The ones that I can recall would be my 911 call and the conversation I had with Detective Pillar.
So your interview with Detective Pillar?
Yes, the one that I had with him in the car.
Okay. But not all of your conversations with Detective Pillar ever, right?
I don't even know how I would do that.
Okay.
I'll be over at Miss Shorty's this weekend, guys, for Camp Shorty on Saturday night. Our usual time.
You had mentioned in your testimony yesterday that the Tesla has a camera on it. Is that correct?
I don't know if I mentioned it in my testimony yesterday, but the Tesla does have a camera on it, correct?
On the front or the back, or how does that work?
They have cameras on the front and the back and on the sides.
So it goes like, oh, sorry. So like a 360 degree view?
Depending on the Tesla, there's different cameras that they have, yes.
And were any of those retrieved to your knowledge from the Tesla, the cameras?
The model that I had was not one where it saved the recordings.
So it doesn't save any recordings at all?
It did not.
Okay. When you talk about where the Jeep Wrangler was located on October 2nd, you said it was nose to nose with the white van, is that correct?
Correct.
How close was that nose to nose, would you say?
To me, that means that they were basically touching.
Okay. And then you had stated that you kept going straight, is that correct, after the shot?
Correct.
And then the Jeep passed you, is that correct? At some point?
I had stated that I went straight. I went around the corner and I parked, and then the Jeep followed the path that I did and went past me, went around the corner and then went down the other lane. Without looking at a map, I can't tell you what the name of that street was.
Okay. And so when it passed you, did you look over at the Jeep?
I saw the Jeep in my rearview mirror initially, and then I looked over to the right as it drove off down the road.
And did you see the driver of the Jeep?
I could not identify the driver.
And you have seen Alex Cox before, correct?
I couldn't see anyone.
But you have seen Alex Cox before, correct?
Yes,
And you have been with him on many occasions. You know what he looks like, is that correct?
correct.
And so you would recognize him if you had seen him, is that correct?
If I had seen him, I would recognize him.
So when you were looking, you said you first saw him in your rearview mirror. You saw the Jeep coming up towards you when you were pulled over, is that correct?
Correct.
And so you didn't see the driver at that time either in your rearview mirror?
That is correct.
Okay. You couldn't tell who was driving?
That is correct.
Not if it was a man or a woman?
That is correct.
Okay. So you didn't see the driver at all?
That is correct.
And then you didn't see the plate number either as well, is that correct?
I did not give them the plate number, no.
And you had your phone in your hand or you did not?
Can you give me some more context? When are you speaking of?
When the Jeep passed you, where did you have your phone in your hand?
My phone was connected to my speakers. So
Oh.
I was talking over the speakers, but I believe the phone was in my hand.
And like you didn't take a picture of the Jeep as it passed or the license plate or anything?
I did not.
Did you yourself personally take pictures of the Tesla after the incident?
Can you give me some context of when?
Anytime after the alleged shooting?
I sold the car, so I took a lot of pictures of it before I sold it. So yes, I did.
Did you take pictures of it immediately after?
Can you give me a definition of like when immediately is?
Like, did you take pictures of it showing the window missing?
At some point I took a picture of my car. I can't tell you when specifically, with it missing a window.
And did you take pictures of the bullet hole?
At some point I may have. I don't think I did though.
Did you send those pictures to anyone?
I may have. I don't remember.
Did you send those pictures to your dad?
If I took a picture of my car, I may have sent a picture to my dad. It's not something that I recall off the top of my head.
Did you send pictures to the two friends that were there with you?
Object to relevance.
Sustained.
How long was it before you sold your Tesla after October 2nd?
I couldn't say. I gave it to the police. They had it for a while to run tests and do whatever they needed to do. Then when it was returned, I took it to a dealership to get it repaired. And after that, at some point, it was sold.
So did they repair it? They were able to repair everything?
They were.
Did they have to replace the whole door?
I don't know what all they had to do. I just paid for it after it was done.
So the police did not ask you to turn the car over to them, is that correct?
That is incorrect. I turned it over to them.
When did the police have the car?
As soon as the shooting happened, I gave it to them, and they kept it. I can't remember when they gave it back to me, but they gave it back to me later.
So days or weeks or months or how long after?
Like I said, I don't know specifically, but I would guess it was a couple weeks if I remember correctly.
Okay. So if that happened on October 2nd, then you had it back maybe before the end of October?
I did have it back before the end of October, I believe.
Okay. And was it the same as when they took it? Was it intact the same way, the window missing and the bullet hole?
I mean, I can't say if they, I would believe that whatever tests they did were not intrusive. I don't know if they did anything, but as far as the car being the same, it looked the same to me.
Okay. And then then you sent it to get repaired after you got it back?
Correct.
Is that correct? Okay. And then how long did it take them to repair that car?
I can't recall.
Like weeks or days?
Like I said, I can't recall. I can't tell you a definitive time.
Do you have to have a rental car during that time?
I borrowed a friend's car.
Okay. At what point did you decide that the Jeep was gray and not puke green or camo green?
I'm not sure I understand what you're asking.
Did you provide information to the Gilbert Police Department that it was a gray Jeep?
I believe I referred to it as several different colors throughout conversations I had with law enforcement.
Okay. And where did you get your information from the VIN number that it was actually a gray Jeep?
I did not.
Where did you get the information that it was a gray Jeep?
Later at some point I decided I thought maybe it was gray.
Later at what point?
I can't say for certain.
A month later?
To
2 days
to
later?
me, puke green and gray are very similar in color. I identify both of them very similarly.
But when did you change your mind from puke green or olive green to gray?
Like I said, I didn't say that I changed my mind.
So in all the reports, they say a gray Jeep. No one ever says a green Jeep. So that information did not come from you?
I can't say what the reports say. I can only share what I can testify to, which is that to me those colors are very similar or the same.
So with you having access to the VIN number of a particular Jeep, would it give you the color of the car?
I never looked at it, so I can't tell you.
You never looked up that VIN number?
I never looked to see if it gave me a color.
Do you know if that's a thing that you can look up the VIN number and see the make and model and color of a car?
I can't testify to the ability to look that up. That's not something I'm an expert in.
And you've never done that?
Tried to look up a car color by the VIN number?
No, that you've never looked up that specific VIN number to that Jeep. Is that what you're testifying to today?
Can you give me some context?
Yes. So after October 2nd, did you ever look up the VIN number that you had access to of the Jeep Wrangler that was in my household?
I don't think I did. I don't have a recollection of it.
So did you just provide the VIN number to Detective Pillar?
Yes.
And when did you provide the VIN number of my vehicle to Detective Pillar?
I think on October 2nd. I'm not certain, but I think that's when I gave to him.
So on this day, on October 2nd, you provided that VIN number to the detective?
I think at some point, if I recall correctly, I remembered that I had it, so I got it and sent it to him just to make sure that he had it.
So at that point, even though you thought it was a puke green or olive Jeep, he would have access to the information that it was actually a gray Jeep that was in my family household. Is that correct?
I can't testify what he had access to.
But you provided him with that information that very day?
To the best of my recollection, yes.
Brandon, did you know of Alex being an avid shooter?
I knew that Alex liked to shoot guns.
Did you know that Alex liked to frequent the shooting range?
I didn't talk to Alex a lot about that, so I can't testify whether he liked to or not liked to.
But you knew through the family that he did go to the range a lot?
I mean, I can't testify. Like I said, I can't testify to whether or not I knew that he liked to go to the gun range.
Did you ever go to the gun range where he was there?
I did not.
Did you ever go to the gun range in anyone in my immediate family with them?
Can you define your immediate family?
Well, my brothers, sisters.
I don't recall going to the gun range with your brothers or sisters.
Did you ever go to the gun range?
Can you object to relevance?
Why is it relevant if he went to the gun range?
Do you own a gun, Mr. Boudreau?
I guess it's sustained.
To relevance.
Overruled, he can answer.
I do own guns now, yes.
Did you own a gun on October 2nd?
I did not own a gun on October 2nd.
You did not have any kind of gun in your possession on October 2nd?
I did not.
Did Melanie own a gun?
She did.
It was registered to Melanie, not to you?
She bought it, correct.
When you say that you provided the VIN number to Detective Pillar, was that later in the day after the police had already left, or was it while he was still at the scene?
I believe it was after he left, but I'm not certain.
So how would you have gotten him that information?
Would have probably been through one of my friend's phones because he took my phone when he left.
So would it have been an email or a text message?
I believe it was a phone call,
A phone call.
but I'm not certain, like I said.
And at that time, you had handed over your phone to Detective Pillar?
Yes.
When did you get your phone back?
It was late that night. I believe he had to give it to somebody who, I'm not a police officer, so I'm going to probably say this wrong, but they had to copy everything off of it, and it takes however long it takes. And so I turned it over, and then I just waited until that was done. And apparently I had a lot of stuff on that phone, so it took a long time.
A long time, meaning a day, 2 days, 6 days?
I believe he's already testified that night.
Sustained.
I'm sorry, I missed that. You had it back that night.
I actually, as I think about it, it may have even been in the morning that I went back and picked it up.
Okay.
I'm not certain, though. It was either that late that night or it might have been in that morning because I think I didn't have my phone that night.
Okay. Did you go buy another phone in the meantime?
No.
You just waited for it to be returned to you.
Yeah, it seemed like the most logical thing to do.
Did Melanie provide information to you that she was going to be out of town that weekend before October 2nd?
She did.
And was that the first time that you, that weekend of October 2nd, or those weekdays, I guess it was weekdays at that point, is that the first time that you activated the mediation agreement where the children were with you at the new house?
We were following our mediated agreement throughout the summer. However, that was the first time that I had a space where we both felt like the kids could move freely and be kids. So it was the first time that they got to come and spend time and enjoy it. They previously had stayed at my house, but I had to be very careful. It's an expensive house, and it had to be show ready. Someone could come at any time.
So what day was it that the kids started being with you on your visitation that before October 2nd? Was it the 1st and the 2nd, something?
No, it would have happened the day that she left, I believe. I mean, I haven't reviewed this, and it's been a long time, so I believe it would have been like a Thursday or Friday that I got the kids, and I had them over the weekend, and then until I did the drop-off on October 2nd.
And what day of the week was October 2nd? Not sure I know. Do you remember?
I believe it would have been a Wednesday based off of our parenting schedule.
Okay. So on Wednesday's the day that you would have turned the kids over, they'd have gone to school and Melanie would have picked them up. Is that correct?
Correct.
Okay. And that morning, had you talked to Melanie in the morning before school at all?
She and I only communicated through text.
Did you communicate with her through text that morning before school?
I texted her to let her know that I was dropping the kids off.
And then you had to have some kind of text messaging to let her know you were there to drop off Breeze, right?
Correct.
And you met at the park for that, is that correct?
Correct.
And then you went straight to the gym after dropping off Blake, is that correct?
Correct.
And that's about how far from Melanie's house to the EOS gym?
5 or 10 minute drive.
And then how far is that to your residence from the EOS gym?
5 or 10 minute drive.
So when you were driving down your street, when you turned onto your street, did you see anyone else out in the neighborhood?
I did not.
No one out walking or anything that you noticed?
Not that I noticed.
And when you drove away over by the pool area, was there anyone out in that location?
Not that I noticed.
How many cars would you say were parked on your street, on the Phelps Street that morning?
There were 2 that I noticed. I couldn't tell you how many other cars were parked on the street.
But it's kind of a crowded street, so people do park on the street there that live in that neighborhood. Is that correct?
I have never testified to that. I can't recall.
And you had lived into this same neighborhood previously, is that correct?
Not this portion of the neighborhood, no.
Well, one neighborhood over on the same street, right?
I did live on a Previously, I did live on the neighborhood over on the same street.
Right. So you're familiar with that neighborhood anyway, even though you only lived at this house for a short time, is that correct?
I would not agree with that. This is a different section I didn't go to.
Because there's no availability to go from that neighborhood to that neighborhood, even though it's the same street, is that correct?
You can't drive. It's not connected in driving.
Correct. But literally, that house to that house is only like 10 houses away, really.
Can you give me context? Which houses are you talking about?
I'm just saying, your rental house from the house you owned earlier on Phelps Street is really only about 10 houses away, even though there's a divider and no access to drive straight over.
Yeah, I've never counted how many houses, but it is a short distance between those two houses.
And you guys lived in that house for a long time before you moved, right? A few years.
Sustained.
Brandon, when you were providing all of this information to Detective Pillar in regards to your relationship with Melanie, were you trying to have him charge Melanie with your murder?
Object to relevance.
Sustained.
No more questions, Your Honor.
Redirect.
I'm going to start by talking to you about June 25th, okay? Why did that date stick in your mind?
It was a painful date.
If you can get closer to you, Mike.
It was a
please.
painful date.
Why was it a painful day? Why did that stick in your mind?
My grandfather was someone who was really important to me, and I was dealing with, sudden loss is traumatic. So I was dealing with that, and my family is the most important thing in this world to me. And so the dissolving of my family was probably one of the most painful things that I've gone through as a person. And that date is the start of the dissolving of my family.
Okay. So when you are talking with Melanie, was the focus of that argument about your marriage?
Yes.
And during that argument, did you and Melanie discuss issues within your marriage?
Yes.
And during that, did Melanie bring up reasons why the marriage was over?
Yes.
Did any of those reasons involve things that Melanie claimed you did to her aunt, Lori Vallow?
Yes.
So one of the reasons why the marriage was going to end was because of this defendant, Lori Vallow, things that she said you had done to her.
Yes.
Did that include the idea that you had hacked into Lori Vallow's computer?
Yes.
So that's something that Melanie was bringing up to you during this argument about the end of your marriage.
Yes.
Did the issue of you helping Charles Vallow try to take away Lori's temple recommend also come up?
Yes.
So again, your marriage and reasons why it's ending tied to Lori Vallow?
Yes.
Is that why you sent those text messages to Lori about the temple recommend, that you had nothing to do with trying to take that away?
Yes.
You told her that was a lie.
Yeah.
During that argument ultimately, did Melanie say that she just wanted to end the marriage?
Yes.
Prior to June 25th, did you think that you were about to get divorced?
No, I had no, there was no thought in my mind that that was going to be an outcome.
And then all of a sudden on June 25th, you start hearing about things that you've done to Lori Vallow that is why your marriage should end.
Yes.
Was it your belief, based upon your conversations with Melanie and with Charles Vallow, that Lori Vallow was involved in causing your divorce?
Yes.
I'm going to talk to you about your interview with Detective Pillar on October 2nd of 2019, okay? Have you tried to memorize your transcript?
No, I mean, we talked for a while, so it would be a lot to try to memorize. No.
When we met, you listened to it again.
Yes, that was the first time I had heard it.
You have been asked by the defendant to read various parts of your transcript. Are you having difficulty recalling what happened to you that day with the Jeep?
No.
Were you trying to verify the specific words that you were telling Detective Pillar during that interview?
Yeah, I think it's important for me to be honest and be thorough, so I wanted to make sure that I was thorough in what I was responding.
Can you tell us from your own memory what the Jeep looked like?
Yes.
What did it look like?
Like I described it that day, a puke green or a gray Jeep with no tire on the back, with a Texas plate.
Did you tell him that it was a Jeep Wrangler?
I did, yes.
How many doors did it have?
2-door.
That what you recall?
That's everything that I recall.
Is that what it was?
I believe that's what it is, yes.
And when you talk to us about what you saw happen, is that because you listened to an interview or your own independent memory of what happened?
Those are my memories.
So whether or not you used X word or Y word, do you remember that the back of the Jeep window lifted up and a rifle barrel came out and pointed at you and shot your car?
Yes, I'm certain that's what happened.
There were some questions about kids. You were given some portion of a transcript. At one point, are you talking to Detective Pillar about calling 911?
Yes, I was explaining the dispatcher.
When you were talking to the 911 operator, do you mention to her that you think maybe someone was using a paintball gun?
Yes, I did.
When your car was hit and a bullet didn't go through the window, were you trying to figure out how that was possible?
Yes.
Did you later realize that it wasn't a paintball gun that hit your car?
Yeah, as I stated, I was certain once I saw the bullet hole in my car that the same reason I called 911 originally, that someone had shot at me, and it was definitely a gun, and it was definitely, they were trying to kill me.
So why did you call 911?
Because I believe in following the law.
Did you think that you'd been shot?
Yes, and I wanted protection. I wanted to feel safe.
Okay. When you saw that bullet hole in your car and no paint on your car, what went through your head?
I think, like I said, it's a really scary thought because up until then, I think you want to feel safe. And so I was trying, my window was broken, but I didn't see a bullet hole. And I was trying to think of something to make myself feel maybe safer. And when I saw that, I knew that there was no other option than that someone just shot at me and they were meaning to kill me. There's no other logical explanation for why that would have happened.
When you were driving back to your house and from the pool area, you told us that you saw the Jeep going up Cole sort of in your direction initially, correct?
Correct.
And then you saw the Jeep turn right onto Waite,
Correct.
and you could see across that field, and then you saw it turn south onto Fisher.
Correct.
So you were asked about why would you return home? Did you actually see the Jeep sort of leave?
Yes, and that's why I turned around.
Did you in fact follow that same direction so you could see if the Jeep was still on Fisher?
Yes.
Did you see it on Fisher?
I did not.
When you turned onto Phelps, did you look down the street and see if you saw the Jeep?
I did not see it on Phelps.
So by then you knew the only other way it could go would be now into Fairview?
Correct. And I believe I told the person on dispatch that I had believed he went out onto Pecos.
And that's because that's the only way you can go from there, right?
Correct. I just wanted them to know there was only 2 exits.
When you got back into your driveway, you were still on with 911, right? We heard that.
I was, yes.
Were you thinking about, oh no, if the door opens, the glass might fall out?
No, I wasn't thinking about that.
Were you trying to talk with the 911 operator and keep yourself under control?
Yeah, I was trying to make sure that I gave them all the information they needed.
Were you trying to watch and document how the glass might have fallen out of the window when the door opened?
No, I actually was surprised when it fell because it wasn't something I was expecting.
Same thing when you were up by the pool. Were you thinking rational enough as you're talking on the phone with the 911 operator about someone just shooting at you to think, oh, I should make sure that I take a photo of this Jeep?
No, if you recall, I was a little out of breath, and I was very nervous. That's a nerve-wracking experience.
Is that when we heard you actually almost like panting like you had been running?
Yeah, yes.
And do you wish you'd seen the driver?
Of course, I wish that my Tesla camera worked. I wish a lot of things.
But you didn't.
I did not.
You were asked a lot about this VIN for vehicles. When you are given a VIN number, does that mean you get to see the car? Does that have anything to do with a visual of the vehicle?
No, it's just a number that identifies cars.
So in your use of a VIN number to look up car insurance, did you care the color or the accessories on a vehicle?
I mean, an insurance company might, but I mean, you have to think they had multiple cars. I had to take all those VIN numbers, put them in, and then you go run it through a software, and it tells you who's going to give them the best price. So I wouldn't have been paying much attention to any of those details. I can't even recall what any of them were on the cars.
So you're just putting in the VIN numbers to see who might pop up the best insurance rate.
Yes.
You were asked a lot about communications with Detective Pillar. Did you know him before this?
No, I met him that day.
Was he the assigned case agent for your case?
Yes, he was.
So that's the person you were supposed to communicate with about your case?
Yes.
You were asked about having a large amount of text messages or phone calls or emails with Detective Pillar over the last 5+ years. Do you recall that?
Yes.
Would it be fair to say that all of those communications that you have had with Detective Pillar over the last 5+ years were not just about this case?
That is correct.
Would it be fair to say that some of those communications that you have had with Detective Pillar over the last 5+ years were in relation to a completely separate investigation?
That is correct.
On October 2nd of 2019, did you tell Detective Pillar that you believed Lori Vallow and Alex Cox were involved or responsible for this shooting?
Yes, I did.
So this is before you had access to VIN numbers or anything else.
That's correct.
While you were still sitting there being told by the police not to leave, Detective Pillar comes over and takes you away from sitting under the shade, brings you to his car, and interviews you.
Yes.
And you tell him that.
Yes.
So even if Melanie had some financial gain in if you had died, did that change your opinion at all that Lori Vallow and Alex Cox were involved in this shooting of you on October 2nd of 2019?
No.
I have no other questions.
Are there any questions for this witness from any member of the jury? All right, seeing none, you can step down, sir.
Thank you.
I'm going to call your next witness. All right, sir, come on up and be sworn in right here.
Now the jury knows he taught detectives over the past 5 years.
Your first and last name? Thank you. Raise your right hand, please. Do you do solemnly swear the testimony you're about to give will be the truth?
Amen, Sajoy.
So help you God? Walk around the court quarter up.
Would you please introduce yourself to the jury?
Good afternoon. My name is Nathan Duncan. I'm a detective with the Chandler Police Department.
How long have you worked for the Chandler Police Department?
25 years.
And I want to talk to you about an incident that occurred in Chandler, Arizona on July 11th of 2019 involving Lori Vallow and Alexander Cox, okay? At that date, did you go to Lori Vallow's residence at 5531 South Four Peaks Drive in Chandler, Maricopa County, Arizona?
I did.
Do you see Lori Vallow in the courtroom today?
I do.
Can you point her out and identify what she's wearing?
She's seated at the defense table, blonde hair and a gray sport jacket.
Your Honor, may the record reflect the witness has identified the defendant.
Good job.
While you were at that residence, were photographs taken of the vehicles?
Yes, they were.
Was there a 2018 Jeep Wrangler located in the garage of Lori Vallow's residence?
Yes, there was.
Showing the defendant exhibits 81 through. 89. Do you recognize those as photographs of that Jeep Wrangler from Lori Vallo's residence in Chandler, Arizona on July 11th of 2019?
I do.
State will move to admit 81 through 89.
We do have an objection. Could we have a sidebar on that, Your Honor?
Okay.
I was running around the house multitasking while listening to this on and on and on. Let's see. Forrest says, I think Lori likes to be in control of the narrative, and representing herself is the way to do exactly that. I would agree. She was already convicted of 3 murders before that, so she has nothing to lose, really. No, she doesn't, does she? I don't. My thing doesn't want to scroll. I was running around the house multitasking while listening. My phone keeps going up. There we go. Recap show in 3 hours. Yes. For Joe's show, right? Joe's show. Joe Schmo's show. There's the link in the chat. Thank you, guys. Yeah, Carrie, it's been a pretty uneventful day. Just standard routine questions. Lori doesn't have any game, but this morning she got into a little shouting match with the judge, and he was like standing up even, and he ordered her out of the courtroom. She wasn't happy. 15-minute recess, and they came back. She was collected at that point, and here we are. We're playing catch up because we did finish out the day with Karen Reed. When hers ended, we jumped over to take a look at Lori's trial. Lord, grandson's playing his game again. He was chilling. He ate his snack. He must have he got some energy back from getting that snack and a little rest. Yeah, Brandon's doing a great job. He'll be so glad when this is over. Like all of them will. All of them will. She's insane. She sure recovered quickly from her illness, didn't she, guys? I mean, they must have just souped her on up with some really good cold meds. Some miracle stuff for her. So Butterfly dropped the link in the chat earlier over to Miss Shorty's. I will be over at Miss Shorty's tomorrow night. We're going to be recapping the Karen Reed case, the defense case in chief, basically. Going over there. It's always a good time. She's got a good lineup this weekend. I think she's going to be hanging out with Publicly Buzz tonight, doing their thing over there. I think Feral Friday. Yeah. So I don't know what all they got planned over there tonight. I'll take a look at that. And then I'll be at her over in her neck of the woods on Saturday. Her show will be in progress, but I'll join in around 8 p.m. Central. Butterfly says she needs some energy. Loopy Lori is lazy. Or Loopy Lori is draining. You need to just, we need to be lazy this weekend and just relax, right? Go there to hang out at Publicly Buzz, Camp Shorty, go get your recap from Joe. I'm going to eat pizza and try to stay awake all night. Don't know how long I'll stay awake. She openly admitted in court she owned that Jeep. Yeah, after Charles passed, it went into her name, and all that was taking place so fast, right? Because it was in Charles' name when. Oh my grand. Let me shut my door. Hold on.
So the state will move to admit 81 through 89.
Without waiving any objection by the defendant, those exhibits are admitted.
So Detective, were photographs taken of the vehicles at this residence on July 11th of 2019?
Yes, they were.
And inside the garage itself, did the Chandler Police photograph a Jeep Wrangler?
We did.
I'm going to put, so Exhibit 81 and 80, are we seeing sort of the side, and then 82, the front of that Jeep?
Yes.
When we get to 83, so let me pull it back a little more. And then a close-up, is that the license plate that was on the Jeep at Lori Vallo's house on July 11th with a Texas plate of LWD 0997?
Yes, it is.
And 85 as well, and it's not shown as well. Can I have my paralegal just take one of these up there?
Yes.
85. Looking at the photos without the glare of the Elmo, were you able to kind of see into the vehicle through the tint?
You can slightly see into that, yes.
Okay. And so, for instance, you could see shapes like the seats and things like that through the tint?
Correct.
Okay. I'll take that back. Thank you. I know it doesn't show as well when we're looking at it on the Elmo with the glare, but even in Exhibit 86, we can see, for instance, the seat back through that rear window, correct?
Yeah. Yes.
Also, on the front of that vehicle, of the Jeep, was there a sticker right in the corner?
There was, yes.
Okay. And again, when we look at 88, you're able to see through the Jeep into the back?
You can see through the Jeep towards the back of the garage there, yes.
Okay. And then that's the side of the, and let me pull out, of the Jeep in Exhibit 89.
Correct.
Now, when you were at the residence on July 11th, was Alexander Cox also present?
He was.
And did he have a vehicle at that residence when you were there on July 11th?
He did. He had a Ford pickup truck.
And was that a 2017 Ford F-150?
Yes.
And you previously had looked at those photos, Exhibits 90 through 92. The state will move to admit those.
They're admitted without waiving objection.
Was Alexander Cox's truck located in the driveway of the residence?
Yes, it was.
And is this what we see here in Exhibit 90?
It is.
Exhibit 91, is that sort of show the side of the vehicle?
The passenger side, yes.
And then a further away in Exhibit 92?
Yeah, from a front view of the passenger side.
Did you, in being at that residence on July 11th, note that the Ford F-150 had an Arizona license plate, personalized one of CPQUINT?
That is correct.
At that time, did you learn Alex Cox's cell phone number was 480-351-9120?
Yes, I did.
And did you learn that Lori Vallow had a cell phone number of 808-755-5452?
Correct.
And did you later learn that Lori Vallow had another cell phone number of 480-692-9562?
Yes.
Did you ever obtain a search warrant for an iCloud account that was associated to Lori Vallow for loriforstyle@icloud.com?
I did.
Can you tell us how you were able to determine that that was associated to Lori Vallow?
So first and foremost, the phone number that is associated with the subscriber was a phone number linked to the defendant. In examining the content of that iCloud, I was able to locate photographs, videos, text messages, and emails, all linking the defendant to that iCloud.
What is an iCloud account?
So basically, an iCloud account, to put it simply, is a cloud account for Apple users. So anybody who's using an Apple device has the ability to store or back up data from their device to the cloud.
So when you obtained those iCloud records, did you get an affidavit authenticating those from Apple?
I did.
Show defendant, exhibits 184, 85, and 86. Did you review and look through all of those iCloud records?
Yes, I did.
In those records, did you see messages, text messages, or sometimes referred to as SMS messages, between Alex Cox and Lori Vallow?
I did.
Did you ever see any mention of, between those text messages, Lori Vallow providing her brother Alex Cox with an email or Gmail account address?
Yes, I did.
And if I can have my paralegal approach with 184 and 185. Is 184 the affidavit that was provided as part of that search warrant that you obtained for the Lori for Style at iCloud?
Yes, it is.
And is 185 the text messages that you just spoke about relating to the conversation between Alex Cox and Lori Vallow, where the email address is requested?
Yes, and that context or that communication is through phone.
Through phone.
Yeah.
State will move to admit Exhibit 184 and 185.
Just object to relevance, Your Honor.
184, 185 are admitted.
So on 185 here, is this sort of a report that's created to pull out these specific messages between the phone for Lori Vallow and Alex Cox?
Yes, that's correct.
Do we see on here that the source is the Lori for Style at iCloud account?
Yes.
Is this time and date for when this occurred?
Yes, so the time you see there is 3/10/2019 at 7:50 p.m. And the UTC -7 means that it has been adjusted to Arizona time.
Okay. And so on this one, we see that this is from Alex Cox to Lori Vallow?
Correct.
And that's one of the phone numbers that you previously testified to that you learned belonged to Lori Vallow.
Yes.
And that was one of the phone numbers that was in this iCloud account as being hers.
Yes.
So in this, do we see Alex Cox then requesting from Lori Vallow, hey, Lo, what's your new address?
You do?
And then does he, a little bit later, I guess, clarify email address?
Yes.
And then in the third line, do we see now from Lori Vallow to Alex Cox on March 10th of 2019 at 8:07 p.m., where she gives a lollytimeforever@gmail.com?
Correct.
When you were reviewing that iCloud account, you told us that a lot of different data is saved there. When someone has a cell phone and is having text messages coming in and out, or you're sending them out, are those some of the things that can be saved in an iCloud account?
Yes, they can.
In this case, did you recall seeing text messages between or from Brandon Boudreaux to Lori Vallow in her iCloud account?
I did.
Did those records reflect whether or not those messages were read or not?
They do, yes.
If I can have my paralegal approach with 186. Do you recognize those as text messages from Brandon Boudreaux to Lori Vallow on June 25th of 2019?
I do.
And do they reflect that Lori Vallow read those?
It does show a red date on there, yes.
State will move to admit 186.
Foundation objection, Your Honor.
What foundation's lagging?
The fact that, I don't know,
Okay.
foundation objection.
It's admitted.
If I may publish. So when we are looking at this, is this another sort of report made where you can pull out specific messages that are part of the hundreds or thousands of text messages that might have been saved in that iCloud account?
Yes, it is.
So again, as we're looking at this, this is Lori Vallow's iCloud account, where we see it's to her, correct?
Correct.
And again, we see the Lori for Style at iCloud.
Yes.
And so the date of June 25th of 2019 at 6:46 p.m.
Correct.
And we see here a message. Can you tell us what that message was?
This is the content of the message. It was Brandon sending Lori a message also indicating that he had sent the same message to Charles as well about being accused of having or being involved in taking her temple recommend from her.
And does this show that Lori Vallow read that on June 25th at 8:19:57 p.m.?
It does.
Did you see additional messages from Brandon Boudreaux as the evening wore on to Lori Vallow?
Correct.
The next one being at 9:10 p.m.?
Yes.
And does that show that that was read by Lori Vallow at 10:08 p.m.?
Correct.
And then the final message sent by Brandon Boudreaux at 9:12 p.m.?
Correct.
And that was read at 10:08?
Yes.
Did you ever see any responses in the iCloud accounts from Lori Vallow back to Brandon Boudreaux with regards to this conversation?
I did not, no.
Did you ever learn that Alex Cox had moved to Rexburg, Idaho?
I did.
Did you ever learn that Lori Vallow had moved to Rexburg, Idaho?
Yes, I did.
Did you ever obtain a search warrant for an iCloud account, LollyTime at iCloud, that was associated to Lori Vallow?
I did.
How did you associate the LollyTime account to Lori Vallow?
Very similar to the Lori for Style. There was a phone number associated in the subscriber information that was linked to her, as well as looking at the content of the iCloud. There was emails, messages, videos, and pictures that would link that to her.
Was that LollyTime at iCloud account associated to one of Lori's cell phone numbers, the 480-692-9542 number?
Yes,
In that iCloud account, did you see photographs of Lori Vallow and her wedding with Chad Daybell in Hawaii?
I did.
Was that in November of 2019?
Yes, it was.
Like the other iCloud account, did you receive an affidavit authenticating those records?
I did.
As part of the iCloud records, we talked about text messages. Did the iCloud accounts also contain emails that were saved in the LollyTime at iCloud.com account?
There were emails, yes.
Did you note any emails between August 14th and October 1st that indicated that Lori Vallow had moved back to Rexburg, Idaho?
I did.
Did those text messages show her scheduling to see a unit at 565 Pioneer Road in Rexburg, Idaho?
They did.
Did they also show her emailing her payment to Blue Sky Properties Management Company for 565 Pioneer Road?
Yes, it did.
If I can have my paralegal approach with 187 and 188. This is the end. The last section for this witness, Your Honor.
Okay.
So 187 was that the affidavit that was sent in relation to the LollyTime at iCloud account.
Yes, it was.
And 188 is that a report of some of those emails that were saved in that LollyTime iCloud account relating to that time period and Rexburg, Idaho, and the Blue Sky properties.
Yes, it is.
State will move to admit 187 and 188 into evidence.
Any objection?
Your Honor, could we have a sidebar? I have a question on that.
Why don't we
Just
go
real
ahead and take
quick.
our recess for the jury. We'll recess for approximately 15 minutes and then we'll take a
Guys, I think we got caught up on with them. Let's see if they're actually still in the courtroom. I haven't checked any Twitter feeds since we've been sitting here. Okay, it appears that we are caught up to the courthouse. Let me shut my door because the grandkids being a little bit loud. Although our food just got here. Hold on. Oh, his dad's home. He just got in trouble and got told to pipe down. He's like, okay. Anyway, um, let's see if we can get some lowdown information real quick. They are 2 hours behind me, like I said earlier. So what is it? 3:30 for them. They usually run till about 5:30, 6 o'clock my time. So we may have another half hour of this today, anyway. Let's see who's got what to say. Okay. So 10 minutes ago, they were back in session. Joe was reporting that she is trying to question the accuracy of the data and reports that he received from Apple and AT&T. Okay. Mr. Brock, you must be fine. They're finally done with Brandon and got a new witness in. Then there was so they're now having discussions about phone records on the stand. So we'll get back to it. Let me pull up the feed. Law and Crime just took their feed down for the Karen Reed trial. It was showing the OnlyFans. The OnlyFans spinning. Oh, I think it still is. Okay. Yeah, they're still on break. So Dolphin was heading out for a little dinner. What did she say she was going to get? Where'd it go? Lebanese food. She's living large tonight, guys. I'm not so sure I could eat it, but I might be willing to try. I don't know. I might be willing to try it. We'll see. I might would. So Joy says she's revealing her checkered past. Butterfly, you got an invite for lunch? Nice. Go for it. Anytime you can get with the kids is well worth it, right? You'll take it. 'Cause 9 times out of 10, they're busy or whatever. I about got my grocery list finished. Things I could think of anyway, just sitting here. Yeah, they still had that feed up. I was like, what are they waiting on? But everybody else had theirs down. I think they finally figured out what they were doing. They may have finally figured it out. Oh, I hear noise.
Over here.
Correct.
Okay, back in business.
Now, did you also see emails from a Hilton, a hotel up in the Rexburg area in those iCloud records?
I did.
And so here do we see from August 15th, from the Hampton to the Lolly Time account, a confirmation.
Yes, you do.
And again, so we can see then on the 25th, we now are getting a receipt that was sent to her email from the Hampton Inn and Suites Rexburg.
Correct.
And again, that's sent to the Lollytime iCloud account.
Yes.
So it appeared to be, when she checked out, the receipt being mailed to her.
Correct.
And then again, that same day, sort of another email, again from the Hampton Inn and Suites in Rexburg, sort of thanking her for choosing them.
Sure.
Did you then see on, let me open this up so we can see the date better. August 26th of 2019, again from that Blue Sky Property Management to the Lollytime to sign your lease for Blue Sky Property Management.
Yes,
It
you
has
do.
a portal for her to go to.
Yes, you do.
And then again, more on the 26th of August, did you see more sort of the portal account is active for that Blue Sky Management?
Correct.
On October 26th, then at 11:44 a.m., again from that Blue Sky Property Management, do we see an email to the Lollytime iCloud thanking her for her payment?
It was August 26th.
I'm sorry, August 26th of 2019, thanking her for the payment.
Yes, you do.
And then did you also see another email from, again, the Blue Sky Property Management, this one from October 1st, again to the Lollytime, again thanking her for the payment?
Correct.
As part of your work as a police officer, were you also responsible for executing a search warrant to obtain phone records for a 515-402-0143?
Yes, I was.
When you were reviewing the Lollytime at iCloud.com account, did you see text messages between Lori Vallow and that phone number, 515-402-0143?
Yes, I did.
Were those text messages romantic in nature often?
They were.
Did you ever, as a police officer, come into possession of a recording of Chad Daybell using the phone number 515?
Yes, that recording, he actually provided that number as his number.
So, to your understanding, who was the person using the phone number 515-402-0143?
Chad Daybell.
And so then when you executed or you wrote a search warrant to obtain those phone records,
Yes, I did.
I can have my paralegal approach with Exhibit 181. Do you recognize those records that we see there from AT&T for the 515-402-0143?
Yes, that affidavit, yes.
So there's an affidavit from AT&T. Does it also contain some printout of the call detail records surrounding the time period of October 1st and 2nd?
Yes, it does.
And does it also contain a thumb drive of all of the records?
Yes, it does.
The state will move to admit 181.
Objection?
Just to the foundation again, if this was an actual phone extraction or this isn't an iCloud extraction, is that correct?
All right. You can cross him if you want to explore that. The exhibit's admitted.
Just to clarify, Detective, these records here in 181, these are phone records, cell site data, call detail records from AT&T relating to that phone number.
Yes, we'd refer to them as call data records. Without having the device in our hand, and just having a phone number, we would author a search warrant to that provider to ask them for what's called call detail records, which includes phone calls, text messages, cell tower data for a specific time.
Now, when we talk about text messages or call records, it doesn't have the recordings of the calls, right?
No, it does not.
And it doesn't have like the text messages, right?
No, it does not.
Just shows that when calls were made, the dates and times,
Correct.
when text messages may have been made, dates and times, as well as like what cell towers may have been used by the phone.
That is correct.
So that's what you're asking for when you issue a search warrant to obtain those cell phone records from AT&T for this number?
Yes.
Thank you. The state has no other questions for this witness.
All right, Cross.
Detective Duncan, you said when you write the search warrant for Apple, then they return it through a portal or an email. Is that correct?
There's two ways. I've seen it done multiple ways. All of them are secure. There's sometimes if the files are too big, they'll ask us to send a hard drive to them. They'll put them on the hard drive and then send it back. Other times they'll just send it via email or a link that we'd go to.
Okay. So in this case of the lollytime@icloud.com that you wrote this affidavit for, what way did you get it? Was it the portal or the email?
I believe that one was through an email, yes.
So in one particular email, or is it come in multiple emails, or how does that work?
I don't know for certain on this particular case. It's come in one. It's another followed up email with a password to get into it, but I'm not 100% certain how this one came over.
Well, it came to you, is that correct?
Yeah, but that was 5+ years ago, so I don't exactly know how it came over.
Okay, so you could look that up and see how many emails you got that were all related to lollytime@icloud.com, right?
I suppose I could reach out to Apple to ask them that question, yes. But I don't have a specific recollection of how many.
Correct, but you have your own email account. You could look that up, right?
I don't know if those emails I don't know if they've been erased after so many years, but I don't know if I'd have access to that right now.
Okay. So, just so I understand, the emails came that contained all of the information from Apple. Is that correct?
Correct.
And then you said the Cellbrite reader, will they send another report, which is a Cellbrite reader report. Is that correct?
No. So what happens is Apple sends it in a file. The best explanation is it's somewhat of a proprietary file that they send it to us in.
Mm-hmm.
And if I were to open that file, I would not be able to look at anything. So what has to happen is then we take that file and we send it to our computer crimes detectives, and they have access to the Cellbrite reader software. We ask them then to take that data that Apple gave us and put it into the Cellbrite reader, so then I can look at that and review that data.
And then how do you know that all the data ends up in that Cellbrite report?
I wouldn't be able to answer that question. That would be up to the detective that actually downloaded that from the file from Apple into the Cellbrite.
So a detective could just basically pull the information they want and put it on a report from Cellbrite. Is that correct?
I suppose that could happen, but I've never seen it.
Yeah, but you have no way to verify if that's all the information or not, is what you just explained to me. Is that correct?
True.
So you have no access to, even though it was sent to you on an email, you have no access to open that at all?
Correct. I mean, I can open it, but I wouldn't be able to understand anything of it. It would just be a whole bunch of random characters and numbers until you put it into the Cellbrite reader.
So Why do they send it to you if they could send it directly to the detectives that are going to extract it?
Because I'm the one that authored the search warrant, and so they send that data to the specific person that authored the search warrant.
And then you send it off to the person who's going to make the report.
Correct. I make a request to have it transferred into Cellbrite so I can read it.
And then who was the person that you sent that to that actually made the report for you to look at?
I don't know if I have that person's name on top of my head. I want to say it was Detective Hunsaker, but I'm not sure if he did that one or another one.
And that was for the lolly time, is that correct?
Correct.
Okay. And so you have no way of knowing what you're receiving in that report, if that's the full entire iCloud account or
I
not.
would have no reason to believe it isn't.
But you have no way to verify it. Is that correct?
Correct.
Okay. So from what you get, you can only take out from what, you can only review what you receive from this other detective. Is that correct?
Correct.
Okay. And then as far as not having a phone and having this AT&T record,
Correct.
you get the AT&T record, you put a search warrant for that. Is that
Yes.
correct? So you just give them the phone number and you find out whatever Verizon or AT&T or whatever.
So we have abilities, we have programs, we can put a number in and see which service provider holds that number.
Okay.
Then we can write the search warrant to that particular service provider. In this case, you would ask for a date range, and you'd ask for certain things such as cell tower locations, SMS data, which is text messaging, phone calls, incoming, outgoing. So there's a laundry list of things you can ask for, and those are called call detail records. That also will include subscriber records as to who owns the phone.
Okay. And what call detail records did you specifically request on your search warrant for this phone number 515-402-4143?
I'd have to refer to the search warrant to know that.
What were you looking for?
Specifically, any kind of calls during this time frame. Tried to identify who this particular person is that you were communicating with, and location data, and like I said, to identify this person.
He said that you were
And how can
communicating
you
with.
verify that all of the information that comes from AT&T is all the information from the phone?
I put trust in AT&T that that's what they would send me.
But if you don't have the phone, how do you verify that information is accurate?
Once again, I base my trust on AT&T that they're sending everything for that particular number that I'm requesting.
So if messages are deleted, text messages are deleted, you would have no way of knowing that if they didn't send you the deleted text messages?
That's a possibility, yes.
Okay. And if things were out of order, you wouldn't have any way of knowing text messages that were out of order as well, would you?
What do you mean by out of order?
Like, when things go up into the cloud and they're designated a number, a text message that you delete goes up into the cloud and they're designated a number. And when you download that iCloud account, those deleted messages get filled in these different numbers, and then you end up with a report that has text messages in the wrong place at the wrong time.
What the fuck?
They fill in when you download iCloud.
Yeah.
So I wondered if that was similar to the AT&T report that you're receiving. You would have no way of knowing if some of these were taken out of context.
That would be a question more for somebody who handles that type of information. I wouldn't have any information on
She
that.
acts like she knows.
So like a cell phone expert?
Correct.
Okay. And you don't qualify yourself as a cell phone expert?
No.
Just a person who asked for the search warrants?
Correct.
So in your search warrant that you asked for on this 515 number, you said you can get text messages, call detail records, that sort of thing. Is that correct?
Correct.
And then did you say that the text messages don't come in, just the time and dates of the text messages?
Each carrier is different.
Okay.
There are some carriers that will retain text messages for a certain amount of time.
Mhm.
If you do what's called a preservation for a particular number and preserve the information that's coming up with the anticipation of a search warrant at a later date, then that carrier will save those actually specific text messages. However, it's after the fact and they've already erased those, or they've outdone their period, of holding those, then they won't be there. Just the fact that a text message or an SMS or what's called an MMS, which is a video or a picture, that it was sent. But the actual content would not be there if it's outside of that period of retention.
Okay, and for AT&T, do you know what that time of retention is?
I don't.
Basically, okay. So you're relying basically on AT&T and whatever information they have currently available when you do the search warrant. Is that correct?
Correct.
Okay, and then that comes to you. So in this particular case, how did you receive that information from AT&T directly?
I believe that was via email as well.
Okay. And does that email come in its own report? It doesn't have to be put into Cellbrite, or it does?
That one will come in its own report. There's several. There's a spreadsheet. There's also a PDF file. There's a lot of different files that come with it and how to read it. But we can also take that data and put it into a Cellbrite reader to actually better review that particular data rather than just looking at it through a spreadsheet.
Okay. So did you send that spreadsheet to your same guy so that he could put it into a Cellbrite reader?
I don't remember if I did that or not, no.
Okay. Did you ever look at it on the Cellbrite reader, the report of this number 515-402-4143?
I did not on the Cellbrite reader, no.
So do you remember looking at it and the report that came to you in an email?
Do I remember looking at that report?
Right.
Yes.
That's what I'm saying. So you looked at it from the email that came to you directly?
Yes, and we have many ways that we can examine these data sets, if you would. We do use another program I refer to as Nighthawk, where I can just take those records that particular provider gave me and dump it into the system, and it'll read it in a timeline format for me, and then it's easier to read, if you would.
And how accurate do you think that organization is? It takes all the data and organizes it, or can it pick and choose?
I've never had any issues with it.
Yeah, but do you compare it to the original once you see the report?
I will. I'll go back and look at the original to make sure it exists, yes.
Okay. And how long of a period of time do you think that you spent personally reviewing the lollytime@icloud.com report from Cellbrite?
I would estimate hundreds of hours.
And how much time would you have spent reviewing this report from AT&T on this 515 number?
Not as much, because there wasn't that much information that came over with it.
And earlier you had testified that there were call detail records, so times and length of calls, is that correct?
For the AT&T?
Correct.
Yes.
But not just the calls, and then the text messages, there was also times, but not actual text messages?
Correct.
So you have no text messages from that entire phone extraction download?
From that particular extraction, I don't. However, you can link those messages and times of when, say that 0143 number texted your lolly time, and your lolly time will retain that content of the message. If that makes sense. So you have the content of the message between you and that number in the lolly time account, but if you reflect that date and time, that'll also show that date and time in the AT&T records.
So did you compare that lolly time account with this 515 number?
Yes.
Side by side, so you could see what the text messages were saying?
Yes.
Is that correct?
Yes.
Okay. And then did you make a report about this yourself?
On which one?
Do you make a report regularly on, say, you spent hundreds of hours reviewing this, so did you make a report specifically on lolly time account?
I have a very lengthy report that I wrote, yes, regarding my interpretation of that data, yes.
And did you make a report on this other assessment that you made on the 515 number?
Correct.
And it's probably not as lengthy?
Well, it's all incorporated into one report.
Oh, it's all in one report?
Yes.
Are there other numbers that are on that report or other iCloud accounts?
Yes, there are.
How many?
I believe there might be 2 additional iCloud accounts or 1 additional iCloud account.
And so your report would just incorporate all of those together. Is that
Correct.
correct? Okay. And about when did you make that report? Do you remember at all?
I do not.
Okay. That's all I have, Your Honor.
Redirect?
So detective, when you write a search warrant, you provide that to a judge, right?
Correct.
You have to provide a probable cause statement.
Yes.
And basically the court then orders someone like AT&T or Apple to provide the data you're requesting based upon that probable cause.
Correct.
And then depending on the size of the data being stored by the agency, you receive it in different ways.
Correct.
For something like AT&T, a phone record, does AT&T keep things like when calls are made and when calls are received in the normal course of their business?
Yes, they do.
Is that why you're able to write a search warrant to obtain those records?
Yes, it is.
So this is just something that all cell phone companies do?
Yes.
And do they all keep things like cell tower data? What cell towers you're using when you're making those phone calls?
Yes, they do.
And when people send or receive text messages or MMS messages?
Correct.
So you're basically, you know what these cell phone companies do, and then you write a search warrant for it?
Correct.
You were asked about Cellbrite. Is that sort of a software that is used to help organize data that is sent pursuant to these search warrants by someone, we'll say Apple?
Yes, it is.
Is Cellbrite a software used by police departments across the country,
It is.
as well as other law enforcement and other agencies?
Yes.
When you are talking about forensic detectives using Cellbrite for these iCloud or Apple Clouds or other digital media, is this something that forensic detectives do hundreds of times, thousands of times a year?
Yes, it is.
Do those forensic detectives know anything about the case?
I prefer they don't know anything about it, and that they just simply make the, basically it's like a translation of the data and not review anything and just take it from the format that it is given to me to the Cellbrite so I can review it.
Do they do any type of analysis of that data?
No, they do not.
So they would have no way to know what might be relevant or not relevant to allegedly, I guess, secret away some things and not provide that to you?
Correct.
So they just get this data, they use a very standard software and put it into a format that allows you more ease to read it?
Correct. I will also give them a copy of the search warrant. There's nothing about the report in there or the case being investigated. But what it'll have is things that the judge allowed pursuant to that search warrant. So say if the judge did not allow or it didn't include information about a calendar, then I shouldn't get that information. And so the detective that does that will then review that and carve out or exclude items that I should not have to be able to see.
So in this case, what we've talked about so far are 2 different iCloud accounts, the Lori for Style at iCloud account,
Yes,
and then the Lolly Time at iCloud account.
correct.
And you spent hundreds of hours, you said, on at least one of them?
Correct.
How much time did you spend on the other one?
Probably hundreds of hours.
So would it be fair to say there was a really lot of data that was sent to you by Apple for each of those search warrants?
Yes, there was.
Thousands and thousands of pages?
Correct.
And you went through all of that to locate information that was relevant?
Yes.
I have no other questions for this witness, Your Honor.
Are there any questions from any member of the jury? All right, I don't see any. You can step down, sir. Thank you, sir. Did you intend to admit 187?
Oh, yes. Sorry.
You didn't move to.
The state will move to admit 187, which is the affidavit, actually.
Any objection?
No objection.
187 submitted.
Thank you, Your Honor.
Yep, butterfly. Yeah, I was AT&T, Nick Balance, Brian Koberger. That's where my mind was going. Are they going to call another witness?
All right, sir, come on up here. You're going to come right in front of my clerk and she'll swear you in.
Can you please state and spell your first and last name?
Thomas Olzak, last name spelled O-L-S, as in Sam, Z as in zebra, E-K.
Raise your right hand, please. Do you solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? I do. Look around the court reporter elsewhere.
Would you please introduce yourself to the jury?
Hello, my name is Tom Olzak. I'm a retired state trooper with the Arizona Department of Public Safety.
How long did you work for the Department of Public Safety?
24 years.
What are you currently doing?
I currently work for the United States Secret Service at the Phoenix office as a network intrusion forensic analyst.
What did you do when you worked for DPS?
My DPS career started in 1999 when I graduated from the academy. I was assigned to the Highway Patrol Division in the Phoenix metro area. My day-to-day activities were traffic enforcement, collision investigation, calls for service, DUI detection. And at 2010, I became a detective, worked for a warrant squad for 3 years where we would work with the adult probation, several other detectives, the federal warrant service that we would go out and serve warrants on individuals that were arrest warrants and arrest them and bring them in. In 2013, I was transferred to the Criminal Investigations Division at DPS, and I was assigned to the Digital Forensic Unit located at the ACTIC, Arizona Counterterrorism Information Center in Phoenix. And there my responsibilities were to assist other federal, state, local, and tribal agencies with service of search warrants and to identify possible digital evidence on scene, and if it had to be processed. If not, it would be submitted to the crime lab and then to the digital forensic unit, and I would perform forensic exams on those.
So in November of 2019, what were you doing? Were you still with DPS?
Yes,
And were you still working in the area of digital forensics?
I was.
Can you tell us what an infotainment system is?
Infotainment is the central digital system combining of entertainment and information.
Where do we find one of those?
We'd find that in a vehicle, more of the newer vehicles. It pretty much came out in 1986. So it's pretty much the console that's in between the driver's seat and the passenger side seat, and it has a display on it, and it's a high fidelity display that you can get navigation, you can get applications. You can also connect your cell phone to that via Wi-Fi, Bluetooth, or USB cable.
Do all vehicles have infotainment systems?
Not all vehicles do.
Do all the infotainment systems contain the same level of data?
They do not.
When you are asked, let me ask this, are you asked at times to aid agencies to determine whether or not a vehicle might have a infotainment system with data that could be recovered?
I am.
In November of 2019, did the Gilbert Police Department reach out to you to talk to you about trying to remove an infotainment system from a 2018 Jeep Wrangler?
Yes, they did.
What kind of information do you ask for to be able to decide if you can obtain anything from that?
Well, we use a software made by a company called Burla. The software is called IVE, and with that software, it can detect, acquire, and analyze an infotainment system. Within that software, they have an application that you can scan either the VIN or enter the VIN into that application to see if that vehicle is supported through that Burla system.
So you need the VIN number for a vehicle, and does that tell you everything you need to know that you'll be able to obtain data from that
No,
vehicle?
you need also the trim package.
What is a trim package?
Trim package is features on the vehicle that would make it more of a newer vehicle or a better vehicle. So you might have a trim package of XL, Sport, Touring, EX. So you have cloth seats, and you're going to have a trim package, same model of vehicle, but now you have a trim package with just cloth seats and one with leather seats and more upgrades.
So the better the car, the better the infotainment system?
Most likely.
Before, when you were advised of this 2018 Jeep Wrangler, were you able to determine with the VIN number whether or not the infotainment system would be able to be, I guess, accessed?
I was.
And what did you believe in terms of whether you could obtain data from that infotainment system based upon the VIN?
The VIN number, according to IV software, showed that it was supported.
Okay. Did you then go with Detective Ryan Pillar to Rexburg, Idaho on November 19th to look at a 2018 Jeep Wrangler with license plate LWD0997?
Yes.
When you went there and you saw that vehicle, were you able to determine if you were going to be able to use Burla to access that?
Yes, once I was able to get inside the vehicle, I looked at the head stack, and that's actually what we would call the infotainment system, the screen and the buttons, the knobs around it. That would be the head stack. With Burla Ivy, they have different head stacks for different model of vehicles, for the same model of vehicle. So I needed to determine that view of that head stack, and I was unable to because I wasn't able to get into that vehicle before I traveled there.
All right, so sometimes before you travel there, you'll have someone send you a picture or be able to let you see what that looks like to see if you will be able to use Burla on it.
Yes.
In this case, you weren't able to have anyone get inside it until you went up there on the November 18th of 2019.
Correct.
So when you go there and you see that, did you realize there might be a problem?
Yes.
What did you?
I saw that head stack was not one of the ones that that was shown on the website,
Okay.
on the actual software.
Did you end up actually calling Burla to find out if you might still be able to access this?
I did.
And what did you determine?
Burla had told me that their customer support told me that that was a lower end model, that it wouldn't be supported, but I could possibly do a chip off to obtain some data.
And so when we're talking data, we're still looking at potentially call logs or connections to that infotainment system or potentially even GPS data.
Correct.
So did you decide to take that infotainment system out of the vehicle?
I did.
How do you do that?
Well, with the IV software, it's very intuitive. It gives you step by step on each vehicle how to take it apart. And I'm careful taking it apart because I might have to put it back together. If it's a victim's vehicle or a rental vehicle, that has to go back working order. So I take preventive steps. I take pictures on each step, and I remove that infotainment system, the unit behind that I need to take with me.
Is that basically just like a hard drive?
It's actually a metal or a plastic box that's behind the screen that contains the printed circuit PC boards that would have all the data on there.
Okay, so you took that with you,
Yes,
brought it back here to Arizona,
correct.
and did you attempt to access it through that chip-off method?
I did.
Were you able to access any user data from that Jeep?
I was not.
On January 2nd of 2020, were you asked to meet with, again, another detective, this time McDermott, from Gilbert Police Department to remove an infotainment system from a Ford F-150 truck with Arizona plates CPQUINT?
I was.
Did you follow sort of the same process we've heard about?
I did.
And was that infotainment system supported by, for the Ford F-150 by Burla?
It was.
Were you able to obtain GPS data, connection data, and call logs from the Ford F-150 with that CPQUINT plate?
I was.
Different infotainment systems, do they have smaller or larger memory chips?
They do.
And in this vehicle, was there a smaller memory chip?
Comparison, it was only an 8 gig memory chip.
And some of that memory is taken up from just data from Ford for the infotainment system?
Correct.
In terms of the data on this infotainment system, for the Ford F-150, did you locate any data relating back to October 2nd of 2019?
I did not.
Did you locate any data relating to any time in October of 2019?
I did not.
So you're looking at this vehicle in January, or pulled the infotainment system on January 2nd of 2020. Were you able to determine if any phones had connected to that Ford F-150?
I was.
Did you see data that a phone number 480-351-9120 had connected to the Ford's infotainment system?
I did.
Did you see data that a phone number 808-755-5452 had connected to the Ford's infotainment system?
I did.
Were there call logs in that Ford F-150 from November 7th through December 20th of 2019?
There was.
Did that infotainment system show calls made to 480-321-9876?
It did.
Did they show calls made to 208-690-9374?
It did.
And did they show calls made to 480-489-4652?
It did.
Did the Ford F-150 contain GPS coordinates?
It did.
Were those all related to the time period of December 3rd through the 31st of 2019?
I believe so.
Was there any GPS coordinates relating back to October of 2019?
There was not.
Thank you. I have no other questions for this witness.
Cross?
No questions, Your Honor.
Any jury questions? Not seeing any. Sir, you can step down.
Thank you.
State will call Detective Ryan Pillar.
Please state and spell your first and last name.
Ryan Pillar, R-Y-A-N, is Paul, I-L-L-A.
Thank you. Is your right hand, please? You do solemnly swear the testimony you're about to give will be the truth. So help you God.
Detective, would you please introduce yourself to the jury?
Yes, my name is Ryan Pillar, P-I-L-L-A-R.
Where do you work?
I work with the Gilbert Police Department and have been so employed since February of 2007, so a little over 18 years.
Back in 2019, where were you working? What area?
In 2019, I was assigned to our Criminal Investigations Division, specifically to our Violent Crimes Unit.
Can you tell us sort of over the years from when you started through current, where you have worked and when?
Yes, I started on police patrol, maintaining typical police patrol officer duties. In 2016, I went to our Special Victims Unit within our Criminal Investigations Division, which is the unit that is responsible for investigating crimes against children and sex-related crimes. In 2019 is then when I began my time with the Violent Crimes Unit, which is responsible for investigating crimes of violence, death investigations, things of that nature.
And where are you currently working?
In 2021, I moved back to patrol briefly, voluntarily, because I wanted to try something different. I'm currently assigned as a school resource officer still in Gilbert.
I want to talk and ask you a few questions about Gilbert Police Department back in 2019. At that time, did the Gilbert Police Department have a full staff of crime scene specialists to help process crime scenes?
We did not.
Did you have basically two people?
We had two individuals that were crime scene techs.
And because of that, as both patrol officers and detectives, were you trained on how to process crime scenes?
Yes.
Can you tell us a little bit about your training in that area?
Both my time on patrol and especially in my time with the Criminal Investigations Division, we received multiple hours of training when gathering evidence, everything from fingerprints to physical DNA. Although we were not crime scene technicians or specialists, we were trained on the basics of processing a crime scene. Everything from basically from photos to collecting physical evidence.
Okay. In 2019 and 2020, did the Gilbert Police Department contract with other police agencies to do forensic lab work?
Yes.
So for instance, we just heard from DPS. Is that someone that the Gilbert Police Department worked with?
Yes, we work with Department of Public Safety, DPS, Mesa Police Forensics, Phoenix Police Forensics.
I want to talk to you about Wednesday, October 2nd of 2019. Were you on duty that day?
I was.
And were you called out to a home at 3875 East Phelps Road in Gilbert, Maricopa County, Arizona?
I was.
Do you recall what you were doing, like where you were prior to responding to that scene?
Yes, I do. I was actually in a meeting with our Violent Crimes Unit. We have weekly squad meetings. We were discussing cases that we were working when a sergeant came in and said, hey, we have a active shooting investigation and we need you to respond, which at that time myself and assisting detectives responded out to the 3875 East Phelps address.
Do you recall approximately when you got out there?
Yes, the time that we arrived on scene was approximately 10:30 hours, 10:30 in the morning. The originating call was approximately 09:13 hours, so a little over an hour by the time we got on scene.
Can you describe the scene when you arrived?
Yes, when we arrived, I positioned my vehicle. So we have unmarked assigned police vehicles. I parked my car east of the target address of the 3875 Phelps address. The street was blocked off with patrol vehicles both on the east end of Phelps and west end of Phelps to prevent traffic from traveling down that roadway. Additionally, there was crime scene tape set up, yellow police tape, to both prevent any further persons entering or exiting the crime scene that was established by patrol officers, and a couple cones within the roadway that I later learned about.
So who were the other detectives that came or arrived on scene that morning?
The initial responding team was myself, Detective McDermott, Detective Biggs, and Detective Ferrer. We were the first 4 detectives on scene. Others later joined.
Okay. When you got on scene, do you recall being given any type of briefing or overview about what patrol had learned or established?
Yes, so typical response for detectives arriving on scene. The patrol officer, patrol sergeant will brief all the detectives once we arrive there. I do not recall specifically who briefed us that day, but we were provided with the names of the individuals involved, the address, the approximate time for the call for service, and a basic rundown from the initial interviews obtained from officers at that scene.
Did you at some point go to the driveway of 3875 East Phelps to look at the vehicle itself?
Yes,
When you were looking at that vehicle, did you see the damage to it?
yes.
What do you recall seeing?
Well, upon walking up to the 3875 address, there was a black colored Tesla in the driveway. The front driver's side door was open, as well as the back driver's side door. There was glass partially on the driveway, as well as partially in the landscaping. While getting the scene walkthrough, which a walkthrough is when a patrol officer or the sergeant, again, I do not recall specifically who, but they will typically walk us through what they have at that point and explain what they've gathered so far. So this photograph that's on the screen now is accurate to what I initially saw, to include a up-close visual of the door. It's not the door frame, it's the vehicle frame that went above the driver's side window that was previously affixed to that vehicle.
Did you, let me ask you this. Have you seen vehicles that have been shot before?
Yes, yes I have.
You're familiar with what, you have seen bullet holes in cars before?
Yes.
I'm going to put up, that was Exhibit 25. We were talking about this as Exhibit 28. Did you see this damage to the Tesla?
I did see that damage, yes.
When you saw that, what did you believe that to be?
I believe that to be a bullet hole.
Was that consistent with other bullet holes you had previously seen in other vehicles?
Yes.
What about this made you believe it was a bullet hole?
Both the angle, the fact that it went through metal, there's up close, you can actually see some scraping that's along that metal edge. The cleanliness, if you will, of that damage is indicative of a fast-moving projectile.
The glass that was off to the side here that we see back in Exhibit 25, did you notice that when you came and walked around?
I did.
And, a different photo, one sec. Put up Exhibit 24. Did you note glass still sort of along the edge of that door even?
There was door, yes, along that edge, and there was some within the cabin, which is not seen in this photograph, but yes.
So you observed glass pieces inside the car itself and sort of in that whole general area?
Multiple small shards from the glass being shattered, yes.
Now you talked about some cones in the street. Let me put up Exhibit 14. Were these up when you arrived?
Yes, those cones were placed prior to my arrival and were in that position when on scene.
What did you understand those to be from?
I understood those to actually be locations where glass was located in the roadway, as well as to give some idea of where Mr. Boudreau, who was later identified as our victim, described his vehicle approaching his driveway.
Okay. So approximately where he was when his car was shot?
Yes.
When you arrive on scene with different detectives, is everyone sort of given a duty,
Yes.
a role to play, so to speak? What was your role?
Once on scene, it was determined that I would be the lead detective, the case detective. The responsibilities of that include interviewing the victims and essentially overseeing the entire investigation from that moment forward. From there, it was decided to have my partner there, Detective McDermott, assist with the primary scene detective, essentially in charge of operating the crime scene management, since we did not have the crime scene technicians available at that time. And then Detective Ferrer and Detective Biggs were then assigned to assist him with both investigating the scene, collecting physical evidence, and they were also provided tasks later on.
So although you were not responsible for processing the scene, did you, for instance, look in this area to note any glass pieces near
Yes.
the cones?
Yes.
And did you observe that?
Yes, I observed glass in that roadway.
Had you, as the case agent, been advised that the first officer on scene, Officer Robb, had done a brief interview of Brandon Boudreaux?
Yes.
Is that normal?
Yes.
As a case agent, did you then want to do a more in-depth interview with Mr. Boudreaux?
Yes, this is typical for any investigation. Of course, uniformed police officers will arrive. When they gather enough information to determine this is going to require some further investigation, they'll contact the Criminal Investigations Division. So Officer Robb did have the initial interview, albeit brief, and then she provided that information.
Now, we hear about body-worn camera. As a detective, did you have a body-worn camera?
I did not.
So when you decided to interview Brandon Boudreaux, did you record that?
I did record that.
How did you record that?
At that time, the body-worn cameras were not as used as much as they are now. So I did not have the body-worn camera. However, it was common practice both in Special Victims Unit and specifically in Violent Crimes Unit on October 2nd of 2019 on this case to use a digital recorder, which is a simple digital recorder that has press play, record, stop. That's how I captured the audio.
When you arrived, do you recall where Brandon Boudreaux was?
I do.
Where was he?
So when I arrived, I was, again, we briefly walked through the scene. There were 3 males sitting on the north side of the street directly across from the 3875 Phelps address. On this particular day, it was pretty warm outside. October 2nd in Arizona, yes, it was warm. They were seated, in this photograph here, this is a good representation across the street. There were 3 males sitting there. I did not know who was who yet, but once I got the basic idea of the layout of our crime scene, I walked over and introduced myself.
So we have Exhibit 9 here. They show where you had contact with Brandon Boudreaux.
Yes.
So when you went over there, did you know at that time whether or not the other 2 individuals had been present during the shooting?
I did not.
Okay. Did you go over there and ask to find out who Brandon was, which one was, and if the other 2 knew anything about the case?
Yes, I tend to be a little more social, so I introduced myself, tried to keep it lighthearted despite it being a serious situation. I confirmed, I believe the friends were Chris and Mark, I don't know their last names. And then Brandon identified himself as being the resident at that house involved in this shooting. Once that was gathered, I asked the friends if they were there prior to or during the shooting, and they said no. They were simply there as support. After the incident, since Brandon contacted them, once that was gathered, those 2 friends remained in the shade while I walked with Brandon after he agreed with me to speak with me privately. And I chose to use my vehicle since it has air conditioning and it was away in a private space.
So if we're looking at Exhibit 9 here, where were you parked in relation on this photograph?
So my vehicle would, where that squad car is at the end of the street, it would actually be even a little bit further to the east of that, so outside of that vehicle, and then it would be to the right. So it'd be kind of around the corner where your pen's at right there. It'd be in that area.
So when you took Brandon to your vehicle, that's where you interviewed him,
Correct.
and that was recorded.
That initial interview with us was recorded, yes.
When you are conducting an interview like this, how do you go about that?
Well, again, coming from SVU, or Special Victims Unit previously, I try to build a rapport phase, which is simply trying to keep it as lighthearted as possible and just discuss basic topics. I remember Brandon was mentioning that he was there with friends and they had some food that they were eating. I don't remember specifically what. But after some pleasantries, introduced myself. Hello, my name's Ryan Pillar. I'm a detective with the Gilbert Police Department once again. And then I obtained his specific identification information, have him spell his first name, last name, date of birth, phone number, any other phone numbers, email addresses, to get a foundation for who I'm speaking with and so I can communicate with them moving forward.
During this interview with Brandon Boudreaux, did you talk to him about who he thought might want to kill him?
Yes.
And did Brandon provide you with the names of some people he thought might want to kill him?
He did.
And what names did he provide to you?
He provided the names of Lori Vallow and the name of Alex Cox.
Did he advise you that there had been an incident that occurred in Chandler in July of 2019, and that was some of the reason for him identifying them?
Yes.
During your interview with Brandon, let me ask you this. Prior to talking with Brandon, when you were briefed, did you receive information regarding the vehicle that had been identified by Brandon as being used that was shot at him?
Yes, I was provided a description of the vehicle that shot at him, or where the shot came from.
When you spoke with Brandon in your car, was he consistent with giving you the same information?
Yes,
Did he describe the Jeep for you?
he did.
Did he provide you the information about what state the license plate was from?
Yes,
Did he talk to you about whether or not it had a rear tire on it?
he did.
Did he talk to you about where it was parked?
He did.
Did he talk to you about what he saw happen right before the shooting?
Yes.
Was anything that he had provided to you different than what you had learned in the briefing as to that area?
No.
We talked about that you had seen the vehicle, so you knew it was a Tesla. Did you ever talk to Brandon about whether or not his Tesla had cameras that might record what happened?
Yes, Teslas were fairly new at the time, but it was, to my knowledge, that they had cameras throughout their body.
And was this a 2016 Tesla Model X?
Yes, it was.
Did you try to recover video from Brandon's Tesla?
Yes.
What were you able to?
Unfortunately, no. We were unable to obtain any of the video data in this vehicle, particularly because it did not have a storage device installed within it, which was also later confirmed by contacting Tesla directly. And there was no video saved from this event.
So you both looked yourself and then contacted Tesla to make sure that there was no other way that video would have been saved?
Correct.
Based upon what Brandon told you had occurred, did you expect to find a casing at the scene?
No, a shell casing, no.
Why not?
The way Brandon described the shooting was the back window of a Jeep opening up and then a weapon shooting at him, a firearm shooting at him. In my experience in law enforcement and utilizing firearms for many years, if it was a bolt action rifle, you would have to manipulate it and then the casing would come out within the vehicle. Or if it was a semi-automatic, the casing would still come out and be within that vehicle where it was fired from, based on the description that Mr. Boudreau provided to me.
And did Mr. Boudreau or Brandon provide or believe that this was a rifle that was barrel that was coming out the back window?
Yes, he believed it was a rifle. He as I've heard before, but specifically from him, he described it as a large barrel that came out of that window and fired at him.
And did he believe there was some sort of silencer or something on the end of that barrel?
He believed there may be a suppressor of some kind, but again, it's often that people, especially if a weapon's pointed at them, believe that it's very large. So I believed it was a rifle.
So he didn't see a hand or anything else or describe that to you, or you would have thought a handgun was put out the window and the casing might have ejected.
Correct.
He only saw the barrel of the rifle.
Correct.
Were you present when the fragments were collected or located in the Tesla?
I was not present when the fragments were located and extracted from the vehicle. I was present after my interview with Brandon, and I returned to where it was in the process of, and they had collected the fragments.
Did you see where they had been removed from?
Yes, there was an extensive period of time focused on that bullet hole and finding as much as we could.
Did you note that I'm going to put up exhibit 28 to help us, that sort of the molding had been damaged as a result of this projectile?
Yes.
And for this vehicle, we had seen in exhibit 25 that there's no sort of metal frame around the top of the glass window, correct?
Correct.
Was it your understanding then that the window kind of went up into this molding in the frame of the vehicle?
Yes.
In this case, did police try to look if there was any fragments anywhere else sort of in the frame of that vehicle around there?
Yes, it was explained to me, and I looked as well into the bullet hole itself, and a lot of that rubber casing that you see surrounding that was pulled away and removed and inspected further to find any further fragments of that projectile.
Now, in this case, did you also see originally the glass sort of on the driveway there where it landed, and then later was the glass sort of manipulated to be able to look at it better?
Yes.
I'm going to put up exhibit 46, for instance. So was the glass looked at, and even 47, and kind of spread out to be able to look at whether or not there was damage to it other than that the whole thing was shattered?
Yes, and where the A sticker, that was placed when I was in my interview, but that's where, yes, that's where they believed that the impact was, had connected with the glass that was within the frame of the Tesla.
And so there seemed to be a little divot there that seemed to match about the location that that window would have gone up there?
Yes.
Now, because only fragments of that projectile were recovered in the frame of this vehicle, did police search elsewhere to see if you could recover any other fragments?
Yes.
And can you tell us what was done to try to see if you could find those?
Well, aside from spending a couple hours on the Tesla itself looking for any fragment, which ultimately recovered 4 small fragments, we searched amongst the glass there, and then we started within the roadway where we could best determine the gunshot collided with Mr. Boudreau's Tesla. We started there. Well, let me back up. We had additional detectives respond to our scene. By early afternoon, there was 14 detectives total, and they were assigned with canvassing the neighborhood and the route that Mr. Boudreau provided as far as where he traveled after the shooting, as where the Jeep traveled after the shooting. We assigned detectives to canvass the entire neighborhood for any type of surveillance and contact any potential audible or visual witnesses. After that task was completed was when we did something called a line search. So it was not all 14 detectives at this point. I believe there was about 10 or 11 of us, where we stand, as it sounds, in a line, essentially shoulder to shoulder, and walk that roadway, the entire pathway where Mr. Boudreau described where he drove, from the point of impact of the shooting, westbound on Phelps towards Cole. We then went northbound on Cole, passing Waite, which we'll get back there, but passing to the point where he said he stopped his vehicle near a park or a pool, a community pool area. We really searched that part because that's where he said he turned his vehicle around. So we searched for any additional glass or fragments. We then proceeded to walk back down Cole, eastbound on Waite, continued our line search, and then ultimately southbound on Fisher, and then back westbound on Phelps, where we got back to those orange cones. So we did a line search, and despite our best efforts to include using a metal detector, no other fragments were located.
Seeing how small those fragments are, you're just trying to find something that might flash or stand out as you're looking on the asphalt.
Mm-hmm.
Were you surprised you didn't find anything?
Surprised, no. Disappointed, yes. But
It was a very long distance. You were looking for very small, tiny pieces of metal.
yes, and it was warmer as the day went on.
Now, you said that officers also contacted residents around that neighborhood to look for any surveillance cameras that might have caught anything.
Correct.
On Phelps, did anyone that was immediately around this area have any ring cameras or any other footage that would have showed this? That showed the street area where the Jeep was?
There was no video surveillance of the street area on Phelps.
During this investigation, did you ask Brandon for his phone?
Yes.
Why did you want his phone?
At this juncture, very early in the investigation, we don't know the complete motive. We don't know the involved parties. He's telling me a story, sure, that he provided some names, but to really know any possible motives or leads, people's smartphones have a lot of data, and he voluntarily turned that over. He completed a consent form, which is what we do when we want to have somebody willingly consent to us searching their device, because it is quite intrusive. And he turned over his device, which was ultimately turned over to our digital forensics unit, which was explained a little bit ago, but specialized detectives who specialize in downloading these types of electronic devices and going through the data.
So you might be looking for text messages where he's threatening someone or someone's threatening him or whatever else.
Correct.
Did you find anything like that?
No.
Did you also take Brandon's Tesla to Gilbert property?
Yes, once we completed our line search, our canvas, it was decided to take the Tesla to the Gilbert Police Department's property and evidence building to go indoors, just take another look at it to see if we can find anything further.
So you're getting there at 10:30 in the morning. How long is this all going on when you finish with this line search and now you're deciding to try to take the Tesla back to look at it?
I don't have the exact time, but I would estimate we probably left the 3875 East Phelps address at approximately 4:30, maybe 5 in the afternoon, early evening.
So did you and others, again, spend more time trying to look through the Tesla to see if there was any other evidence, any other fragments or anything else that might be there?
We did.
Was anything else found?
Nothing else was found.
Did you return the car to Brandon?
Yes, the vehicle was not impounded. We turned it back over to him. That was his only vehicle. So once we made our final search of everything we could regarding that bullet hole and the surrounding areas within it, it was turned back over to Mr. Boudreau.
During your interview with Brandon Boudreau, he advised you of that incident that occurred in Chandler on July of 2019 involving Lori Vallow and Alex Cox. Did you reach out to the Chandler Police Department?
Yes.
And did you learn from the Chandler Police Department that Lori Vallow had a 2018 Jeep Wrangler with Texas plates LWD 0997 in her garage on that July 11th of 2019?
Yes.
Did you learn photographs had been taken?
Yes,
Were you provided with copies of those photographs?
I was.
When you learned that license plate, were you also able to run that and get information about the Jeep?
Yes, we did an MVD records check, which is a simple license plate check, which will provide the registered owner and their information and vehicle information.
So by October 9th, you had the license plate number and VIN for that Jeep.
Yes.
Now, as a case agent, are you the person who is responsible for interacting with the listed victim in a case?
Yes.
And was it your common practice to give out your work number to any victim so they could reach you?
Yes, both this case and any case I worked, I would regularly give out my direct work cell phone number, my name. I encourage them to text me and call me as needed, with the caveat that I'm not always available, but if you leave me a message, I will respond.
So as a detective, you actually are provided a work cell phone for that purpose?
Yes, ma'am.
And all of their detectives are given the same sort of thing, a work cell phone, so that victims and witnesses can reach them?
Yes.
On October 14th of 2019, did you learn from Brandon that Melanie was moving to Idaho?
Yes.
Were you able to confirm that with her?
Yes.
Did you learn during this investigation that Lori Vallow had moved to Rexburg, Idaho?
Yes.
Did you learn in this investigation that Alex Cox had moved to Idaho?
Yes.
So in October then, Melanie joined them in Idaho?
Yes.
On October 16th, did you learn that a license plate reader had recorded Lori Vallow's Jeep with that Texas plate LWD 0997 on the I-40 on October 1st of 2019?
Yes.
Was that reader located in Holbrook, Arizona?
Yes.
How long before the shooting of Brandon was Lori Vallow's Jeep seen on that I-40 heading towards Phoenix?
That Jeep was seen on the I-40 heading towards Phoenix approximately 26 hours and 30 minutes prior to the shooting at Brandon Boudreau. In particular, the LPR, the license plate reader, has cameras. This was a DPS camera, if I recall correctly. Took a picture of the Jeep Wrangler with the Texas license plate LWD 0997. And there was no wheel affixed to the back of the Jeep Wrangler, which Jeep Wranglers are typically have that wheel affixed to the back of them. In this image, 26 hours prior to the shooting, the wheel was not affixed to the back of that Jeep.
When you were working this case, you had talked about other detectives. Did you continue to work with some of them to help you investigate this case?
Yes.
Were you working with Detective McDermott during this case?
Yes.
And as this investigation continued on October 31st of 2019, did you learn of LPR hits of that Jeep in Idaho?
Yes.
And did you then work with Detective McDermott to try to seek help from law enforcement in Idaho to seize Lori Vallow's 2018 Jeep Wrangler with that Texas plate LWD 0997?
Yes.
On November 4th of 2019, did you learn that a detective at Hermosillo with the Rexburg Police Department had located and impounded that Jeep?
Yes.
Once that Jeep was impounded, what did you decide to do?
Well, I learned on November 4th, Detective Hermosillo with the Rexburg Police Department and fellow detectives located the Jeep. They impounded it in their private police lot. And once it was known to be secure in the Jeep that we were looking for, I drafted a search warrant and worked with Detective Hermosillo to arrange processing of that Jeep. Because that Jeep was associated with the crime in Gilbert, Arizona, arrangements were made to ultimately travel up there, up to Rexburg, Idaho, rather, and process that Jeep for physical evidence.
We heard from Detective Olzak. Did he go with you, for instance, up there?
Detective Olzak was accompanying me, yes, up to Rexburg, Idaho.
And did a crime scene specialist, Tammy Lashik, also go with you up there?
Yes.
When you were going up there, were you processing the vehicle to obtain gunshot residue?
Yes.
Were you processing the vehicle to obtain DNA?
Yes.
Were you processing the vehicle to obtain fingerprints?
Yes.
We heard, obviously, to remove the infotainment system. Were you also looking for any casings, projectiles, anything like that that might relate to your crime?
Any physical evidence within that vehicle, yes.
What is gunshot residue?
Gunshot residue, short is GSR, is small particulates that are exerted from a firearm when it is discharged. So when you shoot a gun, these small particulates go out. They can go up to 5 feet, is what I've been told. I am not a GSR expert. However, they do go out in a, best way I can describe it, a smoke-like explosion fashion. And they can both go on clothing, hands, and surrounding areas, depending upon how small the physical environment is.
So in this case, well, let me ask you first, have you collected GSR yourself before?
I have collected GSR before.
Can you describe for us what you use to collect GSR?
Both GSR and any physical evidence, you wear gloves. You will be changing, usually have one primary pair of gloves on, and then you will have a secondary pair of gloves you put on. That secondary pair of gloves is removed every time you go to process another location or collect another evidence item. In other words, you're using a lot of protective gloves while processing a scene. With GSR in particular, you're going to have a controlled vial and a sample vial. The controlled vial is not opened. It is next to the sample vial. That is just to give the lab a controlled example of the same type of material that has not been utilized. The sample vial is sealed. Once it is open, it's cylindrical. It's about the size of a shotgun shell is the best way I can describe it. Once it is unsealed, it has a circular adhesive. That adhesive is then pressed against the area in which you are collecting where you believe gunshot residue might exist. Once that's collected, you reseal it with that adhesive into the tube, and then it is sealed with an integrity seal to prevent any tampering before any type of lab analysis.
And for the vehicle, this Jeep, were you then using that process inside the rear area of the Jeep?
That process was being used at the interior of that Jeep, yes.
And was that because you had been advised that there was someone inside the vehicle when the rifle was fired?
Correct.
We said that DNA was collected also in this vehicle. Have you ever collected DNA from a scene?
I have.
Can you tell us how that is done?
Similar, same process with the gloves, removing them from each location and putting a new pair on. There are essentially long Q-tips, wooden, and then they have the Q-tip at the end. There's 2 Q-tips in each paper vessel, keep them, the integrity of them. And then there's going to be a sterilized water that you also open and crack open, so you have sterile water. You open the Q-tips, as I'll refer to them as. You put water on one of the ends and leave the other one dry. You will first use the wet Q-tip to swab the area in which you are collecting DNA. You will then use the dry Q-tip to swab that same location. You place both of those Q-tips into a cardboard box. The reason why it's cardboard is so it can breathe, so that doesn't get moldy and affect the integrity of the sample you collected. That box, again, is sealed with integrity seals and signed to prevent any tampering prior to any type of lab analysis.
And then lastly, just before we break, you also talked about collecting fingerprints. Have you collected fingerprints before?
I have.
And can you tell us how that is done on a vehicle?
Much simpler. There's graphite powder. You dust it amongst the surface, a flat surface where you believe the fingerprints may exist. That graphite powder will show the existence of fingerprints. You will then use specialized tape, but honestly, it's just clear tape. You press it on there, pick it up, and you place it on a white piece of paper, more or less. It's kind of a cardboard type paper, like a thick paper. And that's how you collect your fingerprints.
All right, let's recess for the weekend. Members of the jury, Monday is going to be a 10:30 start. 10:30 start. Please be in the jury room around 10:20, ready to go. Please remember the admonition. Have a good weekend.
All rise for the jury.
All right, please be seated. Is there anything else?
Okay, what a day. What a day. I appreciate those of you who stuck it out here with us, trying to get Lori's day 2 in here. That was a little much toward the end there. I'm going to tell you, it was a little bit long for me. I was ready for that to be over with. Ready for it to be done. Guys, I'm going to wrap it up. I need to go chill out for a little bit. Joe's going live in about an hour, I think, if you guys want to go over there and join in on that. I think Miss Shorty's still live right now. And anyway, there's a lot of action on the YouTube streets tonight. Y'all find somewhere safe to travel and be safe while you're doing it. And you guys have a great night. Again, thanks for joining me, everybody, and joining the conversation, hitting the like button, all the good things. And yeah, it's been a long one, Butterfly. Like, woo. Like, I kept looking at the clock going, they got to hurry up a little bit now. I'm getting a little tired of being here. But it's all good. It's whatever. But I will go, and I will see, hopefully I'll see all you guys tomorrow night over in Miss Shorty's chat while we talk a little Karen Reed and Crash Daddy efforts. Haha. Are we going for a record, Butterfly? I couldn't tell you. That might be my longest stream so far. I'm not trying to go for a record nor break one. All right, guys, I'm going to go chill out. You all have a great evening.
Thank you all for watching this here video.